Give all the memos. GMCPC. It will come. Give. If tomorrow is a working day, we'll have it. Give it, sir. End of the list, wait. Wait, madam. End of the list is wait. Otherwise, give all the memos. Wait, sir. Any mentioning, wait. ಕೊಡಿ ಕೊಡಿ ಯಾವ GMCPC ನ ಬರುತ್ತೆ ಕೊಡಿ. ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ವಾ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ? ಇವತ್ತಿಲ್ಲ, ಮಂಡೇ. ಟುಮಾರೋ ಮೇ ನಾಟ್ ಬಿ ಎ ವರ್ಕಿಂಗ್ ಡೇ ಎನಿವೇ. ಇದ್ರೆ ಬರುತ್ತೆ, ಮಂಡೇ ಬರುತ್ತೆ. ಯಾವ 482 ಅಲ್ಲ? ಆಯ್ತು ಕೊಡಿ. 230 ತಗೋ. ಸೆಟಲ್ಮೆಂಟ್ 230 ತಗೋ. ಕೊಡಿ ಸರ್. ಗಿವ್ ದ ಮೆಮೋ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರು ಮಂಡೇನೇ, ಮಂಡೇ ಆರ್ ವೆಡ್ನೆಸ್ಡೇ ಇಟ್ ವಿಲ್ ಕಮ್. ಗಿವ್ ಇಟ್. Tomorrow. What is the order and the challenge? Huh? For what? Commercial OS. Is it for the first time coming or notice ಆಗಿದೆಯಾ? ಪೆಂಡಿಂಗ್ ಆದಾಗಲ್ಲ. ನಾಳೆ ಇಲ್ಲ, ಮಂಡೇ ಕೊಡಿ. Take time there, sir. Yes, give it. If it is pending, I will not take it at 2:30. Period. You must also understand the other side should come or not. Kodi. Tomorrow if it is working, it will come. Give it. ಅದು ತಗೊಳ್ಳಿ, ನಾಳೆ ತಗೊಳ್ಳಿ. Hey, what happened? It did not come before the other court. ಆಯ್ತಾ, ತಗೊಳ್ಳಿ ಮಾಡಿ. 2:30 ತಗೊಳ್ಳಿ. Why? ಹಾ, FDP proceedings. ಅಲ್ಲೇ ಮತ್ತೆ ಆಗದು ಇನ್ನೇನು. ನೀವು ಯಾರು? ಹೂ ಆರ್ ಯು? ಕರೆಕ್ಟ್ ಸರ್. ಹೂ ಆರ್ ಯು? ಆರ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರ್? ದೆನ್ ಆಯ್ತು, ವಿಲ್ ಸಿ. ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್. ವೈ? ವೈ ಯು ಆರ್ ನಾಟ್ ಹರ್ಡ್ ಬಿಫೋರ್ ದಟ್? ಮತ್ತೆ ಸೊ ವಾಟ್? ಅಸಿಸ್ಟೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ನೋಡಿ. ಎಸ್, it will come on Tuesday. Give it. Monday is GMCPC day. Tuesday ಕೊಡಿ ಸರ್. ಏನ್ ಅಲಾಟ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? ಆಯ್ತು, ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ ಬಿಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಡೋಂಟ್ ವರಿ, ಗಿವ್ ಇಟ್. ಎಸ್, ನಾಳೆ ವರ್ಕಿಂಗ್ ಇದೆ, ನಾಳೆ ತಗೊಳ್ಳೋಣ. CRP ಏನಾಗಿದೆ ಮೇಡಮ್? ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೋ ಆಗಿದೆಯಾ? ಸೊ ವಾಟ್? Monday, give it. Come, give it. Yes. No problem, sir. Give it. Yes. It will come. Give it. Which order? ಯಾವುದು 15 days ಅಲ್ಲಿ? What date? ಎಲ್ಲ ಕಳಿಸಿಬಿಟ್ಟಿದ್ದೀನಲ್ಲ, ಯಾವುದು ಇಲ್ಲ. ಚೆಕ್ ಎಲ್ಲ, ನಥಿಂಗ್ ಇಸ್ ದೇರ್. ಇಟ್ ವಿಲ್ ಬಿ ಅಪ್ಲೋಡ್. ನೋಡಿ ಮೇಡಮ್, ಎಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದೀನಿ ನನ್ನ ಹತ್ರ, ಯಾವುದಿಲ್ಲ. ನೀವು ಯಾರು? ಹಾ, ಮಂಡೇ. ಆಯ್ತು ಕೊಡಿ 230 ಕೊಡಿ. Give it. So what? ಆಯ್ತು ಅದಕ್ಕೇನು 230 ತಗೋಬೇಕಾ ಮತ್ತೆ ಕೊಡಿ ಬರುತ್ತೆ. ಆಯ್ತು ನಾಳೆ ವರ್ಕಿಂಗ್ ಇದ್ರೆ ನಾಳೆ ಬರುತ್ತೆ, ಇಲ್ಲಾಂದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ. Can't help sir. Yes, if tomorrow is working it will come. CRP day is Thursday, it will come, give it. Yes Sidramana. GM ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು ಇದು ಕೋರ್ಟಲ್ಲಿ 8 ಇಲ್ಲ 16 ಯಾಕೆ GM CPC ನಾ ಕೊಡಿ ಫ್ರೆಶ್ ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್. ಎಸ್ ಇವತ್ತಿಲ್ವೇ ಇಲ್ಲ ಕೊಡಿ. ಎಸ್ ಮಂಡೇ ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಗಿವ್ ಇಟ್ ಸರ್, ಗಿವ್ ಇಟ್ ಮಂಡೇ ಥರ್ಸ್ಡೇ.
ಸೈನ್ ಮಾಡಿ ಸರ್ ಮೆಮೊ. ಅಯ್ಯೋ ಮೆಮೊ ಹಾಕಿದೆ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿ ಮೆಮೊ, ಅದು ಮಾಡಿ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಎಸ್ ಕಾಲ್ ಕೇಸ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ನಂಬರ್ 1
ನೋಡಿದ್ರ
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು 8/4 ಅದಾದ್ಮೇಲೆ ಕೋರ್ಟ್ನವ್ರು ಆರ್ಡರ್ ಮಾಡಿ ತಮ್ಮ ಮುಂದೆ ನಮ್ಮ BDS ಸರ್ ಅವರು ಕೃಷ್ಣ ಅವರು ಓದಿದ್ದ ಲೆಟರ್ 8/4/25 yesterday on the
they will not be encroaching upon, they will put up construction only in the area.
ಹೌದು ಅದ
ಇದೆಯಲ್ಲ
ಅವ್ರದ್ರಲ್ಲೇ ಇದೆ, ಅವ್ರದ್ರಲ್ಲೇ
ರಿಪೋರ್ಟ್ ಅಲ್ಲೇ BCGH.
ಹೌದು
ಮೈಕ್ ತಗೊಳ್ಳಿ.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇರೋದು ರೋಡ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ
ಇಲ್ಲ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಇಲ್ಲಿ ತಾವು ನೋಡ್ಬೋದು
ರೋಡ್ ಪೋರ್ಷನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಟೇಕ್ ಆಕ್ಷನ್,
ಅದೇ
ಅಷ್ಟೇ.
ದಟ್ಸ್ ಆಲ್.
ಅಲ್ಲ, this order will not come in the way of
they am taking action if you are encroaching upon the road, as simple as that. The petitioner is before this court seeking the following prayer. Heard the learned senior counsel Srimati S. Sushila appearing for the petitioner and the counsel sons. What has driven the petitioner to this court in the subject petition is an order dated 28/2/2025 issued by the 11th respondent in respect of petitioner's sites. 11th respondent yaru madam? The special task force of the vigilance squad of the Bangalore Development Authority. During the pendency of the subject petition, it transpires that a slew of orders are passed by the coordinate benches of this court. The orders that are necessary to be noticed are as follows. 17/3/2025 ಆಮೇಲೆ ಯಾವುದು 24/4/2025 order extract ಮಾಡಿ. In terms of the aforesaid orders, a survey was directed to be conducted and a sketch of such survey was also directed to be placed. Who conducted the survey?
ADL.
The Assistant Director of Land Records conducts the survey, a joint survey, and has filed his report along with a sketch. The sketch appended to the report is indicative of two factors. One, in survey number, it is indicative of the fact that the marking shown as B, C, G and H, which are the properties of the petitioners in which they are now wanting to put up or putting up construction, is not a subject matter of any acquisition. The allegation of the BDA is that the construction is being put up encroaching upon a passage or a road that belongs to the government, it is therefore action was sought to be taken. The learned senior counsel, Srimati S. Sushila, would submit that they are not encroaching upon the road for the purpose of construction, and if the BDA finds that they are encroaching upon the road for construction, liberty be reserved to them to take appropriate action.
That is not my, the next portion is your lordship's order.
ಸರಿ ಬಿಡಿ.
ಅದನ್ನ
The learned senior counsel submits, ಅದು ಬರ್ಕೊಳ್ಳಿ. Learned senior counsel taking this court again through the sketch would submit that they are putting up construction only in the portion that is owned by them and not in any passage or a road of the government. The learned counsel for the BDA would, however, dispute and seek liberty be reserved for the BDA to take action in case they find that the construction being put up by these petitioners is encroaching upon the road, of the government. The submission would merit, both these submissions would merit acceptance. In that light, I deem it appropriate to dispose these petitions, recording the report of the survey that the petitioners are not, the lands of the petitioners are not subject matter of acquisition of any kind, and permitting them to put up construction in the, as they are doing at this juncture in the properties at B, C and G of the sketch. The BDA is at liberty to take appropriate action in accordance with law in the event they find that the construction is encroaching upon the road belonging to the government. With the aforesaid observations, the petition stands in the light of the aforesaid circumstance, as a matter of form, the order impugned stands quashed. The petition is disposed with the aforesaid observations.
BCGH ಅಂತ
ಅದು BCGH, ಅದು ನೋಡ್ಕೊಳ್ಳಿ ಚೇತನ್.
ಆಮೇಲೆ ರೋಡ್ದು ತಮ್ಮ ಆರ್ಡರ್ ಏನೇ, ರೋಡ್ ಬಗ್ಗೆ ತಮ್ಮ
ನಂದು ನಿಮ್ದು ಏನಿಲ್ಲ,
ಗ್ರೇಟ್ಫುಲ್
ಇಲ್ಲ ಅವ್ರ ಸಬ್ಮಿಷನ್ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
ನಂದು ಒಂದು ರೋಡ್ದು ಅಂತ ನಾನು
ನಿಮ್ದೇ ಅದನ್ನ ಕರೆಕ್ಟ್.
ಗ್ರೇಟ್ಫುಲ್.
ಎಸ್.
Number 2.
In this case, my lord, I am for the respondent KDB, my lord. The land was acquired.
ಇದು ಕವರ್ಡ್ ಅಂತ ಹೇಳಿದ್ರು, ಕವರ್ಡ್ ಅಲ್ವಾ?
Covered, but in meantime, my lord, the beneficiaries not made them a party. And also, my lord, I have to file it because Lokaita cases are pending. The beneficiary has deposited 200 crore in the KDB, my lord.
200 crores.
Yes, my lord. That's the reason.
Beneficiary ಯಾರು?
Yeah, is
KDB.
No, not on behalf of the beneficiary, my lord.
Let me clarify the question.
Itasca.
Wait.
Totally 450 acres were notified under the preliminary notification. Out of the 450 acres, only 325 acres were for the benefit of Itasca company. Another 125 acres, my land fall under 125 acres. Nowhere I have stated in the petition also, my land is nowhere related to the 325 acres that was supposed to be allotted to the Itasca. Other basis mele, the petitions came to be allowed, even division bench confirmed, it went up to Supreme Court. Kindly see Annexure G, my lord. Very same survey number. Annexure G, page number 75.
One moment.
Page number 75, very same survey number. This honorable court quashed the acquisition proceedings and they have taken it up. Appeal, my lords. Kindly see page number 81.
87. 87, SLP 91.
ಹೌದು, ಅಲ್ಲಿ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ there is a specific finding with regard to ಲೋಕಾಯುಕ್ತ.
ಇದನ್ನ ಫಾಲೋ ಮಾಡಿ annexure H.
ಹೌದು, ಮತ್ತೆ there are several orders, almost a dozen orders.
Anything else, sir?
Just I wanted to brought to the notice of
Nothing
all
but-
these. One week time, madam.
Why, sir?
Written objections, madam. There are
What objections?
Considered.
There are so many orders passed by the coordinate bench. Why should I wait, sir?
They filed
A week time.
20,
A week time, my lord. I will file the objections. Thereafter, my lord, this court can consider it.
objections ಹಾಕ್ಲಿ, they should be specific. ನಮ್ದು Itasca
Date
it
may
is
be
not
ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಕಾರಣಾಂತರಗಳಿಂದ ಹಾಕ್ತಾರೆ ಅವರು ಅಲ್ವಾ?
Is only the reason.
objections ಹಾಕೋದ್ರಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. They should not-
Let him get material instruction.
Please.
Yes.
Date may be fixed.
This is the matter. Next Thursday ಹಾಕಿ ಮಾಡಿ. It is made clear no further time would be granted in the matter in the score that the issue in the list stands covered by plethora of judgments rendered by the coordinate bench.
Much.
Yes.
3.
Copy not yet served, my lord. Read petition.
Already some again.
Yes, Sumit, ನೀವ್ಯಾರಿಗೆ?
I appear for respondent number 3, private respondent.
What's the matter? KDBA, BDA.
Alla,
BDA,
BDA.
BDM.
Consider representation.
On that ground, they are seeking an interim order against me getting any development plan, my lords. They are saying their land is adjacent, they have not got compensation. Nanu relinquish madidini, because I have relinquished, I should not get development plan. That is their case in short.
ಇವ್ರ ಮೇಲೆ ಯಾಕೆ? ಅಲ್ಲ, ಕಾಪಿ ಕೊಟ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ಇವಾಗ
Who are you?
My colleague.
ಹಾ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕೊಡ್ಲಿ.
ಇವತ್ತು ಕೊಡಿ.
ಅಲ್ಲ, ಇವ್ರ ಮೇಲೆ ಯಾಕೆ ನಿಮ್ ಪ್ರಾಬ್ಲಮ್?
ನಮ್ ಪ್ರಾಬ್ಲಮ್ ಅಂದ್ರೆ ನಮ್ಗೆ ಯಾರಿಗೂ ಕೊಡಲ್ಲ, ಅವರಿಗೆ ಮಾತ್ರ ಕೊಡ್ತಾ ಇದೆ.
ಏನ್ನ?
ಇದು PRR ರೋಡಿಗೆ
ಆಯ್ತು,
ಏನ್ ನಮಗೆಲ್ಲ ಅವಾರ್ಡ್ ಮಾಡ್ಬೇಕು, ಕಾಂಪನ್ಸೇಷನ್
ಅದನ್ನ
ಕೊಡ್ಬೇಕು,
ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಅದನ್ನ ಅಲ್ಲ, ನಮಗೆ ಅದರ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕೇಳಿದ್ರೆ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ,
ಇವತ್ತು
ಅದೇ-
ಮಾತ್ರ ಪ್ಲಾನ್ ನ ಮೇಲೆ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡ್ತಾನೆ ಇದಾರೆ, ಅಲ್ಲಿ ಇಡೀ ಎಂಟೈರ್ ಒಂದು ಸಿಟಿಯನ್ನೇ ಡೆವಲಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಪ್ಲಾನ್ ನಮ್ಮ ಮೇಲೆ ಪ್ಲಾನ್. ಏನ್ ನಿಮ್ ಪ್ಲಾನ್?
125 acres ಗೆ ಅವರಿಗೆ ಇದು ಡೆವಲಪ್ಮೆಂಟ್ ಟೌನ್ಶಿಪ್
Have to verify me.
My lords,
You are sanctioning plan after plan.
my lords, from 2009, my lords, the city, Bhartiya city township has been developed. This is not the first
Outside
time.
ಭಾರತೀಯ ಸಿಟಿ ಇದೆ.
Bhartiya city, my lords. About 11 different development plans have been given to me from the year 2009 onwards, my lords. I have relinquished all the portions of the road that were belonging to me. I have not
I will
constructed
see.
on the road.
If you want to file your objections, you
I
file.
will file my objections.
No
my lords.
interim order.
I have not sought for only
ಹೇಳಿರೋದು
land.
ಮ್ಯಾಂಡಮಸ್ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಗೆ
ಅದನ್ನ ಮಾಡ್ಲಿ
ಅವ್ರು
ನಮಗೆ
ಅವ್ರ
ಕೊಡ್ತಾ
ಪ್ಲಾನ್
ಇಲ್ಲ ಅವ್ರು.
ಅದನ್ನ ಸ್ಟೇ ಕೇಳ್ತಾ
ಅಲ್ಲ,
ಇದೆ.
ಈಗ ಅವರಿಗೆ ಮಾತ್ರ ಒಂದು ಎಲ್ಲಾ ರೀತಿಯಲ್ಲೂ
ಸರ್,
benefit
interim
ಕೊಡ್ಕೊಂಡು-
plan should be in aid of main, not in aid of something else.
Lords, my grievance is, my lords, so they don't give any sort of, my lords, even papers also to us. Whereas, my lords, they,
ಈಗೆಲ್ಲ ಕೊಡ್ತಾರೆ. ಎಸ್ ಕೃಷ್ಣ ಅವ್ರೆ, ಆಯ್ತು, ಅದೇನೇನ್ ಬೇಕು ಅವ್ರಿಗೆ ಯಾಕೆ ಕೊಡಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ನಾವ್ ಏನು ಜಾಸ್ತಿ ಏನ್ ಕೇಳಿಲ್ಲ. kindly see, my lords, annexures
ಜಾಸ್ತಿ ಏನ್ ಕೇಳಿಲ್ಲ, ಅವ್ರದ್ದು 11 ಪ್ಲಾನ್ ಕೇಳಿರ್ತೀರಾ.
8 to A25 ತಾ ಒಂದ್ ನಿಮಿಷ ನೋಡಿ,
ಓ,
page 25 ಅಲ್ಲಿ.
see, the construction itself has fallen now. Yes. ಹಾ, ಹೇಳಿ.
Page 25. Wherefore, we request your good self to furnish the details regarding the procedure adopted by number one amongst you in determining the compensation under the acquisition scheme, which is not formed till today. Your early responsibly appreciated. This is all we are seeking.
My lord, here this information is concerned, my lord. This is pertaining to the peripheral ring road number 1, my lord. There the award is concerned, my lord. The earlier in the batch of matters, the Advocate General made a submission that they will consult with the villagers and the landowners. Then they will determine as a special case to this peripheral ring road acquisition. That they have, my lord, now they are carrying on, my lord, to the village wise, the meetings to the village.
ಅದೇನ್ ಅದ್ರ ರಿಪ್ಲೈ ಕೊಡಕ್ಕೇನು?
Our procedure ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಆಯ್ತು, ಏನ್ ರಿಪ್ಲೈ ಕೊಡಕ್ಕೇನು?
And ನಮಿಗಾಗೋಗಿ
ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ he will challenge that.
ನಮಿಗಾಗೋಗಿ ಏನು ಕೊಡಲ್ಲ. Whereas, my lords, for Bharatiya city, they have relinquished, they have released the.
No, I have not gotten compensation, my lords. I have gotten development plans after relinquishing the
Even
land.
the development plans and also, my lords,
ಅಯ್ಯ, ಹಂಗೆ ತೋರಿಸ್ತಾರೆ ಎಲ್ಲ. ಓಕೆ, ಅದೇ ಯಾಕೆ? ಹ್ಮ್ ಹ್ಮ್ ಯಾರು ಗೊತ್ತಾಗಿಲ್ಲ ಬಿಡಿ. ಎಸ್, ಹ್ಮ್
That's all I am seeking.
ಕನ್ಸಿಡರ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿ. ವೈ ಎ ಮ್ಯಾಂಡಮಸ್ ಫಾರ್ ದಟ್ ಆಲ್ಸೋ. ಐ ಟೇಕ್ ಇಟ್ ಆನ್ ಥರ್ಸ್ಡೇ, ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ. ಕಾಪಿ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಥರ್ಸ್ಡೇ, ದಿ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಾಕ್ಬಿಡಿ, 12th. ಎಸ್,
Grateful.
ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್. ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್.
Please.
ಅಷ್ಟ್ರಲ್ಲಿ ನೀವು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವ್ರು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ರೆ,
Please.
challenge it if you.
Compensation granted to us in the first.
That's all right. Whatever they want. Even if you want to file something, please file.
Please, yes. I'm grateful.
Admission seal number 4.
2020.
Appear for
In such an.
respondent number 1. That's very short point. My lords, issue regarding the maintainability of the suit is framed, want of jurisdiction of civil court. As the suit is hit by Karnataka Rent Act. Because if a rent is more than 2,000 rupees per month,
Correct.
then civil court will not have a jurisdiction. Now preliminary issue is framed at my instance. My lords, the court, my lords, records a finding holds that as per the plaint averments, the lease, original lease is for 2,000 per month. In his plaint averments, he says that after 2015, I used to pay 2,500 per month. And accordingly, based on the averments made in the plaint, which my lords would finding at page number 23 and 24, where court holds that it has got jurisdiction since the plaint averment says so.
Correct.
My lords, my limited submission before my lords
Yeah,
court,
Order 7 Rule 11 Act.
please. Not order 7, rule 11.
Jurisdiction.
Issue is framed with regard to the point of jurisdiction
That
and it was treated
only
as
by-
a preliminary issue.
Court has to go only by the plaint averment.
No, this is not the case of rejection of plaint. My lords, this is a case
Even
of,
jurisdictional issue. Yes.
my lords, now I want to pursue in this matter.
Yes, sir.
Lords, issue with regard to the jurisdiction is mixed question of law and fact.
Correct.
I should be given an opportunity.
Jurisdiction, law and fact alla limitation. Jurisdiction issue one day either yes or no.
No, my lords.
Maybe antilla alli.
My lords, now
Yes.
point is here, my lords. He says that, my lords, 2,500. And I say it is only 2,000.
If it is
Evidence
2,000,
has to
if
be
it
led.
is 2,000, it is before this court. If it is 2,500, it goes elsewhere.
Correct.
Correct.
Now, my lords, he says that it's 2,500, therefore.
As on the
court
date
got-
of presentation of the plaint, what is the plaint averment?
Plaint averment, what he says that lease is for 2,000. After that, different to, after 2015, different is to pay
What is the
2,500.
date of the lease?
Plus date of lease, which is mentioned that, that is,
Yes,
6/8.
6/8,
2000, 18/1/2006.
18, 2000,
2016 ಗೆ
2,500 ಯಾವಾಗಿಂದ ಆಗುತ್ತೆ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಅದು?
ಹೌದು 2015 ಅವ್ರದ್ದು ಮುಗ್ದ ಮೇಲೆ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿರೋದು ನಾನು 2015.
2,500ಕ್ಕೆ. Preliminary issue is held against you.
Yes, held
Perfectly held
against.
against.
My lords, what the, my lords, courts have held is
Cross
that
examination
even
ಮಾಡಾಯ್ತು.
issue regarding the jurisdiction, sometimes it is a
Mixed
mixed question of law and fact. Therefore, evidence has to be, opportunity to lead and evidence has to be.
Records are clear as on the date of presentation of the plaint in 2006 or the lease deed, it is 2,000 rupees.
Yes,
2015 ಅಲ್ಲಿ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗಿ 2,500 ಕ್ಲೈಮ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
enhancement ಅಂತ ಹೇಳಿಲ್ಲ ಅವ್ರು.
ಮತ್ತೆ?
What the plaintiff says is, I used to pay 2,500 rupees, that is the averments made in the
That is,
plaint.
we'll go by
But
the
just
document, not
place
by the statement.
Some decision of this.
No, sir.
My lords, kindly see, my lords, when
ಇಲ್ಲಿ
there is a.
jurisdiction issueನೇ ಬರಲ್ಲ, ಮಿಕ್ಸ್ಡ್ ಕ್ವಶನ್, ಲಾ ಫ್ಯಾಕ್ಟ್.
Plus, what had happened is that, my lords, if an evidence is led, I am able to prove that, my lords, rent is only 2,000. Plus, I have not been given an opportunity to lead an evidence. The courts have held that opportunity should be given to lead an evidence. That's what the courts have held. I just placed the decision of the.
ಕೊಡಿ.
Lords, first decision, that is Ramavatar Agarwal versus Roshan Motors. Lords, I draw my lord's attention to para number 5. Having regard to the submission made by the learned counsel for the parties and after perusing the document placed on record and impugned order passed with the trial court, it appears that, I'm sorry, trial court, while deciding the issue of jurisdiction as a preliminary issue, has ordered to return the plaint for being presented in the competent court having jurisdiction, relying on the clause contained in the agreement. It further appears that trial court, while deciding the preliminary issue, has not permitted the parties to lead an evidence. At this juncture, it is pertinent to note that as per order 14 rule 2 subclause 2, court could try the issue of jurisdiction as a preliminary issue and dispose of the case on such issue, meaning thereby court is required to give an opportunity to the parties to lead an evidence. Kindly mark this. For trying the said issue of jurisdiction for being decided as a preliminary issue. In the instant case, it appears that there were two conditions.
You are the tenant.
I am a tenant. Then another decision of this court, my lords, that is very old decision.
This court alla, sir.
I'm sorry,
Madhya
Rajasthan.
Pradesh.
First one is Rajasthan High
First
Court.
Rajasthan, next Madhya Pradesh.
Madhya
This is
Pradesh. Kindly see
Karnataka.
para number 8.
Yes.
Para number 3.
Yes, sir.
It is desirable that whenever any question of deciding a preliminary issue arises, trial court should, before deciding it, ascertain from the parties whether they want to lead any evidence on it, and if the party so desires, should give them an opportunity to lead an evidence.
Ella desire. He doesn't desire.
I am desiring, my lords, to lead
it
an
is
evidence.
desirable ಅಷ್ಟೇ.
At my instance, my lords, the preliminary issue is framed. I should be given an opportunity to lead an evidence because, my lords,
My lords, the order of the trial court. In page 18 of the
ಇದೆ
order,
ಹೇಳಿ.
reasoning, when the rent claimed by plaintiff exceed rupees 2,500 as per section 2
Yes.
E
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? 18.
order judgment ಇದ್ದು, page number
That civil
18.
court has no jurisdiction, trial should contend ಆಯ್ತು. ಆಮೇಲೆ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
Plaint ಅವ್ರು ನನಗೆ actually petition
Plaint government.
ಅಲ್ಲ petition ಕೊಟ್ಟಿಲ್ಲ,
ಹಾ.
order ಇದ್ದು.
Petition
in page-
copy ಕೊಟ್ಟಿಲ್ವಾ?
In page 18 of the order, ಬೇಡ, let it. In page 18 of the order of the trial court.
Why copy ಕೊಟ್ಟಿಲ್ಲ ಸಚಿನ್?
Copy, ಗೊತ್ತಿಲ್ಲ.
ಇಪ್ಪತ್ತರಿಂದ
Notice ಜೊತೆ
print-
ಹೋಗಿರ್ತದೆ.
ಇಲ್ಲ ಬರ್ಲಿಲ್ಲ.
If he doesn't have copy, I can serve.
ಇಲ್ಲ ಬೇಡ. Order.
ಬೇಡವೇ ಬೇಡ ಹೇಳಿ. Yes.
The court is with me, why should I need a order?
How do you
No, my lords, trial court order.
presume such things, sir?
Trial court order I am talking.
Ah,
My lords, in page 18 of the trial court order.
the plaintiff in his plaint clearly ಅದ.
ಹೌದು.
Ah,
When the rent claimed by the plaintiff exceed rupees 2,500 as per section 2
ಎಲ್ಲಿ
E2.
I'm not getting where you're reading, sir.
Para 14 of the impugned order, my lords.
The plaintiff in his plaint clearly stated that the agreed rent as per lease is 2,000 per month, adena?
Correct.
House. Two
Ah,
month.
The defendant number one has paid rent
to him.
to him till 2015 and proceeding, and the preceding month past
Month
few
for-
years,
Defendant number one used to pay the plaintiff monthly rent of
2,500.
2,500. Therefore, on perusal of the above means of the plaint, it is clear that after December 2015, rent payable by defendant number one to premises is at rate of rupees 2,500 per month. Wherefore, the rent claimed by the plaintiff exceed rupees 2,000 per month. Defendant number one and two clearly deny tenancy relationship with the plaintiff and allege lease deed between plaintiff and defendant number one. When the rent claimed by plaintiff exceeds rupees 2,500 as per section 2E2 of Karnataka Rent Act, and when defendant number one specifically denied tenancy relationship with the plaintiff, the alleged lease question applicability of Karnataka Rent Control Act to the present case will not apply. This is a reasoning, my lords.
you have denied relationship.
Yes, my lords.
My lords, I am a defendant. I can always take inconsistent pleas. My lords, plaintiff cannot take inconsistent plea. Defendant
All
can
right.
always take inconsistent plea.
Hmm.
It's a valid defense which is available to the defendant.
Hmm.
My lords, I have specifically stated in the written statement saying that suit is hit by Karnataka Rent Act.
Hmm.
There's a specific element and issue is framed. Considering my stand,
Now that issue is held against you.
which is held against me based on the contention of the plaintiff. I have denied it that the rent is only 2,000, not 2,500. Issue is framed. All that I'm
So you have
requesting.
denied tenancy relationship itself.
My lords, it's a defendant, my lords. What I can impress upon court is that I am being a defendant, I can always take inconsistent stand.
ಈಗ 2,000 2,500
2,500.
ನೀವು ಕೊಡ್ತಾ ಇದ್ದ,
ಅವ್ರು
ಅವ್ರು ಕೊಡ್ತಾ ಇದ್ ನಿಮಗೆ.
ಹೌದು. Earlier it was-
2,500 ಆದ್ರೆ ಯಾವ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕದು?
ಇದೇ ಕೋರ್ಟಿಗೆ ಬರುತ್ತೆ. Till 2,000 ಆದ್ರೆ 2,000
Up
ರೂಪಾಯಿ
to 2,000 it is rent court,
control.
rent control, yes.
2,000 ಮೇಲೆ 1 ರೂಪಾಯಿ ಆದ್ರೂ it should.
All
it is
that
a
I'm requesting,
jurisdictional
permitted
court.
me to lead an evidence.
Hmm.
My lords may stipulate the time also. I'll read the evidence on preliminary
Commercial.
issue, my lords, that court decide the issue regarding the preliminary issue. My lords, because my lords, what had happens is that he says it is 2,500, I say it's 2,000 only. For that, my lords, evidence has to be led. Otherwise, my lords,
So what, do you have any document of 2,500?
no document is produced on record.
ನಂದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ at present situation ಅಲ್ಲಿ. ಅವರು WSO amendment ಹಾಕಿದ್ದಾರೆ ಈಗ 2024 ಅಲ್ಲಿ.
Huh. No, do you have any document of 2,500 payment?
ಇಲ್ಲಿ ಇವತ್ತು right now I don't.
You get it, we'll see. We'll take it on Thursday. Copy on ಕೊಡಿ ಅವ್ರಿಗೆ.
Great, great.
Yes. If he has any document of 2,500,
End of it, my lords, my lords may dismiss my petition.
ಅಷ್ಟೇ. You produce cross examination, ಇಲ್ಲ document ಯಾವ್ದಾರು ಇದ್ರೆ ಅಷ್ಟೇ.
Great. My lords may stay the proceedings, my lords.
Yeah. 2016 ಇಂದ ಇಲ್ಲದೆ ಇರೋದು ಈಗ.
ಈಗ issue frame ಆಗಿ evidence ಹೋಗಿ.
ಅಡಿಷನಲ್ ಇಶ್ಯೂಸ್ ಎಲ್ಲ ಇದೆ.
Next
ಏನಾಗಿದೆ?
Thursday we'll see.
Great.
Let's heard so and so, next Thursday.
Yes.
Yes, Harish.
The last statement, there was some compromise talks.
Compromise talks, sir.
That the respondents, Millard, were ready to pay some amount to the plaintiff share. Now the advocate.
Yes, Leeladhar sir.
I am not aware about that aspect.
He was advocate change ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು. Next
That's
week,
okay.
next week ತಗೊಂತೀನಿ ಕೇಳಿ.
Date ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ.
Next week ಅಂದ್ರೆ date.
ಮತ್ತೆ
Next Thursday.
ಆಯ್ತು.
The learned
Also come
counsel,
back to- I will also come back with the.
learned
terms.
counsel for the respondent submits the talks of settlement between the parties are on. in that light, which the learned counsel for the petitioner disputes, but to the disputes and would seek time to secure instructions. List the matter next Thursday.
Much of-
Yes.
6.
None appears list after 2 weeks. There is no representation on behalf of the petitioner. There has been no representation on behalf of the petitioner continuously, which is discernible from the perusal at the order sheets. Therefore, as a last chance awaiting his appearance, list the matter next Thursday. In the event he would not appear, the petition would be dismissed for its non-prosecution.
7.
No, I appear for the petitioner. Petitioner is plaintiff, my lord. He filed the suit for declaration recovery of possession against quarters who are defendants. Well, the suit was at one stage dismissed, then later restored. And
One stage, why was it dismissed?
because I did not pursue the matter
For default.
for default.
All right.
Then again, it was restored to file. Court
Now what has happened?
Look, again, I examined myself. I'll take your lord, my lord, to,
Yes.
my lord, ink page 6, my lord, my lord, ink page 21.
Where is the order of the trial court?
It is at ink page 16, my lord. When the
16.
relevant portion is at ink page 21, man.
This is first appellate court.
Yes,
Where is the order in OS 45 of 2005? (27/7, 2018).
yeah, that is criminal, that is at page 33, man.
23.
33, ink page 33.
All right.
They are all
So
squatters.
that is on prosecution. Recalling application was dismissed.
Dismissed. My lord, on the wrong
Against that-
assumption of fact, my lord.
All right. Against that you went before the first appellate court. Yes. What happened there?
It got dismissed. I came up before the lawyer appellate court. My lord, I draw my lord's attention to ink page 21, my lord.
Yes.
The last sentence of para 11, my lord.
Yes.
The case was posted for evidence.
Yes.
My lord got it.
Yeah, you read it. Yes.
On 28, 11, 9, 16, 10, 20, 11, 2, 1, 2009, 12, 2, 2009, 12, 3, and as a last chance on 3, 4, 2009. On none of these days, plaintiff appellant appeared before the court to lead evidence. Ultimately, trial court dismissed the suit for non-prosecution. But this is wrong, my lord. I have filed my evidence, my lord, affidavit evidence. I produced the certified copy of my evidence in ink page 53, my lord. So on the wrong assumption of fact. My evidence is laid.
Yes. Sir.
I'm appearing for the respondent number 6 authority. So
Which
this could
authority?
But
have
no
been
grievance against the
parties,
authority. I have to state that.
Private parties.
Who's the defendant?
Respondent number 6.
6, sir.
Respondent number 6, the then respondent number 6, my lord.
That is Gram Panchayat.
Yeah, Gram Panchayat. I have no grievance against the
What
Gram
was the
Panchayat.
suit for?
Suit for declaration recovery of possession. Why he was made a party was, my lord, the then secretary of Gram Panchayat.
2005 suit.
Yes.
No, it is still in the preliminary stage.
I am a resident in Bangalore. Suit was there. The lands were there.
Resident in Bangalore and suit is in Chikmagalur.
My lands were there.
So what?
My lord, wrong assumption of fact. I have led evidence.
ಕೋರ್ಟ್ಗೆ ಹೋಗ್ದೆ ಏನ್ ಮಾಡಕ?
Internal 58, if the lordship may kindly see. The MA order, page number 28. The second line, a certified copy of the order sheet reveals that all the time plaintiff was absent and claim was paid on his behalf before the trial court. It was dismissed during the year 2009, that is 3/4/2009 for non-prosecution. Looking to civil miscellaneous number so and so.
It was restored.
Please. Such
After 3
application
years.
restoration suit. In the end, the justice of civil
allowed and the case was restored. The case was pending for 3 years due to default of the appellant.
Well, what happened is after restoration of suit, I had to file, the court should have simply restored the suit and proceeded with it. What the court did was, he asked me to again serve the defendants. And the trial court, my lord. It was a wrong idea. But I had to do it. And because they're all living in temporary sheds on my land, my lord, they were not receiving the summons. With great difficulty, I served all of them. And all of them are now placed ex parte. I produced the order sheet, my lord.
Now, ಇಲ್ಲಿ notice ಆಗಿಲ್ವಾ here?
Here, my dispensed with, because they're all placed ex parte. After the second round, means after it was restored to file, after fresh notices were issued, they did not appear after receiving notice. Well, I produced the order sheet. All the defendants except the secretary. Well, he wanted a vote bank. The reason why I made him a party is, he's not a necessary party at all. The reason I made him a party is because he wanted to have a vote bank. He encouraged these people using his status as a secretary of Gram Panchayat. Well, my valuable right of ownership will be lost, my lord. Equity demands that I must be allowed to take the suit to its logical end.
Sir,
I undertake to finish it in any limited time. that your lord may
delay
prescribe.
defeats equity, sir. Law protects the diligent and not the indolent. You have been totally indolent throughout. This is
Well,
not
one,
the way.
one last chance.
What one last chance?
Well,
One chance is already given.
well, I can put on terms. Well, I have given evidence on wrong assumption of fact.
What wrong assumptions?
The court below says I have not examined myself when I have examined myself. I produced the certified copy. And all of them are ex parte. The court should have proceeded to actually decree my suit. All of them are ex parte, the squatters. And now this man, in the next round, he lost. He is not there at all now.
What next round? Which next
In the
round?
next election, he lost. The secretary who encouraged
Eviction.
these people to go and squat there. My sacrosanct right, my lord, right of ownership, such a valuable lands, because I'm a
You
business.
should know the right was valuable.
I'm a businessman here.
So
exporter.
business ಮಾಡ್ಕೊಂಡು ಅಲ್ಲಿ ಏನು ಮಾಡಬಾರ್ದು. ಕೇಸ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
One last chance. Equity demands.
ಇಲ್ಲಿ who are served, who are not served here?
But only the secretary is served, my lord. Notice to others is dispensed with because they are placed ex parte. All squatters except defendant, the last defendant, all other are ex parte before court below, trial court. Therefore, they can't plead any grievance also.
ನಿಮ್ದೇನ್ objection ಇಲ್ವಾ?
ಅವ್ರು ಏನಿಲ್ಲ.
There is. We will fix 3 months time.
Yes, I will cooperate with the court. I will finish it.
ಕೋರ್ಟ್ಗೆ ಇದೇ ಕೆಲಸ. Yes. No, it does not, because you right of ownership of a property, I am sending it. The petitioner is the plaintiff. Is now at the doors of this court in the subject petition, calling in question an orders passed by the first appellate court dated 15th June 2019, rejecting miscellaneous appeal 8 of 2018, whereby the order passed on 27th July 2018 in civil miscellaneous 5 of 2017 by the trial court comes to be affirmed. The facts in brief germane are as follows. The petitioner is said to be the owner of the suit schedule lands, having purchased it on 28/3/2001. The suit schedule property is said to have been purchased in an auction conducted by the Vishweshwara Iron and Steel Plant, Bhadravati. The plaintiff petitioner makes an application to the Assistant Director of Land Records, Tarikere, to conduct measurement of the suit schedule property and fix the hadbast in respect of the said property. When the petitioner then comes to know that certain people unauthorizedly were squatting in the property of the petitioner and therefore filed a suit in OS 45 of 2005 seeking declaration, possession, permanent injunction against the defendants. The petitioner did not contest the suit in its true sense. It comes to be dismissed for non-prosecution on 7/9/2018. The first dismissal ಯಾವ್ದು?
7/9/2017.
7/9/2017. The petitioner then files an application in miscellaneous application in Civil Miscellaneous 5 of 2017 seeking restoration of the suit in OS 45 of 2005, which also comes to be dismissed. The petitioner then prefers an appeal before the first appellate court only to get it dismissed. These orders are impugned in the subject petition. The learned counsel for the petitioner, taking this court through the orders passed by both the trial court and the first appellate court, would seek to contend that they are premised on wrong assumptions that the petitioner has not led evidence despite passage of 12 years from the date of institution of the suit, and which is again carried over to the order in the first appellate court. He would contend that evidence was led by way of affidavit that was placed before the concerned court. The said affidavit is also appended to the petition. The learned counsel further contend that all the respondents who were squatting in the property of the petitioner at Chikamagalur have did not receive the notice, and it became a Herculean task to serve them. And by the time the service of notice could get effected, the court had dismissed the case for its non-prosecution owing to the alleged fact that the petitioner had not led his evidence. He would seek an opportunity as right to property would be taken away if the orders of the concerned courts would be affirmed. Per contra, the learned counsel appearing for the sixth respondent, Panchayat, and the state would submit that they would have no objection to consider the case on its merit, as the private respondents who are all held ex parte have never bothered to appear before the court after receipt of summons as well. They would leave a decision to the hands of this court. The afore narrated facts are not in this. I have given my swords on Madi. The afore narrated facts are not in dispute. The link in the chain of events and the dates are all a matter of record. The prima facie, the case would clearly depict the indolence on the part of the petitioner. Equity would undoubtedly depend upon the diligence of any litigant, as a delay would defeat equity. But the case at hand, the issue is with regard to the rights of property of the petitioner, which is a constitutional right as well. In that light, a constitutional right as well. On the said premise, I deem it appropriate to notice the orders passed by the concerned courts. The concerned court, i.e. the trial court at the outset, rejects the suit for its non-prosecution. The respondents therein were also placed ex parte. The suit is dismissed on the score that the petitioner has not led any evidence despite passage of 12 years. The evidence that is led is appended to the petition. In fact, the petitioner has placed his evidence by way of an affidavit. Way back, yavat hakididu?
Page 53, in page 53.
The 53, yavat ಕೊಟ್ಟಿದ್ದು sir. ಅದು 10 ವರ್ಷ ಆದ್ಮೇಲೆ
2016. 3/11/2016.
On 3/11/2016, though it was delayed by several years, it was prior to the passage of the order of dismissal for its non-prosecution. The petitioner then files a miscellaneous application seeking recalling of the order on the score that he had already filed his evidence. The court rejects the petition on the score that the plaintiff's evidence, the matter was posted for plaintiff's evidence on 24/8/2017 and has not led any evidence. Long before that, the evidence had been placed before the concerned court. Therefore, there is an error in observation by the concerned court to reject the plaint. The petitioner then files an appeal in a miscellaneous appeal before the Court of Session before the first appellate court in miscellaneous appeal 8 of 2018. The The concerned court, though, the first appellate court records the dates on which the petitioner was granted an opportunity to lead his evidence. But the fact that that had been recorded by the trial court that the petitioner had not let any evidence is carried on to the first appellate court as well. In the light of the property of the petitioner being put to jeopardy by the defendants, and his and right to property, and recognizing the right to property of the petitioner, I deem it appropriate to grant him one opportunity to conclude the proceedings before the concerned court. In that light, the orders of both the trial court and the first appellate court stands obliterated. The matter is remitted back to the hands of the trial court. Obliterated. The suit in OS 45 of 2005 stands restored. The concerned court, the trial court, shall conclude the proceedings. Since the suit is of the year 2005, the trial court shall conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of the order. It is needless to observe that the petitioner has to cooperate with the proceedings for the conclusion of the proceedings. In the event the petitioner would again display indolence, it is open to the concerned court to pass necessary orders in accordance with law. And it is made clear that any other attempt of the petitioner to challenge the said order which is dismissal for non-prosecution on his own accord will not be entertained. Since the petitioner shall appear before the concerned court on 20th of June 2025, and the trial court shall endeavor to conclude the proceedings within 6 months from 20th of June 2025. ಮೇಲ್ಗಡೆ receipt ತೆಗೆದುಬಿಡಿ ಇದನ್ನ ಹಾಕಿ. Yes.
Lord, I'm appearing for the petitioner.
Ejectment petition.
No, my lord, I'm the petitioner. Petitioner counsel aunt is expired. And
Aunt is expired.
Yes, my lord. Petitioner counsel.
ಸರಿ, ಏನ್ ಬೇಕು? ಸ್ಟೇ ಇದೆಯಾ?
Stay there, my lord. Stay there, my lord. Praise 1 week time, my lord. Next.
You are the tenant.
The proxy counsel is.
Proxy tenant. Sorry, yes. At the request of the council appearing for the petitioner, list the matter after 2 weeks on Thursday, 19th. List on 19th. It is made clear no further adjournment would be granted in the matter. In the event submissions would not be made, the interim order would get automatically vacated. Yes, next.
9.
For petitioner.
Deposit 25%.
We have deposited. I will produce the document, acknowledgement. Lordship may kindly have it next week. We have deposited 25% of the suit claim.
Recovery of 70,000 rupees.
ಅದಕ್ಕೆ ಇನ್ನೂ ಪ್ರಾಬ್ಲಮ್.
Kindly have it next week, my lords. I will produce the document.
Plaintiff.
Recovery of what?
Hand loan of 50,000 rupees. Check was issued in repayment that got dishonored. Then we issued notice, no reply was sent. Then my lord, suit for recovery was filed.
It's decreed.
It is
It is
decreed.
decreed, my lords. We have deposited 25%
They
of the
admitted the
amount.
transaction, also issuing of the check. They said after bouncing of the check, I have paid cash. But there is no proof, even the legal notice. They have not.
Deposit ಮಾಡಿದ್ದೀರಾ?
My lords, 25% is deposited
Of what?
of the, my lords, suit amount.
What is the suit amount?
Suit amount is, my lords, 72,695. We have deposited.
Transaction is admitted,
Admitted.
and let him withdraw it.
My lord,
ಅಷ್ಟಾರು ದುಡ್ಡು ನೋಡ್ಲಿ.
if your lordship.
10 ವರ್ಷದಿಂದ ನಡೆಸ್ತಾ ಇದ್ದೀರಾ? ದುಡ್ಡು ತಗೊಂಡ್ಮೇಲೆ ಕೊಡೋದೇ ಇಲ್ಲ.
We already deposited the amount before the trial court.
ಪ್ರೈವೇಟ್ ಬಾರೋಯಿಂಗ್ ಆದ್ರೂ ಅಷ್ಟೇ, ಬ್ಯಾಂಕ್ ಆದ್ರೂ ಅಷ್ಟೇ, ದುಡ್ಡು ತಗೊಂಡ್ಮೇಲೆ ಕೊಡ್ಲೇಬಾರ್ದು.
Lordship may kindly have it next week so that my lords, I'll produce.
ಎಲ್ಲ
the-
ಕೊಟ್ಬಿಡ್ತೀರಾ?
My lord,
ಎಲ್ಲ ಕೊಟ್ಬಿಡ್ತೀರಾ?
ಹಂಗಲ್ಲ. I will, my lords.
File what, sir?
My lords, I will argue the case on merits, my lords. That's the reason. Lordship, kindly have it next week so that, my lords,
When you have admitted the transaction.
my lords, we have admitted.
Ah,
we
if
have-
you have admitted the
My lords,
transaction.
we have admitted, but we have stated that we have repaid it by way of cash, and that, my lords, we have examined one witness.
Well,
Of
where
course,
is-
my lords, no document is produced except, my lords, the evidence of that.
Whom did you examine?
My lords, the party, my lords,
No, whom did you examine? Your friend?
yes, my lords.
Ah, but-
I borrowed from him and paid my.
No, my lords, we have, my lords, the petitioner examined his friend, stating that, my lords, from him he has borrowed that amount. To repay that amount, my lords, therefore, the only conclusion drawn by the trial court is that, my lords, no document is produced.
Correct.
Of course, my lords, evidence is there to show that,
What evidence is? Documental evidence ಏನಿದೆ?
At least,
my lords,
Deposition.
my lords, after repayment of the amount, they have not repay, my lords, returned the check. That's our contention.
Hello, why?
ಈ ಚೆಕ್ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಅಲ್ಲ, ಚೆಕ್ ಮೇಲೆ ಅವ್ರು ಕೇಸ್ ಹಾಕಿರೋದು. My
Check
lords,
ಮೇಲೆ ಹಾಕಿರೋದು.
we are,
On the basis of check, we have filed this suit.
ಕರೆಕ್ಟ್.
ಹೌದು.
ಈಗ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡ್ತಾರೆ, ಕೊಟ್ಬಿಡಿ ಅದು.
ಹೌದು.
ಯಾವಾಗ?
lords, lordship may kindly have it next week.
ನೋ ಸರ್.
ಅಲ್ಲ, ಸ್ವಾಮಿ, ನಾನು I will,
10 ವರ್ಷ 75,000 ಇಟ್ಕೊಂಡು.
ಅಲ್ಲ, my lords, I will try to convince your lordship.
What will
Otherwise,
convince? I am
Legal
not
notice
convinced even
next-
to its semblance.
my lords, next Thursday, next Thursday.
ಅಷ್ಟ್ರಲ್ಲಿ ಕನ್ವಿನ್ಸ್ ಆಗ್ಬೋದು.
ಅಲ್ಲ, my lords, I will try to convince, otherwise,
72,000.
Legal notice, written lawyer notice ಹೋದ್ಮೇಲೆ,
Ah.
they have kept quiet. At least if it is a false claim, one reply should have been issued.
lordship, lordship,
This
may kindly have it
observation-
next week, so that,
ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡೋಣ. ಫಸ್ಟ್ ವೀಕ್ ಇದು.
ಆಯ್ತು.
Will, next week ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ dismissed, definitely. There is nothing in this as of now. Yes. List the matter at the request of the land council appearing for the petition, list the matter on 12th. It is made clear no further adjournment would be granted in the matter. Deposit ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ವಿ.
Council of the petition submits that
25%
25% amount has been deposited in terms of the order of the court and acknowledgement is already filed.
Acknowledgement is not yet filed, my lords. I'll file
And
the
will file the acknowledgement in the course of the day.
My lords, I have got only the copy because it is,
Print ತಗೊಳ್ಳಿ sir.
ಹಾಕ್ತೀನಿ sir.
ಅದು ಕಷ್ಟ. Yes.
10.
I appear for the respondent, my lord. Possession is taken in execution petition on 14/1/2020.
ಇದು ಸೇಮ್ ಆರ್ಡರ್. ಇಲ್ಲಿ ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಮಾಡಿದೆ. ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಕ್ ಹೇಳಿ. ನನ್ನ ಪಿಯರ್ಸ್ ಯಾವಾಗಲೂ ಬಂದೇ ಇಲ್ಲ ಅವರು.
Alla, we have taken possession 14/1/2020 in
So
execution.
nothing survives. Nothing survives.
Nothing survived.
ಆಯ್ತು ಬರ್ಲಿ ಅವರು.
Alla, last time we were late.
ಅದಕ್ಕೆ ಈಗ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಎಸ್ 6 ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ?
11.
Petitioners, Mr. Madam. Lords, petitioner had filed a suit for partition, lords. And subsequently, the respondents were appeared present before the court and again they did not contest the matter. Now he has filed a miscellaneous petition and now the miscellaneous petition is allowed.
ಎಷ್ಟು ದಿನ ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಸರ್?
Same, lords, it was decreed on,
ಯು ಆರ್ ದ ಡಿಫೆಂಡೆಂಟ್.
yes, my lord.
ಹಾ,
No, I am the plaintiff, my
you are
lord.
the plaintiff.
I am the plaintiff. Suit was decreed. Suit for partition was decreed.
Against that,
Against that, they have filed a miscellaneous petition on
ಅದು
22/11/2019.
ಕಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ?
Our contest Madila, and he was very much present. The findings given by the trial court, his notice was served. Millards kindly.
ವಾಟ್ ಡಸ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೂ?
Now the trial court,
ಸೂಟ್ ರೆಸ್ಟೋರ್ ಮಾಡಿದ.
restore Madida.
ಇಲ್ಲಿ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
First respondent, Millards. Other respondents were placed ex parte. Only notice may be issued to him and further proceedings may be stayed.
ಹ್ಯಾವ್ ಬಿನ್ ಸ್ಟೇಡ್ ಇಸ್ ಇಟ್? ಅಲ್ಲ ಇಲ್ಲಿ ಯಾರು ಬಂದಿಲ್ಲಲ್ಲ. ಸುಶೀಲಾ ಹೆಮ್ ಅಂತಿದೆ ಮೇಡಮ್, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. 11 ಅಲ್ವಾ ಇದು?
11 lodge.
ಓ 11, ಸಾರಿ.
My name may be shown, Millards.
Registry to print the name of
S.A. Sudhindra.
S.A. Sudhindra in place of S.N. Ashwath Narayan.
Please, Millards.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಒಂದ್ಸರಿನು?
Illa, it's first time it's coming.
Emergent notice to the respondent returnable by the 30th ಅಲ್ಲ 3rd of July 2025.
Only to respond number one, Millards, there are many other People, they were placed ex parte before
So
the
who is
trial
the
court.
contesting respondent and who was,
Respondent number
who
one, Anjana.
contested the suit?
Yes, my lords. Respondent number one, Narayan Swamy, my lords.
Respondent number one.
Yes,
Emergent
others
note-
may be dispensed.
Barkoli. Learned counsel for the petitioner submits that notice need not be issued to other respondents who are all placed ex parte in all the proceedings before the concerned court, except except Narayan Swamy, who is respondent number,
One,
respondent number one, who was the ಅವರೊಬ್ಬರನ್ನ ಹಾಕಿದ್ದು miscellaneous appeal.
House Swamy.
Yes, also. Returnable by date.
Further proceedings will be stayed.
Further proceedings ಏನ್ ನಡೀತಾ ಇದೆ?
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ matter has been restored now.
Further proceedings pursuant to the, ಎಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದೆ?
Yes, my lords. I filed an IA also, my lords.
For the reasons in order on IN ಮಾಡಿ. For the reasons indicated in the affidavit accompanying the application seeking stay of further proceedings before the concerned court, the proceedings before the trial court in OS so and so, OS 98.
Yes, my lords.
Huh?
Lords, it was 2019, it was disposed of, my lords. On 22/11/2019,
OS 98 shall remain state till the next date of hearing. We'll dispose it next time.
highly obliged.
Hand summons ಅಲ್ಲಿ serve ಮಾಡಿ ಅವ್ರಿಗೆ.
Please,
The petitioner shall also take out hand summons upon the respondent Narayan Swamy.
great. Lord, the petitioner is the defendant before the trial court.
Yes, sir.
The rejection of Order 7 Rule 11, my lord. The ground is that it is barred by law. The plaint averments, my lord, at page 34.
You are the defendant.
Yes, my lord. Initially, they execute absolute sale deed, my lord. And they, after 1 year, they file a suit. Suit claiming that there is another deed named as Marukraya Patra and the right to reconveyance has been given. The prior sought is that, my lord, to declare the sale deed as a mortgage deed. Prior is at page 37.
You ready?
Malad, next week, Malad.
Why?
Malad, Maru Karar Patra is executed on the same day of the execution of the sale deed, Malad. And the petitioner, the respondent is ready to pay the entire sale consideration. And so many time we approach the petitioner, Malad.
What is the suit for?
The declaration of the sale deed, my lord, as a simple
Marukraya Patra
mortgage
as a
deed.
sale deed.
No. The sale deed as mortgage deed, my lord. Another
Sale
prior,
deed as mortgage.
and prior B, my lord, for mandatory injunction to receive the amount and execute a reconfirmation deed.
Yes, sir.
Malad, kindly next week, Malad.
Next Thursday, ashte. Yes. At the request of the council appearing for the respondent, list the matter on Thursday, the next. Yes.
Published.
Appearing for petitioner, my lords. I seek for a short accommodation. For petitioner, my lords, I seek for a short accommodation. Senior is out of station.
Why, sir? Order 7 Rule 11. Rejected.
I am
Yes.
proxy counsel. my lords.
List on, at the request of the council for the petitioner, list the matter on 19th. It is made clear no further adjournment will be granted in the matter. Next. Yes.
Permitted to withdraw this petition.
ಒಂದು ನಿಮಿಷ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಂಗಿಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು. ಕೌನ್ಸಿಲ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ. Emergent notice, Sanjay, 1 minute. Emergent notice to the respondents returnable by the 3rd of July. Yes. Yes, Sanjay.
14.
Seeking permission to withdraw this bill.
Thank you. Learned counsel files a memo seeking to withdraw the petition.
15.
No representation, 19th. Vijay Kumar.
Respondent, my lord. The petitioner, 7 rule 11 order, under order 7 rule 11, my lord.
Reject ಆಗಿದೆಯಾ?
Plaint has not rejected. Application dismissed against the dismissal application there before this court, my lord. Suit for declaration, triable issue is involved.
ಹಾ.
Therefore, my lord, rightly trial court may held the page number 24 may kindly see the reasons, my lord.
Yes.
Para 12, my lord.
Hmm.
This court perused the plaint and plaint government discloses the cause of action for the suit arose on 18/3/2016 when the defendants have received the advance sale consideration amount. and
Specific
subsequent-
performance.
Yes, yes, my lord. And in failed to execute the sale deed in favor of the plaintiff, there is an there on awards, the plaintiff filed the suit against the defendant for specific performance. And my lord, further, my lord, the findings of the court, my lord, is quoted, the relied upon the judgments of the apex court in para 14 and 15. The limitation, my lord, is also covered under para 17.
ಆಯ್ತು, limitation mixed question of law and fact.
Fact,
It's all right.
therefore, my
Yes.
lord, is the order passed by the court is.
What is wrong in this? There is no representation. We have the petitioner as a last chance. List this matter on 12th. Yes, next.
16. Appearing for the respondents.
Defendant's petition, tenant.
Hmm.
I have sought a ground that 2E have to be placed before the HRC.
That's why you are sitting there.
ಅಲ್ಲ, ಅವ್ರು ಅದ್ರಲ್ಲಿ ವಿರುದ್ಧ, ನನ್ಗೆ ವಿರುದ್ಧ.
ಆಯ್ತು.
ಅವ್ರಿಗೆ ಹೇಳೋ
Again,
ಇದ್ರಲ್ಲಿ 2E ನಲ್ಲಿ
ಎಷ್ಟಿದೆ? ರೆಂಟ್ ಎಷ್ಟು?
rent to at the commencement of the petition. ನಾನು ಇನ್ನೂ ಹೇಳ್ತೀನಿ.
ಹಾ.
On 28/10/2024, this I made a submission before this court. Court said, no, nothing, you have to seek only time.
28?
10, I may be last. Only time that ground was not available on that.
Non-payment of arrears of rent.
ಅಲ್ಲ, ejectment suit,
ಅಲ್ಲ,
106 ಅಲ್ಲಿ. That was, I have, last time I paid it,
ಪೇ ಮಾಡಿದ್ದೀರಾ?
pay ಮಾಡಿ. 28/10/2024,
28/10?
2024. This court has
28/10/24. 29/10/24.
No, 20.
Till then, respondent shall not dispose the petition.
my contentions with regard to that, it was not considered.
Rent pay ಮಾಡಿದಾರಾ?
My lord, which they have paid is not contradictory to the memo of calculation which we have filed, my lord.
What are the arrears of rent as on today?
As on today, it's 3,30,000, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
They have paid 2,87,000 and they have not paid the proportionate cost which was imposed by the.
That will determine, no problem.
Cost, ಅದರಲ್ಲಿ
The cost ಆಮೇಲೆ ನೋಡೋಣ.
ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಆಗಿರೋದು ಕಾಸ್ಟ್ 50,000 ನಾನು ಇದನ್ನ ಡಿಡಕ್ಟ್
ಕಾಸ್ಟ್ ಸೇರಿ 326.
320. ಹೌದೌದು, ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದ.
ಪೇಜ್
10,250 ಪ್ರಪೋಸ್ಡ್ ಕಾಸ್ಟ್. ದಟ್ ಇಸ್ ದಿ ಓನ್ಲಿ. ಆಮೇಲೆ 50,000 ನಾನು ಕಳೆದಿದ್ದೀನಿ, ನನ್ನ ಅಡ್ವಾನ್ಸ್ ಕಳೆದಿದ್ದೀನಿ ಅಷ್ಟೇನೆ, ಬೇರೆ ಏನು ಯಾವ್ದು ಇಲ್ಲ. 2,87,000.
287 ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು.
287 they have paid, my lord, but the advance they can't deduct now. When they are about to vacate the premises, then only they can deduct that amount.
That subject matter is here. We will see while passing the final order.
And still they have to pay 93,250 including the advance.
ಅದು ಅವ್ರಿಗೆ ಅದನ್ನ ಸೇರ್ಸಿ ಹೇಳ್ತಾರೆ, ನಾನು ಪ್ರತಿ ತಿಂಗಳ ಕೊಡ್ತೀನಿ.
And we want them to vacate the premises, my lord, which we have paid in our objections.
Correct, we'll see. We'll hear it finally. ಅಲ್ಲಿವರೆಗೆ ಇರ್ಲಿ. ಏನಿದು?
ಕನ್ನಡ ತಿಂಡಿ ಕೇಂದ್ರ ಅಂತ. ಕನ್ನಡ ತಿಂಡಿ ಕೇಂದ್ರ
ಓನ್ಲಿ ಕನ್ನಡ ತಿಂಡಿ
ಅಲ್ಲ, ಕನ್ನಡ ತಿಂಡಿ ಕೇಂದ್ರ ಅಂತ ಒಂದು ಸಣ್ಣ ಇದು. ಅದರಲ್ಲಿ ದೇ ಪ್ರಮೋಟ್ ಕನ್ನಡ ಅಂಡ್ ದೇ ವಿಲ್ ಇವನ್ ಬೆಳಿಗ್ಗೆ ಎಲ್ಲ ಪೇಪರು ಕೊಡ್ತಾರೆ, ಓದ್ದೆ.
ತಿಂಡಿ ಮೂಲಕ ಕನ್ನಡ ಪ್ರಮೋಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಂದ್ರೆ ನಾಮಿನಲ್ ಪ್ರೈಸ್.
But they have not, like, when
They
the
will pay.
order has been passed, they have not paid the arrears, my lord. They have filed the CRP year. After filing CRP, they
ಆಯ್ತು,
have.
287 ಬಂದಿದೆಯಲ್ಲ, ಇನ್ನು ಮತ್ತೆ ಕೊಡ್ತಾರೆ.
Yes, my lord. Please list it next week.
We'll do that, yes. We'll take it on 19th or 26th.
12th, please.
26th.
12th. 12th.
12th ಇಲ್ಲ, yes. ಅಂತ ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ ಇದು.
My lord, like, this is the only premises the respondents have, my lord, like.
ಇಲ್ಲ, 5 ಶಾಪ್ ಇದೆ, ಒಂದು ಶಾಪ್ ನಾನೇ ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದೀನಿ.
The
ನಾನೇ ಎರಡು
petitioner
ಕಡೆ
brother
ಟ್ರಯಲ್
also
ಕೋರ್ಟ್ ಅಲ್ಲಿ
filed one
ಟ್ರಯಲ್
more
ಕೋರ್ಟ್
CRP,
ಅಲ್ಲಿ
my lord.
ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2 ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು. ಒಂದ್ ಪಿಟಿಷನ್ ನಾನು ಅವ್ರಿಗೆ ಏನೋ ಕೆಲಸ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ ಮಾಡಿದ್ರೆ ಬಿಟ್ಕೊಡಿ ಅಂತ ಹೇಳಿ ಬಿಟ್ಕೊಟ್ಟು, ಅದ್ರಲ್ಲಿ 50,000 ಅವ್ರು ಡಿಡಕ್ಷನ್ ಕೊಟ್ರು, ಎಕ್ಸ್ಟ್ರಾ ಬಿಟ್ರು, ಬಾಡಿಗೆ ಎಲ್ಲ ಬಿಟ್ರು. ಇದ್ರಲ್ಲಿ ಬಾಡಿಗೆ ಬಿಡ್ಲಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಅದರಲ್ಲಿ ಪಿಟಿಷನರ್ ಫಾದರ್ ಇನ್ ಲಾ ವಾಸ್ ಅನ್ ಅಡ್ವೊಕೇಟ್, ಆದ್ರಿಂದ ಅವ್ರಿಗೆ ಮಾತಾಡಿ ನಾನು ಹೇಳಿ ಇದ್ ಮಾಡಿಸ್ದೆ. ಇದು ಹೇಗಂದ್ರೆ 5 ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ 3 ಬಿಲ್ಡಿಂಗ್ ಹಾಕಿದ್ದಾರೆ, ಒಂದು ಸ್ಟೇ ಆಗಿದೆ.
ಅಲ್ಲ, ಅವ್ರಿಗೊಂದು ಗೋಲ್ಡ್ ಕಾರ್ಡ್ ಕೊಟ್ಬಿಡಿ, ಫ್ರೀ ತಿಂಡಿ.
ಅಲ್ಲ, ಅದು ಕೊಡುವ.
ಎಸ್,
100% ಕಾರ್ಡೇ ಬೇಕಾಗಿಲ್ಲ. He can come at any time.
What an offer. Anyway, we'll take it on 26th.
Much over.
Or 19th maybe, my lord, please.
Madam, 26th. Yes. They heard the learned counsel appearing for the petitioner and the respondent. The learned counsel for the respondent submits that the arrears of rent as directed by this court is not paid. The counsel for the petitioner submits that 2,87,000 rupees is already paid, which is the arrears of rent as on the date the court directed. And further rents, if any in arrears, would be cleared by the next date, by the 26th, by the next date of hearing. List the matter on 26th and preliminary hearing.
Interim order.
In admission, we'll dispose it.
Interim order.
Interim order subsisting would continue till the next date of hearing.
17th.
Anjaneya. First time ಬರ್ತಾರೆ. Defendant number 36. Order 7. Emergent notice to the respondents. Returnable by the 10th of July. Yes. Next.
18th.
Order 7 rule. Same order. Next.
19th.
19 to 23, same ground, Swami. And also serial number 18 second list, also same ground.
ಆಯ್ತು. ಏನ್ ಗ್ರೌಂಡ್? ಸೇಮ್ ಗ್ರೌಂಡ್ ಅಂದ್ರೆ ಏನು?
Recovery of money, recovery of maintenance charges from the members of the flat association.
ಯಾಕೆ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹಾಕಿದ್ವಿ, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಯಾರೆ on the ground that the association was not registered under the
under the
Builders
act.
Act. It has been registered under the Cooperative Act. ಅದು
Unauthorized collection of money
ಅಂತ
ಕರೆಕ್ಟ್ ಆಗಿ.
ಅದು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿಲ್ಲ, ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಅದೇ ಹೇಳಿದ್ದಾರೆ. But they have not taken such a ground before at the time of return statement.
Will issue notice. 1, 2, 3. Yeah, the emergent notice to the respondents. ಎಲ್ಲ ಕೇಸಲ್ಲೂ returnable by the 11th of July.
18th of second list to same connect. Same.
ಆಯ್ತು. ಇದು ಯಾವ serial number ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಹರೀಶ್?
19 ಇಂದ 23.
19 ಇಂದ 23 plus that.
18
yes.
of second list. Machu.
Next. Non-compliance. Non-compliance ಇರೋದು.
ಅದರಲ್ಲಿ ಏನು ಅಂದ್ರೆ ಇದು ಮನಿ ಇದು ಎಸ್ಸಿ ಇಂದ ಹಾಕಿರೋದು, ಅದು ಸೆಕ್ಷನ್ ಪ್ರಾವಿಷನ್ ತಪ್ಪು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇಟ್ಸ್ ನಾಟ್ ಕರೆಕ್ಟ್ ಪ್ರಾವಿಷನ್ ಅಲ್ಲೇ ಹಾಕಿದೀವಿ. ಅದು
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ ರೂಲ್ಡ್ ಅಂತ ಮಾಡಿ
ಪ್ಲೀಸ್.
ನೆಕ್ಸ್ಟ್
24.
May I please?
ಎಷ್ಟು ರಿಕವರಿ?
ಅಲ್ಲ, ರಿಕವರಿ ಅಲ್ಲ, eviction.
Eviction.
Commercial building. Within 1 year, notice is issued. Notice ಸರ್ವಾಗಿಲ್ಲ.
What is the court done?
ಬಟ್ಟೆ ಅಂಗಡಿ. Court
ಅಂಗಡಿ.
ಬಟ್ಟೆ ಅಂಗಡಿ.
What has the court done?
Court evicted within ordered for eviction within 2 months. Arrears ಏನಿಲ್ಲ. Even the finding is that there is no
ಡ್ಯಾಮೇಜ್ ಮಾಡಿರೋದಕ್ಕೆ ನಾವು ನೋಟಿಸ್ ಕೊಟ್ವಿ ಸ್ವಾಮಿ.
ಏನ್ ಮಾಡಿದ್ದಕ್ಕೆ?
ಡ್ಯಾಮೇಜ್ ಮಾಡಿದ್ದಾರೆ
ಏನ್ damage
ಪ್ರಾಪರ್ಟಿನ, ಇದನ್ನ ಪ್ರಾಪರ್ಟಿನ
ಡ್ಯಾಮೇಜ್
ಮತ್ತೆ
ಮಾಡಿಲ್ಲ.
ರೆಂಟ್
That is
2
not
months
finding
ರೆಂಟ್
it.
ಕೊಟ್ಟಿಲ್ಲ ಅವಾಗ.
ಆಲ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ.
ಆಲ್ಟ್ರೇಷನ್ ಯಾವುದೇ
ತಗೊಂಡು ಆಲ್ಟ್ರೇಷನ್
ಪರ್ಮಿಷನ್ ತಗೊಂಡಿಲ್ಲ.
ಪರ್ಮಿಷನ್ ಅಲ್ಲ ಇವಾಗ ಲಾಸ್ಟ್
ಒಳ್ಳೆ ಹೊಡಿಯೋಕ್ಕೂ ಪರ್ಮಿಷನ್ ತಗೋಬೇಕಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದಾಕಿದ್ರು.
ಅಲ್ಲ ಡಿಸ್ಪ್ಲೇ ಮಾಡಿದ ಅಷ್ಟೇ.
Display
ಡಿಸ್ಪ್ಲೇ
ಇದಾಕಕ್ಕೋಸ್ಕರ.
ಮಾಡೋದಕ್ಕೆ ನಾವು ಇದನ್ನ ಹಾಕಿದೀವಿ ಅಷ್ಟೇ, ಸೀರೆಯನ್ನ
ಅದನ್ನ
ಡಿಸ್ಪ್ಲೇ
ತಗೊಂಡಿಲ್ಲ.
ಮಾಡೋದಕ್ಕೆ. ದಟ್ ಇಸ್ ದ ಓನ್ಲಿ ಆಲ್ಟ್ರೇಷನ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್.
ಇದಕ್ಕೊಂದು ಸೂಟಾ? ಇದಕ್ಕೊಂದು ಸೂಟು, ಅದಕ್ಕೊಂದು ಆರ್ಡರ್, ಇಲ್ಲೊಂದು ಪೆಟಿಷನ್.
ಗ್ರಿಲ್ ಹಾಕಿದಾರೆ ಸ್ವಾಮಿ. ಡಿಸ್ಪ್ಲೇ ಮಾಡೋದಲ್ಲ, ಗ್ರಿಲ್ ಹಾಕಕ್ಕೋಸ್ಕರ ಡ್ರಿಲ್ ಮಾಡಿ ಎರಡೂ ಕಡೆ
ನೀವೊಂದು ಪರ್ಮಿಷನ್ ತಗೊಂಡ್ಬಿಟ್ಟು
ಪರ್ಮಿಷನ್ ತಗೊಂಡಲ್ಲೇ ಮಾಡಿ 2 months ಇಂದು ರೆಂಟು ಕೊಟ್ಟಿಲ್ಲ.
ಈಗ ರೆಂಟ್ ಕೊಡ್ತಾರೆ,
ಈಗ ಕೊಡ್ತೀನಿ, ರೆಂಟ್ ಕೊಡ್ತೀನಿ.
ಈಗ ಕೊಡ್ತಾರೆ.
ಅಲ್ಲಲ್ಲ ಹಂಗಲ್ಲ, ಈಗ ಕೇಸ್ ಆದ್ಮೇಲೆ ಇದು ಇವಿಕ್ಷನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿಲ್ಲ.
ಈಗ ಕೊಡಿ. ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್?
ಅರಿಯರ್ಸ್ 2 months ಇದೆ, ಅದರಿಂದ ಅರಿಯರ್ಸ್ 2 months ಇಂದ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
4 ತಿಂಗಳು. ಎಷ್ಟು ರೆಂಟ್?
ರೆಂಟ್ 9,700.
36,000 ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
ಅದು ಕೊಡ್ತೀನಿ, ವಿದಿನ್ 2 weeks ಕೊಡ್ತೀನಿ.
Yes. The petitioner is before this court calling in question an order of the concerned court which directs eviction of the petitioner. The petitioner is a tenant in the premises owned by the respondent. You are the plaintiff,
Plaintiffs.
respondent, the plaintiff before the concerned court. The learned counsel appearing for the plaintiff would submit that the petitioners did not take any permission to put the grill in the shop, to drill in the shop for display of the saris,
Saris.
display of the saris in which business they are, and therefore the suit was filed, and they are in arrears of rent of rupees 36,000 as on today. The learned counsel appearing for the petitioner submits that the rents would be cleared by the next date of hearing to its last by. The submission is placed on record. They list the matter on 3rd July. Arrears of rent, whatever it is, shall be cleared by the next date of hearing. Subject to the said, there shall be an interim order of stay spread for.
25.
ಕೊಡಿ, ನೋಟಿಸ್ ಮಾಡೋಣ. ಇನ್ನೊಂದ್ಸರಿ ಕೋರ್ಟ್ ಬಂದೆ ಮೇಡಮ್. Order 7, Rule 11. Same emergent notice returnable by 3rd. Next.
26.
Petitioner.
Order 7, Rule 11.
Yes, issue notice to rest.
Issue notice. Emergent notice returnable by 3rd. Yes, next.
27.
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದ್ದಾರೆ, ಇದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ.
ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್
ಪ್ಲಾಂಟಿಫ್.
ನೀವ್ ಯಾರು?
ಪ್ಲಾಂಟಿಫ್.
ವಕೀಲರಲ್ಲಿ?
ವಕೀಲರು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಇದ್ದಾರೆ.
ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಹಂಗೆಲ್ಲ ಮಾಡಂಗಿಲ್ಲ ನೀವು, ಕೊಡಿ.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
ತಗೊಳ್ಳಿ ಮೇಡಮ್. Tag the petition along with so and so. Emergent notice. Yes, next.
28.
The caveat.
Suit for injunction. Application is filed by.
Notes for the respondent. Can I seek for 2 weeks time to file my counter, my lords?
Order 7, Rule 11.
Order 7, Rule 11. On the ground.
Rejected.
Beg your pardon. Rejected. Rejected.
You are before RERA.
Before RERA. They have to go before RERA. Their complaint is suit for injunction is based on the ground that I have changed the parking plan, parking
Notes
layout
before
plan
this, can I
completely.
seek for 2 weeks
After
time?
giving
Yes,
the possession of the.
We'll file the
File
counter.
counter.
ಆಯ್ತು ಮಾಡಿ. ಕೌಂಟರ್ ಹಾಕ್ಲಿ ಬಿಡಿ. ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ ತಾನೆ.
ಅಲ್ಲ ರಿಜೆಕ್ಟ್ ಮಾಡಿಲ್ಲ, ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್.
ಅದೇ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಸೂಟ್ ಅಲ್ವಲ್ಲ. ಸೂಟ್ ರಿಜೆಕ್ಟ್ ಆಗಿದ್ರೆ ಸ್ಟೇ ಕೇಳ್ಬೇಕು, ಅವ್ರು ಬರ್ತಾರೆ. ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಆದ್ರೆ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ಎಸ್. Learned counsel appearing for the caveator Surat Sampath seeks 2 weeks time to file 2 weeks aka? 2 weeks time to file statement of objections. List the matter on 26th June.
Objections, if any, by then, next.
ಸ್ಟೇ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕೇಳಿದೆ, ಅಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಿಯರಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Because this
26
is
no.
on the ground of maintainability of the suit itself.
We'll see, yes.
29.
Order 7 rule 11D was filed by the.
Notice returnable by 3rd July.
30.
Same emergency notice.
31.
7 rule 11. Application was rejected, 7 rule 11.
Correct, notice. Emergency notice returnable by 3rd, all.
32. Party
7/11 ಎಲ್ಲ 3rd ಮುಗಿಸ್ಕೊಂಡು ತಗೊಂಡು.
Lord,
Party in person,
I have filed Vakalat, it is put up in the file. My name is not shown. Last time it was directed.
the registry to print the name of
Keshav
Keshav
Agni-
Agnihotri as appearing for the petitioner and delete the indication of party in person, the indication of the petitioner appearing in person.
The, not to precipitate ಆಗಿತ್ತು ಅದು ಕಂಟಿನ್ಯೂ.
ಅದು ಕಂಟಿನ್ಯೂ. ಎಷ್ಟು ಮನಿ?
Ejectment.
ಅದೇ ejectment.
Yes. In fact, the petitioner has already delivered the possession to the landlord.
ಮತ್ತಾದ್ಮೇಲೆ ಏನಂತೆ ಮತ್ತೆ ನಾಟ್
ಅಲ್ಲ ಅವ್ರೇನೋ ರಿಕವರಿ ಬೇರೆ ಅಲ್ಲಿ ಹಾಕಿದ, ಅದಕ್ಕೆ ಸ್ಟೇ ಕೇಳಿದ್ದೀನಿ. They have filed recovery.
There is no representation on behalf of the respondent. List the matter on 3rd July. Interim order subsisting would continue till the next date of hearing. Next.
3.
I appear for the petitioner's counsel.
Yes, sir.
The matter arises this way. The plaintiff sued the defendants seeking 1/16 share in the properties of C schedule property.
Yes.
And these properties are said to be those of her mother. And therefore she claims a share in those properties. Now, the pleadings are complete. We made an application based on a very sound principle of Muslim law, that a person who does not exercise her rights for a long time, attended with circumstances like getting sufficient funds after the marriage and getting settled several properties in her name, etc., etc. That conduct amounts to renunciation of her claim. This is based on a Privy Council judgment, which I will read shortly, and thereafterwards upheld by the Honorable Supreme Court, recognizing that principle. Now, before that, may I request the court to kindly peruse the undisputed facts of this case. Page 23 may kindly be perused.
Yes, sir.
This is the plaint filed by the contesting respondent. Para 2 at page 25 may kindly be seen.
Page?
Page 25.
20. Second paragraph.
Second paragraph.
Yes, sir.
That the plaintiff and defendants in the above case are Indian nationals, permanent residents of the city of Bangalore. They are Muslims by religious denomination and are constituents of the Sunni sect governed by the Hanafi school of Muhammadan law. And in matters of succession, inheritance, Hanafi law of inheritance. Thereafterwards, at page 28, para 10, page 28, para 10, the plaintiff submit that as determined by the table of sharers, the following persons in accordance with Hanafi law of inheritance would be natural heirs and next to kin of deceased so and so, and the respective shares are mentioned. Again, para 15, next page, that as next page, as aforesaid, Haji Jana Abinabi died intestate, her disposable estate too, divided in accordance with the table of share and residuaries under the Hanafi law of inheritance
as applicable to Sunni Muslims. Again, next several paragraphs, the same is repeated, saying that it is according to the Muslim law that is his claim. So we have set up an application for dismissal of for rejection of the plaint under Order 7 Rule 11 on the ground that it is barred by the principle of renunciation of her claim as upheld by the Privy Council and the Honorable Supreme Court. Now, may I request the court to kindly peruse the last time ಕೊಟ್ಟಿದ್ದೇನೆ records ಅಲ್ಲಿ ಇರ್ಬೋದು.
I'll try to get a copy. Where is it?
I'll try to get a copy.
All right. Yes, ಹೇಳಿ sir. ಇಲ್ಲ ಕೊಡಿ.
Annexure G, we have produced it as Annexure G also.
Oh, it's already an annexure, is it?
Annexure.
Yes.
Annexure.
Yes.
At page 66. Annexure. Yes, kindly come to page 76.
Yes. I am there, sir.
Yes, page 76. So, I'm sorry, there is some, my copy is not readable. But, earlier page 75 make it perused. Last but two paragraphs, internal page 10 it would be. Last but two paragraphs, yes, may I read that?
They may be further remarked that according to Allah.
Earlier to that.
All right.
One para earlier. Their
Yes,
lordships think,
Yes.
their lordships think it of the utmost importance that those who have thus sanctioned a long possession should not be allowed lightly to disturb it or to escape from those legitimate inferences and presumptions which on a conflict of evidence arise from their own acts and conduct. They may further remark that according to the Mohammedan law, there may be a renunciation of the right to inherit, and that such a renunciation need not be expressed, but may be implied from the ceasing or desisting from prosecuting a claim maintainable against another. Their lordships do not say that in this case, the point was not taken in the court below. The acts and omissions of the respondent can be taken up to afford an implication of actual renunciation. So kindly come to next paragraph. Last sentence in the same paragraph. Next page.
Yes.
They have to choose between the cause for the plaintiff corroborated merely by those slight inferences which arise from the depositions already considered, and the case of the defendant corroborated by the very strong presumption arising from the conduct and acts of the respondent. They have already stated, in their opinion, Southern Court has given more effect than ought to be given to the proceedings in the suit of 1832. They think that court has not given sufficient weight to the presumptions arising from the respondent's conduct, and therefore, though unwilling, even when there is a conflict between the two courts below, to disturb the final finding of an issue of fact, they feel bound to say that in their judgment, the respondent has failed to establish the title upon which he sued, and therefore, Jilla Judge was right in dismissing this suit. So this is how the Privy Council said. Thereafterwards, the Honorable Supreme Court had occasion to consider this aspect of the matter.
Which is that?
Yeah, 1973 Supreme Court, page 554.
(1973)
1973 Supreme Court, page 554.
ಇದೆಯಾ?
ಇದೆ.
Yes, Chetan. ಇದೆಯಾ?
Along with a memo, it was placed on the earlier occasion.
Nothing is here, that's the reason. Yes. Anyway, here is sir. You can read.
Yeah. Para 11 at page 557. This is how it reads. Quote, it may be mentioned in Muslim jurisprudence, where theology and moral concepts are found sometimes mingled with secular utilitarian legal principles, contains a very elaborate theory of acts which are good because they proceed from Hana, those which are bad because they exhibit Kuba, and those which are neutral per se. It classifies them according to the varying degrees of approval or disapproval attached to them. The renunciation of a supposed right based upon expectancy could not, by any test found there, be considered prohibited. The binding force in future, kindly mark this, the binding force in future of such renunciation would, even according to the strict Muslim jurisprudence, depend upon the attendant circumstances and the whole course of conduct of which it forms a part. In other words, the principle of an equitable establishment, far from being opposed to any principle of Muslim law, will be found on investigation to be completely in consonance with it. Then para 13. Incidentally, we may observe Muhammad Ali Khan versus Nisar Ali Khan, AIR 1928, Aud 67, has relied upon Harbat Ali Nisam Begum's case, which I cited a minute ago.
Yes.
To hold, according to Mohammedan law, there may be renunciation of a right of inheritance, and such renunciation need not be expressed, but may be implied from the seizing or desisting from prosecuting a claim maintainable against another, as we are clearly of the opinion that they proceed on the basis of estoppel. So this is what the Honorable Supreme Court has also recognized. In the instant case, admittedly, the claim relates to a date of 10/12/2008.
Yes.
After the death of the mother. And she claims.
No, according to you, cause of action arose in 2008?
No, it is the admitted case. It is the plaintiff's case that the cause of action arose on the death of her mother on 10/12/2008.
Paragraph 6 of the plaint.
Yeah.
22.
6 also, 22. 22 is description of cause of action.
Yes, yes.
All right.
And the suit is filed on 19/9/2016 after a long lapse of 7 years and 9 months.
So you're on limitation.
It is not a question of it is not.
You're on two aspects. One is renunciation and limitation.
Yes, yes.
Yes.
Renunciation according to Muslim law.
Correct.
This is a well-recognized principle of renunciation. If a person does not claim inheritance within a reasonable period, then he or she is deemed to have renounced that claim and therefore not entitled. Now, this is a all-important question of Muslim law, which needs to be considered by this House.
Yes. Yes.
Please, my lord. Now, my lord, the Learned Senior Counsel has pointed drawn your lordship's attention to a judgment. I'll just take your lordship to that first.
Of the Privy Council.
Please, my lord.
Yes.
It's 1871 judgment.
1871.
Yes.
Yes.
That's the para that he read out.
Yes.
Now, the same para, my lord, that last para on internal page 10.
Yes.
It says, my lord, they may further remark that according to the Mohammedan law, there may be a renunciation of the right to inherit, and that such a renunciation need not be expressed, but may be implied. From ceasing or desisting from prosecuting a claim maintainable against another. So the word clearly used, my lord, is maybe. Now, taking one step further, my lord, when an application under Order 7 Rule 11 is considered, it is a plaint averments must be looked into, my lord.
Yes.
Now, that being said, my lord, my plaint disclosed the cause of action. I have stated very clearly,
Come to para 22.
Para 22.
Yes.
That is page 31.
Yes.
That the cause of action for the above suit arose on 24/1/1999 when Al-Haj CJ Abdul Qadir expired and his mother Hajia so-and-so inherited share in Schedule B properties owned by him on 10/2/2008 when Hajia Ami
be expired and the plaintiff and defendants inherited undivided shares, right, title, interest and claim of the scheduled properties and defendants 5, 6, 7 and 8 being beneficiaries therein, 2 in view of the demise of the spouse and father of them respectively on 29/1/1999 and subsequently on 2/8/2016 when the plaintiff and the 9th defendant by a notice issued to their counsel so and so demanded a partition of the scheduled properties of meets and bounds and delivery to them of their respective shares therein. And when the defendants 1 to 8 failed to comply with the said demand to effect a division by meets and bounds of the aforesaid scheduled properties, and the defendants
Was
failed.
it an intestate death?
Yes, my lord. It was interstate, my lord. Now, my lord, my case, my lord, is that I have been approaching them subsequent several occasions to seek a partition. That's also called out in para 21. They have kept. If your lordship will also see the written statement, this very same plaintiff, the defendant number 4, who has filed this application, she files 2 written statements, my lord. First, I'll point out the first written statement, which is at
No,
page.
order 7, rule 11, only plaint our.
No, my lord, no, in the written statement, she says we are ready to partition the property.
Where is that?
That is at page 42 is the written statement. Your lordship will see page 48. Page 48, para 7, the last 4 lines, my lord. This is what they say. Now, this is a written statement filed by our defendants 1 to 8 jointly. These defendants have always been ready and willing to give the legitimate share, right, and entitlement of the plaintiff and defendant. Number 9, subject, however, resolution of the issues pertaining to the properties as referred to here and above. So this is what she says in this written statement. Then, my lord, para 11, page 50, para 11. Though the notice was received by these defendants did not choose to reply as they were intending to resolve the matter amicably without the recourse to litigation. So this suggests, my lord, that I have been approaching them several times. They have kept me hanging, my lord, and then I have no other option. I have come to the honorable court and filed the suit. Now, my lord, she comes up with an additional WS, which is at page 55, where she takes other contentions with regard to certain properties that she seeks to incorporate and make some. That's at page 55, my lord. Now, D4 only files this additional written statement. And if your lordship would,
What is this?
she says that there are some additional properties that are also concerned, my lord. This was filed much later, my lord, in 2023, and was allowed on cost of 25,000. Now, in both these written statements, my lord, there is absolutely no plea of limitation that is urged. Both the written statements are silent. Now, what happens, my lord? After this application for rejection of plaints is dismissed, she comes up with another application before the trial court seeking to file a third written statement where she wants to take these contentions of limitation, my lord. So, lordship might see that as on date, this is nothing but an afterthought. This is nothing but an attempt to protract the proceedings. There is no pleading whatsoever in both the written statements filed by her with regard to the concept of limitation. That being said, my lord, it is the point of limitation is a mixed question of fact and law. It will be decided by a trial, my lord. And even the judgment they relied upon clearly says it may be a renunciation. So that will also have to be examined by evidence. So on these submissions, my lord, and this honorable court has also, in another judgment, my lord, which is not on Mohammedan law, but on a case of partition, a coordinate bench. I'll just take lordship to para 15, my lord. In view of the matter, this court is of the agreement that with the trial court in coming to a conclusion that the issue of limitation raised at the hands of the defendants is a mixed question of law and fact, and therefore the same is required to be considered after looking into the evidence that could be adduced by the parties in a full dress trial. At any rate, suit for primary relief of partition and separate possession cannot be rejected at the threshold on the ground that law of limitation would apply insofar as the deed of relinquishment is concerned. Now, my lord, in this particular case, there was an express document, which is the deed of relinquishment, and they took the contention that that would be a ground for limitation. But notwithstanding, my lord, at the threshold without evidence, the proposition of law is that it cannot be rejected without evidence. So on these submissions, my lord, my humble submission is that there is no merit in the application. The trial court has rightly dismissed the application.
No other judgment you have.
No, one more judgment is that the Supreme Court, on the point of limitation.
Where is the latest?
It is.
2025 SEC online, SC 1208.
I'm not aware of the judgment. I will look into it. So this judgment, my lord, head note D.
Yeah, all old ones.
Yeah, I know. This concept, my lord, is about what is the period of limitation. They are urging it as 3 years. But here it says, my lord, Article 144 would apply, which takes it to 12 years, my lord. So notwithstanding that, even on the argument that I've kept out for 7.5 years or 7 years, 9 months, it was within the period of 12 years, my lord. So that being said, my suit is within time. And on that point, the writ petition has the CRP has no merit.
Consider. Yes. Heard the learned senior counsel.
I may reply may.
Anything in rejoinder, sir?
Or- Yeah,
Any submission in rejoinder, please?
yes, my learned friend read out the pleadings, my written statement at page 48. Kindly
Yes.
come back to page 43 in the same written statement. What I have said.
43.
Yeah,
Yes, sir.
paragraph 5. The plaintiff has provided details of 24 items of properties described as plaint C schedule properties. The following properties are not available for partition is the specific case. All the properties, practically all the properties in schedule C up to item number 24, that is KL at page 47. Given the various details, particularly of the conduct of the plaintiff and why those properties are not available for partition. So a specific contention is taken. It is in respect of the remaining properties that this statement was made, that the defendants have always been ready and willing to give the legitimate share.
The both should be, both the paragraphs should be read in tandem.
Yes,
To know what is the intent in the written statement.
Yes, my lord, but my submission is
So
that.
except these properties, the other properties are available.
Maybe, my lord, but limitation has not been urged as a ground in both written statements. That he left.
Where is the third written statement?
That
filed?
is now pending consideration, my lord. An additional application has been filed. Where they have taken the very same contentions, or they taken the 7 to 11 application, which came to be dismissed.
Let's see. Anything, sir?
Yes.
Yes.
My lord, one more point. In that Harmutul.
Senior ಹೇಳೋದು ಮತ್ತೆ ಒಂದೊಂದು point.
Harmutul ಕೇಸಲ್ಲಿ 12 years ಇಲ್ಲ ಸುಮ್ಮನೆ, it is less than that.
That I know, yes. Heard the learned senior counsel, Professor Ravi Kumar, appearing for the petitioner and counsel respondent Rego. Your name is?
Arjun Rego.
Arjun Rego. Reserved.
I appeal for petitioner, my lordship. My application under Order 7, Rule 11 has been dismissed, rejected by Honorable Trial Court.
Notice.
Interim order.
Interim order ಏನು ಬಂತು?
My lordship, they have, Honorable Trial Court has rejected my application only on the ground that we have not mentioned the specific provision of law, my lordship.
ಅಷ್ಟೇ. Only that?
Only on that ground, my lordship.
Take, where is that?
Page number 35, my lordship.
ಇದಲ್ವಾ? ಬೇಕು.
Page number 35, line 8. I don't find any reason as to why application filed by the plaintiff should not be rejected. In the absence, sorry, my lordship, may I permitted to read these lines?
Yes, page, I'm at page 34.
Page 35, my lordship. May I permitted to read? In an absence
What
of,
provision? Yes,
there is a landmark.
emergent notice to the respondent. Petitioner is at liberty to serve the counsel who represented the respondent plaintiff before the concerned court. The learned counsel appearing for the petitioner takes this court through the order passed rejecting an application in Order 7, Rule 11 of the CPC seeking rejection of the plaint. A perusal at the order would indicate, inter-alia, that the court is swayed by the action of the applicant in not mentioning a proper provision of law. It is trite that mere mentioning of a wrong provision of law would not take away the tenor of the application. It is for the court to consider the appropriate provision of law and pass necessary orders, not reject the application on that score. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date. List the matter on 20th,
Grateful, my lord.
19th.
Grateful, my lordship.
My lords, there is another writ petition we have filed. We have filed another writ petition.
Another writ petition.
And
We'll
now
discuss this.
6 Rule 17 accusation that has been rejected. We have filed writ petition in 6350 of 2025.
ಇದೇನು?
7 Rule 11.
7 Rule 11.
That has to be tagged. Otherwise, I am ready to.
ಆಯ್ತು ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ. Tag this petition along with so and so, list them both on 12th.
Issue notice to respond number 5, my lord. Meanwhile,
ಈ ಹಂಗಾರೆ 12th ಬರಕ್ಕಾಗಲ್ಲ ಅದು.
next month.
12th ಮಾಡೋಣ, we'll see. Yes.
We have filed a memo
12th, sir.
application for seeking withdrawal of the suit with a liberty to file a fresh suit, my lord. That is pending for consideration.
ಮೂರನೇದು
ಇಲ್ಲ ನಾವು ಅವಾಗೆ ಹಾಕಿದೀವಿ ಸುಮ್. That has not been considered.
ಆಯ್ತು, we'll see. 12th will take, yes, list on 12th.
36.
My lord, this petition challenging the orders of the trial court in a execution petition, my lord, wherein the court has directed issue of notice when the execution was filed within 2 years as contemplated under Order 21, Rule 22. So there is no provision for issuance of notice, my lord, to the judgment debtor under Order 21, Rule 22.
Yes, yes, one moment. Which is the impugned order?
Impugned order is at page 11, my lord. Oh, sorry. Change.
But here.
Page
we
10,
will-
11, page,
No, I have seen that.
yeah.
It is only said that it will hear and pass an order. That is
Yeah.
page 11, right?
Yes, ma'am. Peruse the petition and other documents, peruse the record clearly shows that until and unless other
This
side
is
is heard.
execution
ex parte-
proceedings.
The execution, there is no ex parte orders in execution. You know. This,
You are the decree holder.
I'm a decree holder.
Yes. Take out notice. Yes.
Notice is not contemplated.
ಇದರಲ್ಲೂ ಬೇಕಾಗಿಲ್ವಾ?
Bekagilla. Lordship can see that this is purely challenging the orders on the basis of Order 21, Rule 22, my lord. And Order 21, Rule 35, where the court, the provision says that the minute we file the petition.
We'll take it tomorrow. Yes, list tomorrow.
Much of that.
Yes.
Thirty-seven.
Lordship kindly pass over.
Rejection of
How are you,
application.
sir?
Order 7.
fine. Yes.
Kindly pass over.
Pass over ಯಾಕೆ? In order 7 rule 11,
Please,
rejected
rejected.
on limitation.
Because the court comes to the conclusion.
Suit
that
for what?
Suit is for declaration that the partition deed dated 29/8/2005 is null and void, and the compromise petition.
What is the date of compromise?
Date of compromise is 2000.
2000.
Then
Suit is
the,
decreed on the basis of compromise,
please, madam.
2005.
No, suit, compromise is done 2000 only. At that time only the suit was decreed. Then subsequently, one leftover property was there. Because of that reason, a fresh partition deed, registered partition deed was entered into. That is on 29/8/2005.
Suit is filed by the respondent when 2021.
21. His mother was a party to all these
Where is,
proceedings,
the-
earlier
where is,
proceedings.
the- where is the plaint?
Plaint at page.
ಒಂದೇ ನಿಮಿಷ ಪಾಸ್ವರ್ಡ್ ಸೋಮವಾರ ತಗೊಂತೀನಿ ಹೇಳ್ತೀನಿ. ಹಾ, where is the plaint?
Plaint, your lordship can see at page 48, my lord.
Page 48.
Page 48, plaint. Here, your lordship, himself has said in para 2, para 3 and page 54. And para 2, the plaintiff submits that thereafter one more suit was filed by Krishnappa and Narayanappa, his uncles,
against Tyagaraja, who is their brother and who was managing the properties after the death of Sonnappa, being the manager of the family by filing a suit OS number 7398 of 95. Though the suit was referable to the entire Asian property, but was ended in a compromise, contending that there was some properties are not at all available, which fact is now noticed by the plaintiff. That the leftover properties were entered into a partition deed dated 2005.
Fraud is alleged.
No fraud is alleged because his mother was a party. He
Page-
said that he was a minor.
Page 61, para 13.
Sorry, my lord, para
Para
13,
13, page 61, sir.
page 61.
Cause of action.
The cause of, the plaintiff submitted that the cause of action of suit originally arises in the 2012, but thereafter discovering so many fraudulent acts of defendant number 1 and 2. What is the fraudulent fact? Your lordship can say,
We'll see.
suit is ended in a compromise. If he has challenged that, he has to file an application before the same court at Rod 23 Rule 3A. Then your lordship can say.
Correct. Compromise challenge ಮಾಡ್ಬೇಕು, order 23 rules
Yes.
3 ಅಲ್ಲೇ, yes.
That was challenged, yeah. Then one more thing, my lord, 2005, a partition deed was entered into between all the parties. At that time, he was a minor. His mother was a party and she is acted on the partition deed. She sold the properties which are fell into her share also.
Yes, sir.
Kindly pass her. Monday.
Monday ಇಲ್ಲ, CRP Thursday ಮಾತ್ರ, next Thursday. At the request of the council appearing, heard the learned senior counsel Sadashiv Reddy appearing for the petitioner. List the learned counsel for the respondent seeks a week's time. List the matter on Thursday, the next. We
Tomorrow,
close
your
it.
lordship can see the pending for argument on IA number 1 there, 39 Rule 1 and 2. They have
ಒಂದು
filed
ವಾರ
plaintiff.
they will decide it on the next date. Next date ಏನಲ್ಲ?
ನಾಳೆ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅದು ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಇಂಜೆಕ್ಷನ್
ನಾಳೆ ಇದೆಯಾ?
ಮತ್ತೆ ಹೌದು ನಾಳೆ ಇದೆ.
The court shall defer its proceedings till the next date of hearing.
Please.
Yes.
38.
Small cause suit, my lord, this is, I have filed Article 16 Rule 1 and 2, wherein the IA has been allowed. Thereafter, the trial court has issued RPID and through court, and the summons has been served to the witness. Thereafter, he didn't turn up, the witness. Then we requested the trial court to issue bailable warrant to secure his presence, but the trial court refused to issue bailable warrant. Page number 18.
Article 16 rule was rejected.
ಇಲ್ಲ ಅಲೋ ಆಗಿದೆ.
Allow, correct.
ಅಲೋ ಆದ್ಮೇಲೆ ಸರ್ವ್ ಆಗಿದೆ. ಸರ್ವ್ ಆದ್ಮೇಲೂ ಅವ್ರಿಗೆ ಸೆಕ್ಯೂರ್ ಮಾಡಕ್ಕೆ ಕೊಟ್ಟೇ ಇಲ್ಲ.
ಇಲ್ಲಿ ನಾವು ಇಶ್ಯೂ
Rejected.
ಮಾಡ್ಬೇಕಾ ಈಗ?
ಹೌದು.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡೋಣ. Available warrant ಆಮೇಲೆ ನೋಡೋಣ. Yes. Emergent notice to the respondent returnable by the 20th.
ಅದು ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಸುಮ್ಮನೆ 11/6
Returnable by 20th.
11/6 ಹಾಕೊಂಡು ಸ್ಟಿಲ್ ದೆನ್ ಇಂಪ್ಯೂಡ್ ಆರ್ಡರ್ ಮೇ ಬಿ ಸ್ಟಿಲ್ ಆ 9/6
One minute.
ಟೈಮೇ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ 2/6 ಇಂದ 9/6
You are the defendant.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Now, who did not appear before the court?
ವಿಟ್ನೆಸ್ ಮೈ ಲಾರ್ಡ್.
Emergent notice to the respondent. Petitioner is at liberty to serve. The counsel who represents the respondent in the trial proceedings lists the matter on 19th. Till such time, the further proceedings before the concerned court shall remain stayed. Yes. Serve ಮಾಡ್ಬಿಡಿ ಇವತ್ತೆ. Take it on 12th.
ಮಾಡ್ತೀನಿ ಮೇಡಮ್.
12th, yes.
RBS ಆಫೀಸ್
ಬೇಡ.
ಅಲ್ಲ ಮಾಡ್ತೀನಿ.
By hand summons serve ಮಾಡಿ. ಅಲ್ಲ, sorry. The counsel serve ಮಾಡಿ. List on 12th, yes.
Order 39.
For the respondent, my lord. My lord, all these 5 connected petitions were disposed of by this honorable court. by
Time
giving a
limit fix
direction.
ಮಾಡಿ ಕಳ್ಸಿತ್ತಲ್ಲ?
Yes, my lord, 4 months was the time limit granted by this court, my lord. And the matter was listed before the court on 30th December. From that date till now, my lord, it was for defense evidence. From that date till now, they have not even adduced evidence, my lord. Over 15 dates of adjournments have been granted by the court. And every date the accused has sought time to lead his evidence, and in spite of it, the
This court.
has-
in terms of its order dated 5th November 2024, noticing the fact that 8 years had passed by as the issue was of the year 2017, directed the concerned court to conclude the proceedings within 4 months from the date of receipt of the copy of the order. Now comes a communication from the concerned court seeking extension of time to conclude the proceedings by another 6 months. The learned counsel appearing for the respondent would contend that indiscriminate adjournments have been granted to the petitioner who is not appearing before the court or cooperating with the proceedings. In that light, the concerned court shall endeavor to conclude the proceedings in an outer limit of 4 weeks from today. Any other communication that would ensue from the concerned court seeking further extension would be viewed seriously.
Yes.
My lord, steps have been taken this morning.
Learned counsel submits, needful has been done, office to verify.
Okay.
Yes, next.
41.
Two weeks time is 2015 now. Taking steps. 2 weeks time is granted to do the needful. Next.
42.
Jawai, previous, serial number 40. The council submits, needful has been done, office to verify. 41, 2 weeks time is granted to do the needful. Alindane alva? 14 da. Yes. Next.
42.
Two weeks time to do the needful. Next.
43.
Finally 2 weeks time is, ಅದು 15 ಗೂ ಅದೇ ಹಾಕಿ. Finally 2 weeks
Take
time is
steps in
granted.
office, my lordship, 43.
2019, sir.
Last time, they are already on record, my lordship. Notice have already been served.
The R1C ಎಲ್ಲ ಆಗಿದೆಯಾ?
Yes, my lordship. Since the 1B passed away,
Sir, ಆಗಿದೆ
again
madam?
reissue of notices were given.
Huh?
Furnishing of fees.
Huh? FPF ಅಂತ ಇದೆ. A week's time is granted to do the needful. 2 weeks time. Unclaimed ಆಗಿದೆಯಾ? ಕೊಡಿ. The steps taken pursuant to the orders of this court, the Shara indicates that the notices have been unclaimed by the unserved respondents as indicated in the cause list. In the light of the fact that they have not claimed, the registry to print the name of those unserved respondents and show them as served. List,
R1C and D only.
list the matter. R1C and D matrana. Insofar as R1C and D are concerned. R1E, R1F.
We'll take steps, fresh steps.
Insofar as R1E and R1F, 2 weeks time is granted to do the needful as a last chance. Next.
Please.
54.
Finally, 2 weeks time is granted to do the needful. In the event needful is not done, the petition will be dismissed for its non-prosecution. Next.
46.
Third time,
45.
45, yes.
R1 and R3, my lord.
R5 yaru?
45, I'm appearing for petitioner.
R5, not 45. Who's R5, sir?
We have done
Kodi
the
madam.
needful, you have taken steps on 10/6/2024.
ಇನ್ನೂ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
Notice ಆಗಿಲ್ವಾ?
ಇಲ್ಲ, it's not been served yet. Mahesh ಅಂತ is the
What's the matter?
matter, my lord. This is a suit for partition that was filed by the respondent number 1. They filed an application under order 7 rule 11, my lord, for rejection of plaint.
That is rejected.
That is rejected. The interesting question that emerges over here is this, my lord. They say that the stay has been granted in this matter on the ground that there is a proviso, section 6 of Inter-Succession Act. But insofar as Karnataka is concerned, the 1990 amendment, which came into force in 1994.
Hindu Succession Act.
Outside.
Huh?
Yes, my lord.
Which petition is this?
46, my lord.
45.
I'm at 45, sir.
My apologies, my lord.
Have taken steps.
ಇಲ್ಲಿ
to-
none of them are what you call ಅದಕ್ಕೆ Jama Masjid and the Hindu Succession Act.
We have taken steps to R5 on 10/6/2024. This court had already.
The
on
learned
last
counsel
day-
submits, steps have already been taken to serve the fifth respondent office to verify. Yes,
No.
next. ಈಗ ಬನ್ನಿ.
Yes,
46,
I'll take steps for R6, my lords.
R6 ಯಾರು?
he is the person who has, to the land was alienated
Hmm.
without, by the father, my lord, and the other brother. The suit for partition, my lord, is by the daughters.
Yeah, 4 years in, 5 years in stay idea.
2022.
3 years.
Two, my lord. And the stay is only on the ground of the proviso to section 6, my lord.
Correct, yes.
Whereas, my lord, in Karnataka, 1990 amendment, already, my lord, the unmarried daughters had rights, my lord, as co-parceners.
Let's see. Yes. Finally, a week's time is granted to do the needful. List the matter on 19th.
My lords,
My lord,
interim order is there.
Interim order subsisting will continue to the next date of hearing.
We directed to give us.
Finally, time is granted till the next, 1 week ಅಂತಾನೆ ಹೇಳಿರ್ಲಿ.
Yes.
We
19th.
directed, other documents ನಮ್ಗೆ ಯಾವ್ದು ಸರ್ ಮಾಡಿಲ್ಲ, just the bare
See,
CRP
ಇವ್ರ್ದಾರು?
ಮಾತ್ರ ನಮ್ಗೆ ಇರೋದು.
It has been served is what I've been informed.
ಇಲ್ಲ,
my
just
lords,
the bare
because-
CRP
Your
ನಮ್ಮ ಹತ್ರ ಇದೆ.
information may be incorrect. sir.
Yes, I'll serve it
Yes.
again. my lords.
Grateful.
Next.
57,
Okay, for the respond number 1, please.
It's
R2 ಯಾರು?
we seek dispensation, we're finding
Memo.
Memo will be filed.
His presence is required, please, my lord. For this reason,
At his risk is doing it, leave it.
my lord, petitioner herein and the respond number 2 herein. So both have entered into a compromise in a suit, and that compromise is under challenge in the present suit, please, my lord. And in a revenue proceedings, my lord, this respond number 2 has been represented by these petitioners as a GP holder. So in one proceedings, they represent altogether, and in another proceedings, they will take, they show that they are contesting.
That is at their own peril. Why are you worried?
I'm on a very limited point, my lord.
Not in this stage. I will post it on 12th. Order 7 rule 11,
Yes,
That has been rejected.
that is rejected.
yes.
Before 2 weeks' time, I will file detailed objection, or some developments have taken place before the revenue.
What developments?
Flood,
Heard the learned counsel KBS Manian appearing for the petitioner and so and so. The learned counsel for the respondent seeks 2 weeks' time to file statement of objections. Finally, 2 weeks' time is granted. List the matter on 19th. In the event no objections are filed on by the said date, the matter would be heard. The submissions of the counsel for the petitioner would be heard.
Grateful.
Yes, next.
48,
For the petitioner, your lordship, this CRP is not maintainable, your lordship. Actually, Not the, maintainable, ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? yes, because ಯಾಕೆ? by mistake, it has been By filed. mistake, Yes, objections ಇದೆಯಾ? order 7 rule 11 petition has been allowed, your lordship. So RFI is maintainable. Yes. I may be request to The convert learned this matter. counsel for the petitioner seeks leave of this court to withdraw the petition and file an appropriate petition before the appropriate jurisdiction. Yes. Submission is placed on record, disposed as withdrawn, reserving such liberty. Next.
49,
The office objection to produce the death certificate, JDR, we don't, he has not produced before the trial court also. We are unable to produce death certificate to JDR, office objection be overruled.
Death certificate ಕೊಡದೆ overruling ಮಾಡೋದು?
ಅಲ್ಲ, ಎಲ್ಲಾರು was brought on record by the trial court ಅಲ್ಲಿ ಆಗಿದೆ.
ಅವ್ರನ್ನ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
ಹಾ? ನಿಮಗೆ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ನಾವು ಇದು ಮಾಡಕ್ಕಾಗತ್ತಾ?
Death certificate, you don't have the JDR.
ಇದಾರಲ್ಲ already ಎಲ್ಲ? Yes, so on. The legal representatives of the deceased judgment debtors are already on record. In that light, the office objection stands overruled. Emergent notice to the respondents returnable by the 3rd of July. Yes. next.
Connected to 66 to 75 matters are there.
Same, huh?
Connected, same.
66 to 75 ಗೆ same order Jawad. Yes. Next.
50,
May I please, Your Lordship? I appear for the petitioners.
Responding B. Lord, on the
I
last
appear for
day of
respondent number 7 in this case.
25/4/2025. There, my lord, the chief engineer was directed to authorize a competent engineer to go survey and submit a report.
That has not been done?
My
The
lord,
government has to-
my lord.
You are appearing to the BDA?
No, my I'm lord, it's for representing the BDA, there for the government.
Who was directed?
The government.
State was directed.
Yes, what has happened?
My lord, I'll produce it on Tuesday, my lords. It is ready. Today I'll secure it.
It is ready.
Please, my lords.
Which order is that?
25/4.
25/4/25.
Yes. Detailed order.
Coordinate bench of this court on 25/4/2025 had passed a detailed order while directing the state to conduct a survey and file a report by the next date of hearing. The date of inspection was also indicated by the bench. The learned counsel representing the state submits that the inspection is conducted and a report is ready, which would be placed before this court on the next date of hearing. List the matter on Tuesday in preliminary hearing.
Please.
Great, my lord.
Intermodal, yeah,
No, no, my
They
lord.
had, there is an undertaking, my lord, that they'll construct, but they'll not need equities.
Tuesday. Yes.
No,
Don't construct on Sunday. There is a order that construction can go on way back in 2000. It's all right. I'm not passing any order.
I appear for the petitioner on this matter. My lords, on this matter, I have filed, my lords, by special orders, it's come here, my lords, because
Oh.
51.
Yes, madam.
I have filed IA number 1 of 25 to bring the LRs of R4. That IA has been served, he is not represented. Your lordships may allow that IA. I'll carry out the
Which one,
amendment.
madam? This IA 1 of 25.
Please, my lords. He served, he is not represented.
All right. The learned counsel, Nayantara BG submits that notice on IA 1 of 2025 has already been served upon the legal representatives of the deceased fourth respondent and have not entered appearance. In the light of service of notice upon them, the registry to print the names of the legal representatives of the deceased
My lords,
are
it's already printed, only one
already
LR.
there. Matten
Yes.
bek, madam.
Your lordship may allow that IA
There-
formally, I'll
Therefore,
bring
for the
them on.
reasons indicated so and so, the application IA 1 of 2025 stands allowed.
Please, my lords.
Next.
My lords, your lordships may also hear me on the merits of the matter, my lords.
Merits Ivatta,
Please, my lord, any day convenient to the court, I'm ready today also.
next Thursday?
Very well.
Yes.
Please,
List
my
the
lord.
matter on the Thursday,
Interim
the
order may
next.
kindly be extended.
Madam,
Interim order may kindly be
that makes sense, yes. List the matter on Thursday, the next interlocutor matter, let it come in preliminary hearing.
Very good.
And preliminary hearing, interim order subsisting would continue till the next date of hearing, yes.
T2.
For respondent in this matter, my lord, respondent 2 in this matter, I have filed my status report on
R3 to
16.
R9.
ಅದು await ಅಂತಿದೆ, but
And for
information is they are
immediately-
served already.
Sir, they are served.
Served ಅಂತ.
ನೋಡಿ. Dispense with ಆಗಿದೆ?
ಇಲ್ಲ ಇಲ್ಲ, ಆಮೇಲೆ ತಿರ್ಗಾ ಫ್ರೆಶ್ ನೋಟಿಸ್ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಮಾಡಿದ್ರು.
Fresh notice ಆಗಿದೆಯಾ? Post immediately after service of notice
ಸರ್ವಿಸ್
upon
ಆಗಿದೆ.
respondents 3 to 9.
ಆಗಿದೆ.
Interim order ಇದೆಯಾ?
ಇಂಟರ್ ಮಾಡ್ರಿ. ಸೊ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಆರ್ ಥರ್ಸ್ಡೇ.
Thursday. This next Thursday.
ಸರ್ವ್ ಆಗಿದೆ. ಆಫೀಸ್ ಟು ವೆರಿಫೈ ಅಂಡ್ ಪುಟ್ ಅಪ್ ಅಂತ.
ಅಲ್ಲ ಅದು ಕೊಡ್ತಾರೆ. That will come, need not worry, yes.
T3.
ಯಾಕೆ ಇಲ್ಲಿ ಬಂತು? ಏನ್ ಮಾಡಿಫಿಕೇಶನ್ ಮೇಡಮ್? ನೀವು ಹಾಕಿಲ್ವಾ?
For the respondent, Your Honor.
ಬ್ಯಾಂಕಾ?
ಹೌದು.
As against 34 lakhs, more than 20 lakhs.
Already been deposited. Let them file one undertaking. Outstanding.
ರೆಗ್ಯುಲರೈಸೇಷನ್ ಕೇಳ್ತಾ ಇದೆ ಸುಮ್ಮನೆ 20 ಲಕ್ಷ ಕಟ್ಟಿದ ನಂತರ ಇನ್ನೊಂದು
ಅಫಿಡವಿಟ್ ಹಾಕಿ ಹೇಳ್ತೀನಿ.
ಪ್ಲೀಸ್ ಮೇಡಮ್
ಕ್ಲಿಯರೆನ್ಸ್ ಆಫ್ ಲೋನ್ಗ ರೆಗ್ಯುಲರೈಸೇಷನ್
ಕ್ಲಿಯರೆನ್ಸ್ ಆಗುದಿಲ್ಲ sir. ತುಂಬಾ ಕಷ್ಟ ಆಗುತ್ತೆ. ಹೌಸಿಂಗ್ ಲೋನ್
ಎಷ್ಟಿದೆ?
ಹೌಸಿಂಗ್ ಲೋನ್ 35 ಲಕ್ಷದಲ್ಲಿ 20 ಲಕ್ಷ ಕಟ್ಟಿದ್ದೇವೆ. ಇನ್ನೊಂದು 15 ಲಕ್ಷ ಅದನ್ನು ಟರ್ಮ್
NPA ಆಗಿರೋದು ಯಾವಾಗ?
23 ಅಲ್ಲಿ 20 ವರ್ಷ ಟರ್ಮ್.
ಇದು ARCS
20 ವರ್ಷ ಟೈಮ್ ಇದೆಯಾ?
20 ವರ್ಷದಲ್ಲಿ ಇನ್ನೊಂದು 15 ವರ್ಷ ಇದೆ ಸರ್.
ಆಲ್ರೆಡಿ
ಈಗಲೇ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ರೆ ಹೆಂಗೆ ನೀವು 35 ಲಕ್ಷ ಅವರು ಕಟ್ಬೇಕಲ್ಲ?
ನಾನು ಅವ್ರು ಎಷ್ಟು ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಡ್ಯೂಸ್ ವಿಚ್ ಇನ್ ಹೌ ಮೆನಿ ಮಂತ್ಸ್ ಅವ್ರು ಕ್ಲಿಯರ್ ಮಾಡ್ತಾರಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿ
15 years. Yes.
Please, I'll file my affidavit.
File your affidavit, madam.
1 week.
Yes, next Thursday. The petitioner shall file an affidavit of regularization of the loan account. Affidavit of making good the amount for the purpose of regularization of the loan amount, if any. The respondent bank shall also consider the same by securing necessary instructions and making submissions on the next date.
Great.
We'll take it on 19th.
Please.
Or ಕೊಟ್ಬಿಡಿ ಮುಂಚೆನೆ affidavit. Yes.
Please.
Yes.
My lord, could the.
47 rule 11.
Yes. My lord, it could be if my lord permits, we could.
Interlocate
Go on the
claim.
main matter, my lord. Any date, my lord, it's convenient.
Who is the
I am the plaintiff, madam.
impleading application? I'm the subsequent purchaser Huh. from the petitioner before your lord. What's the suit for?
Suit is for partition.
By the respondent. They impleaded me in the plaint. Oh, you're already on record there.
Yes.
Now I'm on record, consequently, my lords, I've appeared.
This application
come on record.
may have to be allowed, my lord.
We'll allow, because you're already a party there.
Yes.
IA 1 of 2020, we'll allow that, Ajay.
Yes, my lord.
Yes. For the reasons indicated in the affidavit accompanying the, IA 1 of 24. For the reasons indicated in the affidavit accompanying the application, and being satisfied with the same, so and so stands allowed. The learned counsel Aditya Narayan appearing for the impleading applicant submits that the impleading applicant was already a party in the before the concerned court. Alli implead madidra?
Yes.
The impleading applicant was impleaded as a party before the concerned court by the plaintiff themselves. In that light, and for the reason so and so, allowed, the petitioner is directed to amend the cost title and file an amended cost title. What's the matter about now? Our
Order
7 rule 11.
Any date, my lord.
Well, next Thursday, my lord.
2015.
So we have argued many times, my lord. So the records have
Argued
been,
many times.
Oh, no, we did.
for some reason, it was urgent.
All right. On what ground is it rejected?
My lord, it is on the ground of limitation, saying it's a triable issue.
Correct.
My lord, I purchased the property in 1960s. They filed the suit in
1960.
2011.
51 years after.
Yes, yes. I'll make out my case, my lord.
Next
You are the
Thursday,
plaintiff.
Thursday, my lord.
You are the plaintiff.
Yes.
I am the plaintiff.
51 ವರ್ಷ.
They claim that they have purchased it from my father. But
Correct.
we deny that, my lord, such a document was executed by the father.
ಇದು pure question of fact and law ಅಲ್ಲ.
Yes.
There is no mix here. 51 ವರ್ಷ.
And they don't seek for declaration of my sale deed, only partition. So they try to overcome the aspect of limitation under 58. They try to come under 109, which also would be.
All right, we'll fix it.
Yes, grateful.
We'll take it on, because it's 2015.
Yes.
We'll take it on 12th.
Great.
List the matter on 12th. The understanding is the matter would be heard and
Please.
matter would be considered finally. Yes.
55.
My lord, it will be in the preliminary hearing.
In preliminary hearing ಅಂತ ಹಾಕಿ.
Great.
Let these 10-year matters go away first.
Yes, my lord.
ಎಲ್ಲಿ ನಾಗರಾಜ್ ಇದ್ರಲ್ಲ ಇಲ್ಲೇ ಡಿ ನಾಗರಾಜ್ 28 days in filing the petition. ಏನು ಇದರಲ್ಲಿ ಡಿಲೇ ಏನು? Order 7 rule 11 rejected. ಇಲ್ಲ. Waqf tribunal. Naveed, you are there Waqf tribunal ga?
Yes, Lord.
Waqf ga?
Lord.
55 ಅಲ್ಲ 56 ಅಲ್ಲ 55.
I'm sorry.
Yes. No representation on behalf of the petitioner. Notice on IA 1 of 20. 2020 notice ಆಗಿಲ್ಲ. Yes, next. Yes, Navid.
56.
Look, this
378 days delay.
they have filed after lots 1 year. And the lots suit is at the verge of conclusion lots. Cross examination is going on lots.
Order 7 rule 11 rejected.
Yes, lots.
First time ಬರ್ತಾ ಇರೋದಾ?
ಇಲ್ಲ ಬಂದಿದೆ.
ಎಲ್ಲಿ ಬಂದಿದೆ? No representation on behalf of the petitioner. List after 4 weeks. I shall conclude ಆಗಿರೋದು.
Oblate lots.
Yes. Registry is directed not to list the matter prior to the expiry of 4 weeks. Next.
57.
I'm for the petitioner, my lord, work tribunal order. The first petitioner is died. And within 90 days, we filed the application to bring his LR.
Allowed for the reasons, JV. Allowed petitioner to amend the cause title. Yes.
58.
Petition.
There
is rejection of 7 rule 11.
134 days delay. Notice.
All the 3 matters.
ಮೂರು ಅದೇನಾ? All 3, 58, 59, 60. Notice.
61.
Same notice. 62 notice.
63.
Notice.
64.
Appear for the petition in this
Yes,
matter.
sir.
Respondent. The petitioner happens to be defendant number 7 and 8. Files an application in order 7 rule 11. Comes to be dismissed. Lordship may kindly see the entire case of the plaintiff, that is the respondent, is that he has derived right over the property by virtue of a will. That will, my lord, can be kindly be seen at page 31 at annexure B, my lord.
Will, two things, date of the will and the date on it on which it comes into existence.
Yeah, date of the will, my lord, is, it has been executed on 9/5/2014, my lord. And immediately after that, the executant, my lord, dies.
That's what, when did it come into force?
It has come into force in the year 2014 itself.
All right.
Your lordship may kindly.
Who is the plaintiff?
The plaintiff claims that he is the beneficiary of the will. Now, your lordship may kindly come to annexure B, my lord, at page 33, my lord.
Yes.
Lord, para number 5, I may be permitted to read. After her death, both the movable and immovable property, including bank balance, if any, in both savings account and fixed deposit, will go to my cousin brother K. Nagabhushan, so and so, who happens to be the respondent here in Malad.
You are Nagabhushan.
Yes. Subject to the following conditions if he fulfills. Now, the conditions are mentioned at page 35, my lord. Page 35, 36, and 30 up to 38, my lord. Now, your lordship may kindly come to page 38, para number 7.
The above statements.
The above settlements to be done by K. Nagabhushan within 24 months after demise of so and so. Thereafter, he can claim the ownership of the scheduled property. In case of settlement after 24 months, K. Nagabhushan should compensate with the bank interest at the rate of savings bank account. My lord, none of the conditions have been fulfilled. An earlier suit came to be filed, a suit for permanent injunction.
Which is that?
My lord, that is at
874 of 16.
874 of 2000. Please, my lord. There are certain, my lord, observations made in that suit. And that came to be, my lord, challenged in a regular first appeal.
What happened to that?
That they withdrew, my lord. They withdrew on the ground that they are going to file a comprehensive suit for declaration. Now, your lordship may kindly come to, my lord, page 103, my lord. This is the plaint in the present suit. 103, my lord. Your lordship may kindly see the relief A, declaring that the plaintiff is the absolute owner of the Schedule A property in terms of the registered will dated so and so, registered in the office of the, and direct the defendant number 4 to 8 to deliver possession of the suit Schedule A property in favor of the plaintiff. And your lordship may kindly come to page 104, relief H, my lord.
He says, pass a decree permitting the plaintiff to fulfill the conditions imposed on the plaintiff in the registered will. My lord, he asked for, let him, I need to perform those conditions, pass a decree in my favor.
So you need to perform the conditions.
Yes.
No decree need to be.
Yeah,
passed
no
for that
decree
purpose.
needs to be passed, my lord.
Lord, what had
Mother,
If you
happened?
want the benefit of the will, those conditions.
Yes.
They sold it. That is the problem.
Oh, who has sold it?
Mother and daughters.
My lord, mother and daughter
My
have
lord,
sold
one
based on
submission, my
the.
lord, one submission. Varalakshmi had executed, bequeathed the property in favor of the plaintiff
ಆಯ್ತು.
by giving some conditions that
Yes.
I should pay each 35 lakhs and the life interest has been given to Mother Venkamma and each 5 lakhs to Ramakrishna Ashrama and Theosophical Society. Thereafter, Venkamma in collusion with the daughters, they sold in favor of one
When was that sale?
before filing suit, my lord.
And there was no interim orders, my lord.
My
And
lord.
there was an observation made in the earlier.
Immediate, I filed suit, my lord. I filed suit restraining Venkamma from selling the property.
Which is the sale deed dated 6/8/2020.
I have produced it, madam.
Which is that sale deed, sir? ಯಾವಾಗ ಆಗಿದ್ದು?
ಅದು 2020,
ಅದು ಗೊತ್ತು ಯಾವಾಗ, that is prior, what date is the suit? 2021 na?
ಹೌದು
21.
21.
So they have
Before.
sold it in 2020.
20. Then, my lord, I preferred RFA. Again, I have filed injunction suit. My suit has been dismissed, saying that it is a premature. Venkamma is alive. I can't maintain suit for any relief against Venkamma. Thereafter, Venkamma died. I preferred RFA in the before this court, and this court has given liberty to me to file comprehensive suit after the death of Venkamma and fresh cause of action, for which they have said no objection in the
Where is that
RFA.
order in RFA?
RFA is at page number 90 of my objection, along with my statement of objection. I have filed statement of objection.
ಹಾಕಿದ್ದೀರಾ?
Hakid.
90.
90.
And I have also filed at page 76, my lord. Your lordship may kindly
ಇದೆಯಾ?
see. Yeah. Page 76, para 4, I have raised a clear objection.
One
my lord.
moment.
Yes. Seventy-six, para 4, my lord.
Yes.
At this juncture, learned counsel appearing for respondent should submit to this court that the appellant cannot maintain a fresh comprehensive suit on the same cause of action. If there is a fresh cause of action, if the law permits, it is open for him to take recourse to the remedy that is available to him. My lord,
That is your submission.
submission, my lord. I did not give any consent to it. My lord, that besides that, my lord, the rights of the petitioner, that is respondent herein, has not been crystallized at all. My lord, he has not even taken a single step
No, that's all right.
to perform those conditions.
Even before the rights getting crystallized, you have done something that will take away his right. First thing, right getting crystallized has no limitation in that.
No,
24 months
true.
ಮಾತ್ರ ಇರೋದಲ್ಲ?
ಇಲ್ಲ, even in the earlier suit, there are certain observations. Your lordship may kindly come to.
Which is that earlier suit?
The earlier suit 874 of 2016, madam.
What
May
observations?
kindly come to page 63, para 30, my lord. Which injunction suit came to be dismissed. Para 30, my lord.
Yes, you file a list of dates and events.
I will do that. I will do that.
We'll take it on. He appears to have a right
Alla,
to demonstrate that.
my lord, conditions he has never taken a step to, in fact.
No, never taken a step. The conditions were not time bound.
It's mentioned there. my lord.
24 months.
Yes, yes.
During
You
lifetime.
have sold the property after 24 months.
Sold the property after 24 months. My lord, that is, my lord, even now on instructions, my lord, let him perform those conditions. My lord, if he is ready to perform, let him state before the court. I will, my lord.
They're ready, my lord. If they are ready to file affidavit saying that they will relinquish property in favor of.
Allala, affidavit alla. Let him first file.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರೆ ಈಗ ಮಾರ್ಬಿಟ್ಟು 5 ಕೋಟಿ
ಒಂದ್ ನಿಮಿಷ.
they have taken sale consideration of 5 crores.
ಆಯ್ತು, ಈಗ conditions
ನಾವು ರೆಡಿ ಇದ್ದೇವೆ ಸರ್.
ಆಯ್ತಾ?
Already.
Now what property is not there?
Alla, property I am
Mane-
holding.
yeah.
I'm in
Mane
possession of
house
the property. I'm in possession.
Now, if you see these conditions at page 38,
Yes, sir.
what all you have to do,
Ready.
if you do it now,
Yes,
we will pass some order.
yes.
Yes.
ನಾವು ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ. ಒಂದು 6 months ಆದ್ರೂ ಟೈಮ್ ಬೇಕು.
ಆಯ್ತು,
ಬಿಕಾಸ್
ಅಲ್ಲ.
ಎಲ್ರಿಗೂ 35 ಲಕ್ಷ ಕೊಡ್ಬೇಕು, ರಾಮಕೃಷ್ಣ ಆಶ್ರಮಕ್ಕೆ ಕೊಡ್ಬೇಕು, ಥಿಯೋಸಾಫಿಕಲ್ ಸೊಸೈಟಿ ಕೊಡ್ಬೇಕು, ಡಿಸೀಸ್ಡ್ ಫ್ರೆಂಡ್ಗೆ ಒಂದು ಮನೆ ಮಾಡ್ಕೊಡ್ಬೇಕು, ಅವ್ರಿಗೊಂದು 10 ಲಕ್ಷ ಕೊಡ್ಬೇಕು.
ಕೊಡ್ಬೇಕು ಇಲ್ಲ
ಅಲ್ಲ
ಬಿಡ್ಬೇಕು.
ಅದಕ್ಕೆ ಟೈಮ್ ಬೇಕು. 6 months ಟೈಮ್ ಕೊಟ್ಟು
ಆಯ್ತು.
Ready, next time, my lord, let the suit be stayed because the suit is going on. Dates are, my lord, not.
I will see.
Yes,
Yes,
Yes.
pass an order.
Matter. Yes. On date may be fixed, I'll discuss.
Yes. The petitioners are defendants 7 and 8, are at the doors of this court calling in question an order of the concerned court dated 19/12/2024, which rejects the application filed by the petitioner, filed by the petitioners under Order 7, Rule 11, seeking rejection of the plaint. The issue in the list dates back to a will executed by one Varalakshmi. The will bequeathed certain properties in favor of the plaintiff in OS 1747 of 2022. The conditions imposed were to be complied within 24 months, and after the conditions would be complied, the benefit of the will would flow to the hands of the plaintiff. The petitioner, earlier suit another?
Suit for injunction, bare injunction.
A suit for injunction was preferred by the Nimmala,
By the respondent.
by the
Respondent.
plaintiff, by the present respondent,
Yes.
which comes to be dismissed. The dismissal of the suit was called in question in RFA 764 of 2020. The coordinate bench of this court, after hearing both the parties herein, permits filing of a comprehensive suit if law would permit. The appellant, the respondent, was permitted to withdraw the suit in OS 874 of 2016. It is therefore exercising that liberty the plaintiff has now preferred OS 1747 of 2022. In the said proceeding comes the application filed by the defendants 7 and 8 under Order 7, Rule 11, seeking rejection of the plaint on the score that none of the conditions stipulated in the will have been performed by the plaintiff for him to claim to become the beneficiary of the properties described in the will. The learned counsel for the petitioner submits that the time limit fixed in the will was 24 months for settlement of all the conditions.
But within 5 months, they have created gift deed and registry. Sorry, ma'am.
ಏನ್ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ ಆರ್ಡರ್ ಅಷ್ಟೇ 24 months. The learned counsel for the plaintiff would now submit that even before the expiry of 24 months or his rights getting crystallized, the defendants 7 and 8 had already executed a gift deed in whose favor?
Gift deed in favor of daughters, that is.
Gift deed in favor of the daughters only to frustrate the right of the plaintiff in terms of the will.
Daughters in turn executed sale deed.
So and so. He would further add that the daughters have in turn executed sale deeds to third parties, and there is sale deed to third parties. Be those submissions as they are, both the learned counsel for the plaintiff and the defendant 7 and 8, the petitioner and the respondent herein, would submit that if the conditions even today are fulfilled by the plaintiff, there could be a settlement between the parties. The learned counsel for the respondent submits that the settlement is too onerous to be fulfilled in 2 weeks or 4 weeks. He would need at least 6 months' time. Therefore, by the next date of hearing, the respondent plaintiff shall file an affidavit before this court with regard to the timeline in which he would conclude the conditions stipulated in the will. And if they are acceptable to the petitioner's defendant 7 and 8, the matter could be closed, failing which the matter would be considered on its merit. Till such time, further proceed in the light of the aforesaid reasons, until such time, the further proceedings before the concerned court shall remain stayed.
Highly obliged.
Any date?
Highly obliged.
2 weeks, 3rd July ಹಾಕ್ತೀನಿ ಅಷ್ಟರಲ್ಲಿ ಹಾಕಿ.
Yes.
I appear for the respondent number 1.
227 delay. Nope. No objection?
Delay may be condoned.
The- For the reasons indicated so and so, as also the fact that the respondent has no objection to condone the delay of 227 days, delay stands condoned.
Lords, matters coming up on 16th, I've sought for stay, my lords. For the
ಇನ್ನು
trial.
ಕೇಸ್ ಏನು ಅಂತಾನೆ ಹೇಳಿ.
Lords, Lords, there is a suit. Petitioner number 1, petitioner and the respondent are brothers, my lords. Respondent number 2 files a suit for partition bearing OS number 30 of 2020, 39 of 2020. During the pendency of that suit, there is a compromise, my lords. That compromise is produced at page number 39, annexure B.
What is the suit for now?
The suit, lords, I'll come to that, my lords. The suit is for specific performance, my lords. Between these two brothers, there is a settlement and a partition, a registered partition deed is entered at page number 39 and produce that document. Now, in that partition deed, the present scheduled property goes to the share of the respondent number 2. Therefore, as on the date of filing the present petition by the respondent number 1, the petitioner is no longer the owner of the property. He has no title itself, my lords. Therefore, when the suit is filed, the petitioner files an IA under 7 Rule 11 stating there is no cause of action because I don't have title to the property. This comes to be dismissed, my lord. Therefore, without having title, I cannot convey the property. He has to proceed against respondent number 2, who is my brother.
It is the case of the petitioner herein, my lord, that on the date of the agreement, I am the owner of the property, but on the date when I filed the suit, he is no more a owner of the property, so my suit is not maintainable. My lords may kindly see the application. The application filed under order 7 Rule 11. My lords, absolutely the application does not disclose under which specific clause of order 7 Rule 11, my lord, the plaint needs to be rejected. And even, my lords, the affidavit filed along with the application, my lords, is absolutely bald and, my lords, which clearly fails to make out.
If provision of law is correctly not noticed, then
No, my lords.
tenor of the application, the court will consider.
I agree, my lord. I agree. But at least, my lord, affidavit should make out a reason as to why, what exactly is the reason to throw the plaint away. Absolutely, my lords, even the affidavit fails to make out any of the grounds.
Where is the plaint?
Plaint, my lords, is at
Page 34, man.
That is
34.
OS 53 of 23.
Please, my lords.
Yes, ma'am.
Cause of action is at page number 36, my lords, para 7.
ಈ ದಾವೆ ವ್ಯಾಜ್ಯ ಕಾರಣವು ಸನ್ನಿಧಿ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಮಧ್ಯೆ ಸತ್ತು ಭಾಗದ ಹಕ್ಕನ್ನು
My lords, appearing for the respondent number 2, my lords, in this matter, serial number 65, my lords.
Yes.
My lords, in this matter, there is one more connected matter, my lords, which is not listed today.
That is the writ petition. That is with regard to the other application, my lords.
It is with respect to the same order itself.
It's a matter of evidence. Your ground is a matter of evidence.
Please, my lords. And
But
my
I'm
lords,
relying on the
Rightly
judgment.
rejected. Anyway, we'll hear. Which is that other petition?
My lords,
Not
WP
an
number 29976 of 24.
Tag this petition along with WP number
29976 of 24, my lords.
List them both on 19th. Put it.
Lords, para 35, my lords, as on the date of filing of the suit, I did not have the title itself. So
Yes,
therefore, they
yes,
cannot.
yes.
Lords, the matter
But
is
my
on
lord-
16th,
Oh, no.
then it may be.
Yes.
my lord, the agreement counters even this situation also.
List the matter on 19th. Yes.
Obliged.
Tag the petition along so and so. List the matter on 19th. Next.
Deeply obliged, my lords.
70 adjourned, 71.
My lords, kindly pass over, my lords.
RP.
ಇದರಲ್ಲಿ
Appearing for petitioner, my lords, kindly pass over, my lords.
ನಿಮಿಷ ಯಾಕೆ ರಿವ್ಯೂ ಏನು?
ಅದು ಕಸ್ಟಡಿ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್
ಚೈಲ್ಡ್ ಕಸ್ಟಡಿಯಾ?
ಗೋಲ್ಡ್ ಕಸ್ಟಡಿ
ಗೋಲ್ಡ್ ಕಸ್ಟಡಿ.
ಆ ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ದೇ ಸೀಮ್ಸ್ ಟು ಬಿ ದಿ ವರ್ಕರ್ ಇನ್ ದಟ್ ಶಾಪ್ ವಿಚ್ ದೇ ಆರ್ ರನ್ನಿಂಗ್.
ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್.
ಅಲ್ಲ petitioner is running jewelry shop. They sees that after 10 years they came to know that the worker has done a theft. That they have ಅಂತ ಹೇಳ್ತಾರೆ. After taking all the things necessary ಎಲ್ಲ ಆದ್ಮೇಲೆ.
What is review in this?
Review is only in respect of the custody.
My lords, kindly pass over. My senior will address the
ಪಾಸ್ ಓವರ್ ಬರಲಿ, ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
please.
I can't again rehear the matter in review. Yes. Delay ಇದೆ?
Delay 144 days.
Objection ಹಾಕ್ಬೇಕಾ?
ಹಾಕ್ತೀನಿ ಸರ್.
ಸರಿ ಬಿಡಿ ಹಾಕಿ. List on 12th.
Actually, Manoj, there is another matter which can be connected with the
So
same.
what do you,
Please.
tag the petition along with so and so, list on 12th. At
Please.
the request of case Venkatramana, who seeks time to file objections to the application seeking condonation of delay. Yes, in IA 1 of 2020. Next,
72,
I'm for the respondent, 2 and 3.
so agla ಆಗಿದೆಯಾ ಇದು? This court on 3/6/2025 had observed as follows. Noticing the fact that the petition counsel for the petitioner or has been continuously absent, the court had, the matter was posted today and was indicated in the event that there would be no representation, the matter would be dismissed. There is no representation on behalf of the petitioner even today, as has been throughout. Therefore, the petition is dismissed. For example. Next. The petitioner ಈಗ?
Respondent.
That's correct.
73,
A number 1 is for production of additional documents.
ಏನ್ ಅಯ್ಯ ಇದು?
As for production of additional documents before the court.
Heard with the main matter.
May kindly note, there is, day before yesterday, I made a submission to this honorable court. There is some urgency because challenges with respect to final notification. And we have submitted a proposal before the SHLCC and which has been approved. And we are the owners of the land. And subsequently, land has been notified for the purpose of the KIDB. And that is under challenge before this honorable court. And
No. First you
they
tell
have-
me, you were, how did you come in possession of the land?
note, this property belonged to one of the directors of the company.
Which
who
company?
gave- Note, this is the petitioner company.
Ready?
In vacuum.
Yes, my lord, I already filed the objections also.
ಹಾಗಾದ್ರೆ ರೆಡಿ ಇದ್ದೀರಾ ಅಂತ.
Yes, position also, my lord, position also taken, my lord.
When?
2023 itself, we have taken the
Award itself
position.
is not been
And my
passed.
lord, compensation also, notice was sent to them for paying the compensation at 29/2. My lord, award, because they are not willing, my lord, the award is ready, my lord. Within a week, my lord, we will pass the award also.
Payment of compensation does not arise at all because unless award has been passed, the question of payment of compensation.
Award ಆಗಿದೆ ಅಂತಾರಲ್ಲ.
The award agilla, it is pending because we have filed the writ petition.
It is
That's what
sent
exactly
for
they
the
are saying.
approval, my lord, award sent for the approval. 29/2, my lord, award was decided, my lord.
May kindly
They are
see,
willing, my lord, we'll pay the amount under 29/2.
award agilla, award notice, award
We'll
agilla. It's not
we'll
been
hear it on
passed.
Monday.
May kindly, but not till them, let them not proceed with the development over there on the land.
What developments?
They are performed the road over there, I produced additional documents.
ಸಂಡೇ ಡೆವಲಪ್ಮೆಂಟ್ ಮುಗಿಸ್ಬಿಡ್ತಾರ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಏನೋ ದಿನಕ್ಕೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
2 ವರ್ಷದಿಂದ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ಲ?
2 ವರ್ಷದಿಂದ ಡೆವಲಪ್ಮೆಂಟ್ ಆಗ್ತಿರೋದು ಈಗ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ನೋಡಿ.
List the matter on Tuesday at 3:30 PM.
May kindly.
It is made clear the matter would be heard in said date. 2016, yes. Let me also go through it and come.
May kindly.
Next.
74,
Extension of parole.
60 days was granted, my lord.
ಏನ್ 302 ನಾ? Folksona 302 ನಾ? ಯಾರಿದ್ ಬಸವರಾಜ್ ಡಿ? There is no representation by of the petitioner throughout the proceedings. And an extension of parole is granted, is sought for. List the matter after 4 weeks.
He has already returned.
Let him be there only, yes.
75,
Preparing for the petition, my lord, I filed the application for amendment of prayer, my lord, to Amendment allot of the trial la? prayer, Ah. prayer, to allot the alternative site, my lords.
Amendment application in IA 1 of 2025 will be considered along with the main matter. Notice ಆಗಿಲ್ವಾ ಇನ್ನು?
Notice ಆಗಿದೆ sir.
ಆಗಿದೆಯಾ?
ಆಯ್ತು.
No, ಯಾರು ಇಲ್ಲ
ಕಾಪಿನ
ಬಿಡಿ.
ಸರ್ವ್ ಮಾಡಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ.
ಆಯ್ತು. List the matter on 19th. Yes, 19th, 17th.
76,
APF for the petitioner. Matter was listed yesterday. My lord, it's in a suit for injunction. An application filed, IA number 2, is for seeking ex parte injunction. That was rejected. Suit summons, notice is ordered and the application.
1 and 2 is not granted.
Not granted, straight away rejected. straight away rejected. Would your lordship kindly?
Rejected even before appearance.
Yes.
Why, sir?
My lord, my learned friend yesterday made a submission that it is by a mistake. If it is by a mistake, let it be heard.
Here ಮಾಡ್ಲಿ.
Let it be heard.
ಅದು ಹಂಗೇನೆ ಆಗಿರೋದು ಆಫೀಸ್ನವ್ರು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದಾರಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಆಯ್ತು.
3 applications have been filed. One is my lord section 82 dispensation to the government.
Correct, notice, statutory authorities.
Before my lord registering the OAS, FR ಅಲ್ಲಿ IA number 1 ಅಂತ ಮಾಡಿದ್ದಾರೆ, but ಅದು ಮಿಸ್ ಆಗ್ಬಿಟ್ಟು 1, 2, 3 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್ಸ್. Instead of my lord mentioning
ಆಯ್ತು, ಈಗ ಇಬ್ಬರನ್ನು ಹಿಯರ್ ಮಾಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತೀನಿ.
That's all.
We'll do that.
ಅಷ್ಟೇ, ಅಷ್ಟೇ.
The petitioner is before this court calling in question an order dated. ಎಲ್ಲಿದೆ order?
Order, page 30.
One minute.
Page 30.
Order dated 4/4/2025, which rejects the application of the petition IA2 of 2025 filed under order 39 rule 1 seeking temporary injunction. The petitioner is the plaintiff. Files OS 239 of 2025 along with an application under order 39 rule 1 seeking
1 and 2
temporary injunction. Along with it had preferred several other applications.
Please.
Under section 82 or 80 within bracket 2 of the CPC
and 39 rule 3.
and 39 rule 3. All the 3 applications appear to have been taken together and rejected.
No. IA number 1 was allowed.
IA number 1 ಯಾವದಕ್ಕೆ?
80/2.
Section 80.
Section 80/2.
IA number 1 that was filed under section 80 within bracket 2 comes to be allowed. And IA2 is 39(1) na?
1 and 2.
IA2 39 1 and 2 is rejected. And IA3
rejected the application IA number 3, 39 rule 3, my lord. That was rejected, but by mistake, my lord, IA number.
The other 2 applications in IA 2 and 3, which were for order 39 rule 1 and order 39 rule 3 were taken up, and order 39 rule 3 is rejected. But inadvertently, it is noticed that order 39 rule 1 in IA 2 has been rejected. This is admitted by the counsel for the defendant as well. Fairly admitted by the counsel for the defendant as well. In that light, I deem it appropriate to set aside the order passed by the concerned court on IA 2 of 2025 filed under order 39 rule 1 and 2 in terms of its order dated 4/4/2025 and remit the matter back to the hands 5/4/2025 and remit the matter back to the hands of the concerned court to hear all the parties and pass necessary orders on application under order 39 rule 1 and 2 in IA 2 of 2025 within an outer limit of 4 weeks from the date of receipt of the copy of the order.
There was a status quo order by this on.
That is concerned, but I have a submission to make.
Let it be.
Please, my lord. No, one minute. Why I am making submission, my lord? Lord, OS 2010, he has filed OS. That was, my lord, afterwards only for injunction. Later on, it was
2 weeks ಮಾಡಿ to hear.
Later on, my lord, it was amended by way of advert person. He sought for declaration. No.
It is
only 1 minute, my lord. I will leave your suit dismiss ಆಗುತ್ತೆ. Declaratory suit. RA dismiss ಆಗುತ್ತೆ. RSA dismiss ಆಗುತ್ತೆ before this on book court.
Yes.
No, 1 minute.
Yes,
3/4/2025, my lord, RSA has been dismissed. Very next day, my lord, 4/4/2025, he has filed this suit. Very same.
My lord,
seeking very same relief, my lord.
Not to very same relief. Earlier, my lord, it's
Kindly see, my lord, relief. I have filed all the judgments.
My learned friend is opposing for this. It's a suit for declaration of adverse possession against respondent 1 to 4, the state.
One ನಿಮಿಷ. There is already an order granted. 2 ವಾರ ಅದನ್ನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ.
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
court, I will direct
it
the
is
court
an agricultural
not to be influenced by
property.
this.
Why? Because it is an agricultural property. He is interrupting my possession, making some galatas and some atrocity case he wanted to introduce. But it is going on since because he lost the suit, my lord, since 2010, and before the assistant commissioner, deputy commissioner, he lost the cases. And before this time court, my lord, he lost this vote.
Grantina.
Yes, no.
No,
He, my lord,
my
he is
application.
nowhere concerned. He is nowhere concerned, my lord.
Then court may kindly
That is the
permit me
reason,
to
my lord.
say
He
this,
is
my lord.
unnecessary making
My
some galata,
application.
that's all.
I will observe that he will not, during the subsistence
That
of
what
the,
happens, my lord?
subsistence of the interim order, he will not interfere in your possession.
Very much of
My
it.
lord, I am in position
No.
for this reason, My lord,
Our title he'll
my lord,
ಕಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
if they, for 2 weeks, status quo order, which is, as on today is
ಯಾಕಂದ್ರೆ
said.
2010
And,
ಇಂದ
I will observe, wait.
Yes,
In the light of the coordinate bench of this court had granted the following order on 15/4/2025. While issuing notice to the fifth respondent, the parties were directed to maintain status quo in respect of the suit scheduled property. In the light of the matter being remitted for hearing on the Order 39 Rule 912 application by the subject order, I deem it appropriate to continue the order of status quo for a period of 2 weeks. For a period of 2 weeks, merely because the status quo order is continued, it would not mean that the concerned court would be swayed by this order, but shall consider the application on its merit and pass necessary orders. The learned counsel for the respondent submits that there has been interference with the possession of the fifth respondent, while the petitioner contends that he is in possession of the property. Therefore, both the parties shall not precipitate the matter during the subsistence of the status quo order that is passed.
please.
ನನ್ನ ಪೊಸೆಷನ್ ತುಂಬಾ ತೊಂದರೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Both the parties ಅಂತ ಹೇಳಿದ್ದೀನಲ್ಲ ಈಗ.
ನಾನೇನು ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ, ನನ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ.
ಅದು ಮಾಡಂಗಿಲ್ಲ ಅಷ್ಟೇ. ಅದೆಲ್ಲ
ಅಷ್ಟೇ,
ಮಾಡಿದ್ರೆ
precipitate ಅಂತ
take note of,
ಮಾಡಿದ್ರೆ
yes.
2 weeks.
Precipitate ಅಂದ್ರೆ ಎಲ್ಲ ಆಯ್ತು.
They have lost the matter before this court.
My lord, on the question
Order
of grant,
ಬಸವರಾಜ್ ಒಂದು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ 2 ವಾರ ಅಷ್ಟೇ. ಅದೇನು ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ we would have just right away sent it.
ಅದು
ಆಯ್ತು, yes.
Final hearing 77.
Vacating interim order ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ, ಅದಕ್ಕೋಸ್ಕರನೇ ಹಾಕಿದ್ದೀನಿ.
ಹೌದು,
That's the reason I filed.
ಬಂದಿರೋದು.
ಅದು ಅಲ್ಲಿ ತುಂಬಾ ಗಲಾಟೆ ಮಾಡ್ಬಿಟ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಇಮಿಡಿಯೇಟ್ ಆಗಿ I filed the matter.
ಅಲ್ಲ, I have no objection because my client says that he is in possession and let him not be dispossessed without due process of law. If he is in possession, that question may not arise.
ಅದನ್ನ ಮಾಡಿ, so and so shall not precipitate the matter
Both parties, my lord.
Till the next date.
Yes,
Till the, for a period of 2 weeks ಅಷ್ಟೇ. You seek separate orders there. Yes, next.
please.
Final hearing 77.
This matter I appear for the petitioners, my lord, but I have request for 10 days time in this matter, my lord.
2014. Why, sir?
Senior counsel is engaged.
Senior counsel is engaged. Senior counsel engaged ಮಾಡಿದ್ರೆ ಇರ್ಬೇಕಾಗಿತ್ತು.
ಇವತ್ತು family function ಇದೆ ಅವ್ರು.
What's the matter, sir?
My lord, it's a simple restoration application. And it's
Restoration of the suit.
restoration of suit for advocate not being available and advocate not being.
And ಆ ಇಶ್ಯೂಗೆ 11 years in pending ಇದೆಯಾ?
And please see the daily order of 28/10/21, my lord. They have a stay order in their favor, hence this helps them. 28/10/2021, Justice R. Nataraj. List this revision petition for final hearing. This is 3 years back, my lord.
No, it is Justice Suraj.
No, Justice R. Nataraj. 28/10/2021. And then, my lord, 6/1/23, Justice Chennai Judge Sir Hemant Chandan Gowda sir. Same thing, at the request of the petitioner, he agrees to give them adjournment provided list the matter finally on.
Yes, sir, again you are seeking time.
Next week, my lord.
No. Yes. Tomorrow may not be a working day, ನಾಳೆ ಹಾಕ್ತಾ ಇದ್ದೆ. Tuesday, Thursday, list on Thursday in preliminary hearing as a last chance. In the event, submissions should be made or adjournment be sought, the interim order subsisting would get automatically vacated.
There is interim on till today, my lord. Interim on till today. it's
Subject to the said condition, interim order stands extended till the
Once the interim order dies down, then we have no problem. They can take as much adjournment.
ಅದಕ್ಕೆ ಈಗ ಸಬ್ಮಿಷನ್ ಮಾಡೇ ಮಾಡ್ತಾರೆ. ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರು ಹೋಯ್ತು. ಏನ್ 10 ವರ್ಷದಿಂದ ಇಟ್ಕೊಂಡು ಈ ಕೇಸ್ ಈ ಸ್ಟೇಟ್ ಅಲ್ಲಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್
78.
For the petitioner, Lord, senior counsel.
ನಿಮ್ದು ಅಷ್ಟೇ. I will vacate the interim order.
My lords, we are ready with the matter. Pass it over, my lord. We'll come at 2:30.
There's no entry.
So interim order.
Yes.
Stay that is pending.
Next Thursday, as a last chance. ಏನಿದು eviction ಆ?
Yes, my lords.
Ejectment, yes.
Ejectment.
Next.
79.
ನಾಗರಾಜ್, ಅವಾಗ್ಲೇ ಮ್ಯಾಟ್ರಿ ತೆಲ್ಲದ್ರಿ.
Not noticed, my lord.
Huh?
I have not noticed my listing, my lord, sorry.
Not moved.
I have
I
not.
saw you sitting here and you.
No, my lord, I have not noticed that matter. I was sitting
What,
here.
ನೋಡಿಲ್ವಾ?
Nodilla, sir.
ಆಗ ನನ್ನ ಪೇರ್ಸ್ ಅಂತ ಹಾಕ್ಬೇಡಿ ಅದ್ರಲ್ಲಿ.
Please.
ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು?
55.
55 ನನ್ನ ಪೇರ್ಸ್ ಅಂತ ಹಾಕ್ಬೇಡಿ. ಅಡ್ಜನ್ ಮಾಡಿದೆ.
Also.
ಇದೇನು?
Lord, two wives, my lord, fighting a rival claim. Lord, I may say two ladies.
I need to have lunch, I guess.
Lord, next
To
month.
listen to two wives fighting.
Next Thursday.
Okay.
First tag ಬಂದ್ಬಿದೆ fresh ಆಗಿ short date.
Same ಬಂದಿದ್ದ?
ಇಲ್ಲ ತುಂಬಾ ಸರಿ after vacation.
2015
After long time.
sir.
Long time first.
At the request of the council, D. Nagaraj,
Yes.
list this matter next Thursday. It is
Please.
made, next Thursday in admission.
Admission.
It is made clear further, no further adjournment will be
Yes.
granted in the matter.
Yes.
Get ready in all these old
Yes.
matters.
Yes.
Yes.
Please.
GS, registry to delete the name of GS but as appearing for the first respondent. Yes.
In this case, Lord, I mean, yes, they will, it will be supplement, Lord, maybe.
Supplement ಏನಿಲ್ಲ ಯಾಕಂದ್ರೆ
Since,
admitted
Lord,
ಇಲ್ಲ.
they,
ಯಾವ್ದ್ರಲ್ಲಿ?
79 ಅಲ್ಲಿ.
ಹಾ, ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ?
Try ಮಾಡ್ಬೋದು.
Settlement
ಒಂದ್ ವಾರ ಕೊಟ್ಟಿದ್ದಿಲ್ಲ, ಟ್ರೈ ಮಾಡಿ.
ಇಲ್ಲ ಅದು settlement
ಅವ್ರು ಇಲ್ಲ ಅಂತಿದ್ರೆ ಅದಕ್ಕೆ ನೀವು ಟ್ರೈ ಮಾಡೋದ್ರೆ ಮಾಡಿ. ಒಂದು ವಾರ ಕೊಟ್ಟಿದೆ, ಟ್ರೈ ಮಾಡಿ.
I am ready, Lord, they are not. I am otherwise ಎಲ್ಲ.
Sir, 2015 I will not adjourn. Yes.
Next to Thursday.
11 ವರ್ಷ ಬೇಕಾಗಿಲ್ಲ ಸೆಟಲ್ ಮಾಡಕ್ಕೆ. ಕೇಸ್ ಹಾಕಿದ ತಕ್ಷಣ ಮಾಡ್ಬೋದು.
ಮಾಡ್ತೇನೆ.
ಅವ್ರು ರೆಡಿ ಇಲ್ವಲ್ಲ ಈಗಲೂ? ಎಸ್. ಮಧು ಯಾರಿಗೆ?
My lords, serial number 80.
80, my lords.
It's a
ಬಿಟ್ರಲ್ಲ?
settled matter.
Settled.
Parties are present.
The petitioner has filed a memo seeking to withdraw the petition on account of a settlement arrived at between the parties to the list. The memo reads as follows, and the parties have also affixed their signature on the said memo. ಅಷ್ಟೇ ಸಾಕು, ಇನ್ನೇನಿದೆ?
It is settled out of court, my lords.
ಅದೇ ಬರ್ತದೆ ಮೆಮೋಲ್, ಅದೇ ಹೇಳಿರೋದು ಮೇಡಮ್. ಎಸ್, ಸೆಟಲ್ಡ್ ಇನ್ ದಿ ಕೋರ್ಟ್ ಅಲ್ವೇ ಅಲ್ಲ? So in that light, now what is to be done? Disposed ಅಷ್ಟೇ. In that light, the petition stands disposed in terms of the settlement arrived at between the parties as indicated herein above.
Lordships,
ಇದು
seal-
ಬರುತ್ತೆ. Tomorrow or day after will pass. It's ready.
Yes, yeah.
ಅದಕ್ಕೆ ಹಾಕಿ.
ಆಯ್ತು, grateful.
Oh, 3:30 ವರೆಗೂ ಹೇಳ್ತೀನಿ.
May I make a request, my lord? List number 2, my lords, serial number 19. There is solitary objections. Office objection is that the other defendants are made. One of the defendants files an application, serial number 19, my lord, in CRP. The other defendants are not necessary parties. I have made a note in the cause title itself. This is a rejection of plaint. One of the.
19.
Yes, sir.
There we'll finish it off.
I'll wait.
ಇನ್ನು 4 minutes ಇದೆ, we can finish it.
Yeah, yeah.
List number 2. First time matters. Still number 1.
2 weeks time is granted to comply with the,
Fine.
ಅಲ್ಲ ಒಂದು ನಿಮಿಷ, 1 to accept, ನಿಮ್ದೇನ ಸಬ್ಮಿಷನ್ ಇದೆಯಾ?
Serial number 20, my lord, regarding maintainability, my lord, is ended.
ಒಂದು ನಿಮಿಷ. ಸೀರಿಯಲ್ ನಂಬರ್ 18 ವರೆಗೂ ಜೈ 10 ಅಲ್ಲಿ ಏನಿದೆ?
ಇಂಪ್ಲಿಮೆಂಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಒಂದು ಲೈನ್ ಟೈಪಿಂಗ್ ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಪ್ರಿಂಟ್ ಮಾಡುವಾಗ. That is the problem, sir.
ಮಾಡ್ಬೇಕಲ್ಲ,
ಅಲ್ಲ ನಾನಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವ್ರು ಹೋಗಿ
ಅವರೇ ಮಾಡಿದಾರ. 10 ಅಲ್ಲಿ accepting the submission, office objections overruled.
ಅದ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ನೋಟಿಸ್ ಹಸ್ ಬೀನ್ ಆರ್ಡರ್ಡ್.
ನಂಬರ್ ಕೊಡಿ.
59 to 60.
ಅದೇನಾ ಸೇಮ್ ನೋಟಿಸ್? ಅದನ್ನ ಅವಾಗ್ಲೇ ಓವರ್ ರೂಲ್ ಮಾಡಿದ್ನಲ್ಲ ನಾನು.
ಅದಲ್ಲ
ಹಾ ಸರಿ, ಎಸ್ ಓವರ್ ರೂಲ್ ಮಾಡಿ ಸೇಮ್. ಅದು ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬಿಡಿ, ಜೇವಾಗಿ ಹೇಳ್ಬಿಡಿ. Ajay, 58 to 60, first list, yes. 19, accepting the submission of his objection overruled. ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು 20, ಲಿಂಗರಾಜ್.
My lord, regarding maintainability, my lord,
ಹಾ.
against my lord, P miss my lord, what happened, my lord? As a claiming the indigenous person, my lord, application had been filed. P miss petition has been filed. Same has been dismissed, my lord, against which CRP has been filed.
CRP ಬರುತ್ತಾ?
CRP maintain ಆಗುತ್ತೆ. They claim that in office, RA ನಲ್ಲಿ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. RA ಪೆಂಡಿಂಗ್ ಇರೋದ್ರಿಂದ maintainable ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. This is the P petition.
Keeping open the objection of maintainability, list the matter on Thursday the next in preliminary hearing, in admission. Yeah, ಇನ್ನೂ objections.
ಇನ್ನೆರಡು objection ಇದೆ, government ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ.
Objections, the remaining office objections be complied with by the next date.
Please.
ಅದು ಕೊಟ್ಬಿಡಿ ಈಗಲೇ.
Please.
ನಿಮ್ದು overruled. ನಿಮ್ದು ಎಷ್ಟನೇದು?
The 19, your lordship just now overruled the objections. The application, the revision is as a rejection of the plaint filed.
Notice, yes.
Lordships, one micro submission. ಇದರಲ್ಲಿ
ಕೊಡಿ,
ತಮ್ಮದೇ ಒಂದು ಎರಡು ಜಜ್ಮೆಂಟ್ ಇದೆ.
ಕೊಡಿ.
81. It may come to some.
You will get it comprehensive.
Because a lot of lives and livelihoods of a lot of youth of this country.
Anyone?
Yes. Maintainability 21. ಮಧ್ಯಾಹ್ನ ತಗೋಣ. ಇನ್ನು ತುಂಬಾ ಇದೆ.
Oh, yeah.
and 94 and 104 she got admitted for 6 hours, my lord. And 105 Aster hospital bills, my lord. These are the bills.
So this is for the twisting of the hands.
Yes, my lord. And she was there is a bruises on her hand and other things, my lord. And there was a fluctuation in their pulse rate and BP and other things, my lord, because she is suffering from low BP. So because of that, she was admitted for the 6 hours, and later on, when she was stable, then she has left from the hospital, my lord.
All right.
Yes, my lord. My lord, regarding the dates, I will come, my lord. 10/11 MLC report was filed. 12/11 was LPT, my lord. What happens is 14/11/2024, there was a mediation, my lord, inside the police station where the husband was called before the police. After the LPT, mediation was done. Immediately, he rushes to the family court and files MC petition, my lord. Rather than filing bail petition, he files bail after filing of a complaint on 2/12/2024. Complaint was filed. FIR was filed on 2/12/2024. On 9/12/2024, bail application was filed. And these are the dates, my lord. Even before taking a bail, he files a MC for cruelty, my lord.
All right.
And he has made an allegation that I have an affair with one person, my lord. This is the
With one person.
yes, my lord. It is a cruelty according to him.
Allah, he has an affair.
No. He makes an allegation that wife has an affair with the one person called X, my lord.
Called X.
Yes,
All
my lord.
right. X factor.
Yes, my lord. My lord, FIR is against the husband, my lord. These are the allegations, my lord. 115. Hurt, my lord. Section 351(3), criminal intimidation.
ಅಷ್ಟೇ hand twisting ಅಷ್ಟೇ.
Yes, my lord. Hand twisting. ನಾನು ಬರ್ತೀನಿ, my lord.
ಎಲ್ಲಿಗೆ?
My lord, to my objections, my lord.
ಅಲ್ಲಿಗೆ ಬನ್ನಿ.
Yes, my lord.
Yes.
But 39, my lord. Page 39, annexure 4. My lord, honeymoon ಹೋಗಿದ್ದಾಗ, because for the unnatural sex, he has pushed me. So it is above the knee, my lord. There is abbreviation 39, my lord. Page 39, R4. R4, 40, my lord. My lord, it shows Bali, my lord. The location, my lord. This is not in India. And
Bali is not in India, ಅದು ಗೊತ್ತು.
Page 41, my lord, device from where it was extracted, my lord. But subsequently, my lord, these are the page 42, my lord, annexure R5. These
How long were you together?
My lord,
How long was the relationship correct?
my lord, 1 year, my lord.
ಆಮೇಲೆ third
Yes,
soar.
yes, my lord. This is the love marriage, my lord.
ಅದಕ್ಕೆ 1 year ಅಷ್ಟೇ ವ್ಯಾಲಿಡಿಟಿ.
ಅಲ್ಲ, my lord. I was telling you. And she was with the father-in-law and mother-in-law, my lord, in the matrimonial house, my lord. My lord, there are financial transactions. She was financially exploited by the husband, my lord. Wherein, yes, my lord.
Financially exploited by the husband.
Yes, my lord. But you can see the transaction from page 42 to 82, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
My lord, around 10 lakhs, my lord. These are the transactions.
What for?
Simply, my lord, for bike and daily day-to-day things and whatever he requires, he'll simply send me the scanner, my lord, and I have to pay. Scanner ಸಮೇತ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
ಯಾಕೆ ಅವ್ರು ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ವಾ?
My lord, he is a physiotherapist, my lord. He never used to go to the hospital or anything. He privately practices, my lord. So he never used to earn. Apart from that,
work from home ಆಗಲ್ವಲ್ಲ?
ಅದೇ ನನಗೂ ಗೊತ್ತಿಲ್ಲ ವರ್ಕ್ ಫ್ರಮ್ ಹೋಮ್ ಹೇಗೆ ಅಂತ. ಬಟ್ my lord, 83, my lord, he plays ludo. ಇಷ್ಟೇ ಮಾಡೋದು, ludo, ಕುಡಿಯೋದು and other things. I'll show, my lord. Page 83. Page 83 to 85, my lord. 30,000 ಗೆ he makes a betting. And my lord, 87, my lord.
Ludo.
30,000 ಗೆ, my lord. My lord, page 87. Double black. My lord.
Well, senior. On his way.
My lord, it's important, my lord. R9, my lord. ಇದೊಂದು ನೋಡ್ಬಿಡಿ, my lord.
ಒಂದೇನಾ? ಯಾವುದು?
ಇದೊಂದು ಸಾಕು, madam. 95, my lord. Page 95.
Page
95. but I can't quote the name, my lord.
Please don't do all.
Yes,
ನಾನು ನೋಡ್ಕೊಂತೀನಿ.
yes, my lord. There are 3 names, my lord. They are not married also, my lord, so I can't disclose the names. It is after marriage. They themselves tell in the message, my lord. Because of this conversation, she wanted to confront the
So where
husband.
did the cat come in?
My lord, cat come in, my lord, only one paragraph, my lord. She has the problem where, my lord, what happens is she has to take care of entire house. She works from home. She's a software engineer. So what happens is this cat used to come to the house and make it dirty, my lord. Ili, adu, idu ella tagoman. So one paragraph, this complaint could not know because she was not.
ಬೆಕ್ಕಿಲಿನೇ ತರದು ಬೇರೆ ಏನ್ ತಂದು.
Yes, my lord. While giving the complaint, she was not accompanied by the advocate, my lord. But on 14, the advocate was there before the concerned police station, my lord. Advocate on record. And for the matter of fact, my lord, he is also friend of petitioner number 1, my lord.
Advocate.
For 12 years.
Petition number 1 now. ಇನ್ಯಾರಿದ್ದಾರೆ?
Petitioner number 2 is father-in-law.
ಅವ್ರದ್ದೇನು?
ಅವರು ಗಾಂಧಿನಗರಲ್ಲಿ is a good producer, my lord. Very famous producer.
Film producer.
Film producer, my lord. Then very influential.
Very influential.
Very highly influential, my lord.
Influence ಇಲ್ಲಿ ಅವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ ಈಗ?
He has influenced in, my lord, that is a dowry demand, my lord. That is in page number R2, my lord, page 18.
Where is your petition? Her father's name is Venkatesh.
Yes, sir. Parkline, this thing. He's one of the thing. Because he has also called the jurisdictional IO. This is what I've got to know. There is an allegation. But in the complaint also, my lord, there is averment. Site ಕೇಳಿದ್ದಾರೆ, ಒಡವೆ ಕೇಳಿದ್ದಾರೆ, ದುಡ್ಡು ಕೇಳಿದ್ದಾರೆ. Everything is there, my lord. But last paragraph, she has mentioned regarding the cat. ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಗಿ
ಅದನ್ನ ಮಾಡಬಾರ್ದು.
She was not accompanied by the advocate like.
Cat picture ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yes, sir.
ಇದೇನಿದೆ? ಯಾಕೆ ಹಾಕಿದ್ರಿ? ಕ್ಯಾಟಾ ಡಾಗಾ?
So she's financially abused, physically abused, mentally abused, and he never used to work, my lord. Mane bari kudiyadu, everything I've made it as annexure. Ellanu ide. And she was very scared to submit before the IO, my lord, but she has given all the documents, but it is not part of the petition, my lord. Everything is suppressed and they have
You have filed everything in the objections?
Yes, my lord. Detailed objections, my lord. Everything I have mentioned. Suppress 230 ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಮಾಡಿ ರೆಗ್ಯುಲರ್ ಆಗಿ ಬಂದಿದ್ರೆ ಇದು ಆಗ್ತಾ ಇರಲಿಲ್ಲ
ಅಲ್ವಾ? ಕರೆಕ್ಟ್. 230 ಮೂವ್ ಮಾಡೋದೆಲ್ಲ ಇದೆ ಪ್ರಾಬ್ಲಮ್. ಬರಕ್ಕೆ ಹೇಳಿ.
ಇದು ಮೈ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಪೇಜ್ 100 ಮೇಲೆ ಅದೊಂದು ಫೋಟೋಗ್ರಾಫ್ ನೋಡ್ಬಿಡಿ.
ಅರೆ ಅವಾಗ್ಲೇ ಅದೊಂದು ನೋಡಿ ಅಂದ್ರೆ ಅದೊಂದು ಆದ್ಮೇಲೆ ಮತ್ತೊಂದು ಅಂತ ಇದೆ. ಪೇಜ್ 100.
ಎಸ್ ಮೇಡಮ್. ಮೇಲೆ 99, 100 and 101.
ಇದೆಲ್ಲ ಎಲ್ಲಿ ಸಿಕ್ತು ನಿಮ್ಗೆ?
ಮೇಲೆ what happens is on 9/11/2024 he was fully drunk. So face
making use of that ಎಲ್ಲ ತಗೋ face unlock ಮಾಡಿ. He was drunk and sleeping, face unlock.
Yes, my lord. Same
face unlock ಗೆ ಕಣ್ಣು ಓಪನ್ ಇರಬೇಕು.
I don't know, my lord. She has managed to open the phone.
Face unlock doesn't happen with the face but with the eyes. It's a retina.
I don't know, my lord. She told me, my lord, upon her instruction, and this is the tab. He's a sex maniac, my lord. So all these things, it is in the tab. Idu yavadu this page number 9900 idu. Adu bere WhatsApp messages ella phone, bere phone. He has separate tab for this.
Oh, iduk separate tab.
Separate tab. Ludo, cricket, betting cricket, and this forceful sex and unnatural sex, my lord. And there is an allegation in the complaint. Site allegation ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಸೀನಿಯರ್? ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ. ಇದು ಮುಗಿಸ್ಬೇಕು ಇವತ್ತು, ನೋ ಟೈಮ್.
Please, madam.
He has finished, only you. Because I have granted interim order on.
12/12/2024, my lord.
Correct, on cat scratching you ashte. But there is something more than the cat in this, yes.
Case of disproportionate effect and exoneration in the department.
Oh, it is separate, kodi. ಅದು 7A ಅಲ್ಲ, 7Aನಾ?
No, my lord.
ಮತ್ತೆ ಟೈಮ್ ಕೇಳಂಗಿಲ್ಲ. ಎಲ್ಲಿ ಬಿ ಪಾಟೀಲ್?
So criminal appeal argue ಮಾಡ್ತಾ ಇದ್ದಾರೆ. So ಬೇರೆ
ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಮಾಡ್ತಾ
ಮಾಡಿದ್ಮೇಲೆ ಬರಕ್ಕೆ
ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್
ಮಾಡ್ಲಿ.
ಮಾಡಿ. So next date ಅಲ್ಲಿ ನಾವು ರಿಪ್ಲೈ ಮಾಡ್ತೀವಿ.
ಅದು ನೋಡೋಣ. ಎಸ್ ಎಸ್ ಸರ್.
It's a corresponding provision under the 88 Act, 13E. My lords will get it at the exoneration.
ನೀವು ಯಾರಿಗೆ?
Exoneration report.
BB Patil.
ಇಬ್ರು ಇದ್ದೀರಾ?
Yes, please.
ಒಬ್ರನ್ನ ಕಳಿಸಿ ಕರ್ಕೊಂಡ್ಬರ.
That's the exoneration report. My lords will get it at page number. Page number 190 onwards.
No, is it after a departmental inquiry or what? Where is the report of the inquiry officer?
Well, it's the report of the officer, the operative portion, my lords will get it at page number 333. 333, 333. And it is spilled over to 334 as well. Sabit ಆಗಿರುವುದಿಲ್ಲ. Then, my lords,
ಒಂದು ನಿಮಿಷ.
it was forwarded to the.
ಒಂದು ನಿಮಿಷ.
Please.
ನಿಮ್ದೇನ್ 319 ಆದ್ಮೇಲೆ 340 ಹೋಗ್ಬಿಟ್ಟಿದೆ ಸೀದಾ. 333 ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ. ಎಲ್ಲಿ ಕೊಡಿ ಪೇಜಸ್
Please.
ಅವ್ರಿಗೆ ಕೊಡಿ. ಪೇಜಿನೇಷನ್ ತಪ್ಪ ಇಲ್ಲ ಪೇಜ ಇಲ್ವಾ?
Yes, one. Pagination, no. 357. Spilled over.
ಪೇಜಿನೇಷನ್ ತಪ್ಪ?
Pagination.
ಎಲ್ಲಿ ಓದಿದ್ರಿ?
My lords, the last operative portion is last two lines.
ಮೇಲ್ಕಂಡ ಅಂಶಗಳಿಂದ.
ಹೌದು.
ಹಾ.
Last two, ಆದ ಕಾರಣ
ಮೂರನೇ ಆರು ಸಂಬಂಧಿತ ಚರ್ಚಿಸುವ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದ ಕಾರಣ
ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳಿಂದ
ಮೂರನೇ ಆರೋಪಿಯು ಸಾಕ್ಷ್ಯಾಧಾರಗಳನ್ನು ಕೊರತೆ ಇರುವ ಸಾಬೀತಾಗಿಲ್ಲದಿರುವೆಂದು ಅಭಿಪ್ರಾಯಪಡಲಾಗಿದೆ.
Yes. My lords, the next one is, my lords, the order accepting the inquiry report by the government. My lords, the last page, that's on 23 to 23.
23 to
23
page ಏನು ಇದೆ ಸರ್? Page.
My lords, the
This is
last-
accepted by the disciplinary
Yes,
authority.
yes.
All right. This has become final?
It has become final. And moreover, in the departmental inquiry, they have examined more witnesses than the
And the same witnesses?
same witnesses. My lords,
Documents marked are same?
yes, may I just pass it on the comparative table itself?
ಅದು ಕೊಡಿ, that is what is needed.
Comparative table.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಜಾಸ್ತಿ ಇದೆ?
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಜಾಸ್ತಿ ಮಾಡಿದೆ.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ಜಡ್ಮೆಂಟ್ಸ್.
ಆಶು ಸುರೇಂದ್ರ.
ಆಶು ಎಲ್ಲ ಹಳೇದಾಯ್ತು, ಲೇಟೆಸ್ಟ್. ಬಟ್ ಪುನೀತ್ ಕುಲಕರ್ಣಿ ಕೊಡಿ.
No, sir, that judgment I have not brought.
What your colleagues have not seen? There is one judgment of mine, which where I have considered everything.
Attar Mohammed. Attar
Ah,
Mohammed
ಕೊಡಿ.
Shafiullah. Right. I'll just pass it on.
ಎಲ್ಲಿದೆ?
ಕೆಳಗಡೆಯಿಂದ library in the first.
Yes. Yes,
Kindly pass over, my lord. Will
pass over. Yes, Keshav, ಬನ್ನಿ. ಅದು ಕೊಡಿ.
I'll start.
You should, sir.
This. Now, page 35
Is a complaint.
is the complaint. She has made allegations that the cat has scratched her,
Cat has scratched.
and on the basis of which she has registered a 498A and dowry harassment. Now,
39, 39, ah,
Page 35, man.
35. Yes.
35 of my writ petition.
Yes. At 11:30 hours in the night, relating to our pet cat, adena?
Several times disputes have arisen due to the issue of the pet cat. Cat has attacked me several times and even scratched me, from which I am afraid of it. Those averments.
ಅದು cat ಮೇಲೆ ಆಯ್ತು, husband ಮೇಲೆ?
Husband mele, my lord. Now kindly see, there is another PCR that she prefers.
Where
That
is
is, she has mentioned on page 35 only, my lords.
LP.
Can we take page 35 on 12.
LPT, my lord.
LPT ಅಂದ್ರೆ ಏನು?
My lord. For mediation, they do that, my lord.
ಸರಿ ಆಯ್ತು.
But kindly see what complaint she has given on that. That I have produced it as well, my lords, by way of a. I think my learned friend has produced.
ಹೌದು, ಅವರೇ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
No, no, ಈ NCR ಕಾಪಿ ಇವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಇರ್ಲಿ, ನೀವು ನಿಮ್ದು ಆಯ್ತಲ್ಲ, ಆಮೇಲೆ ಹೇಳಿ.
Yes, sir.
My lords, I produced it by way of a memo dated 25/2/2025.
25 to
2025.
It's here. Yes, sir.
I've obtained this by way of a RTI.
All right.
At page number 2, my lords. Page number 3 is her complaint. Last 2 lines, my lord, she says, the father-in-law, mother-in-law, and the husband were saying they are forcing me to have a child. So which is why she prefers this complaint. So there are 3 different versions for the same date of incident. Now, this version says that because they are forcing me, you give buddhivada kodi anta heltare.
Buddhivada?
Buddhivada. So that is one. And subsequently, my lord, she files another petition on 4/1/2025, saying for seeking for domestic violence, where she claims kindly take their objections, my lord, IA for vacating stay.
All right, domestic violence ಹಾಕಮ್ಮ crime ಹಾಕಬಾರದು ಅಂತೇನೆ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, it's not that. I am, my lord,
First ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್. Sorry, my lord.
ಕೂತ್ಕೊಳ್ಳಿ ಸರ್.
Page 122, annexure R13. R13. Kindly take page 130, my lords. At para 24. She says, now that she says, sorry, para 19 at page 128. Para 19, page 128. She says it is submitted on 9/11/2024 at 11:30 in the night. Respondent number one started scolding the petitioner about a cat in their house. Then the respondent number one tried to physically assault
The cat?
the petitioner. So there are three complaints, three different versions, and none of it has any veracity at all.
So it was still at the stage of investigation.
Still at the stage of investigation. My lords were pleased to stay further investigation in the matter. My lord, in a similar situation, my lord, I've also filed a memo for judgment at on 4/3/2025.
Yes.
My lord, the first judgment, my lord, which was
Judgment alla ideno Chennai to Bali, something you said.
my lord, there were two memos, my lord. I think the second memo
On the same day?
on the same day.
Yes, judgments. Yes.
I'll come to that other memo as well. In this judgment, my lords, kindly take para 18, 20 and para 18, 20, 28 and 29, my lords. At page internal running page 16, my lords. Para 18.
Read.
A bare perusal of the FIR shows that the allegation made by the respondent number 2 are vague and omnibus. Other than claiming that the appellant 1 harassed her and the appellant 2 to 6 instigated him to do so, respondent number 1 has not provided any specific details to describe any particular instance of harassment. Now, if my lords were to take the complaint at a bare perusal, there are no instances of dates, times, what harassment has been melted out, and all the harassments are of the year when they got married or when they went on a Bali trip or something, and all of which, my lords,
when they got married and think towards one day varsha agirada.
My lord, even then, but she's kept quiet all that while. So it goes to show the conduct of the wife. So you keep quiet all this while, one small incident that transpires where there is not much that has happened, and in fact, according to her, only a cat has scratched her. How does an allegation of 498A come about? 498A or even asking for dowry, where there has not been any instance of dowry that has been asked by the petitioners here.
So dowry only need not be the ingredient of 498. Even cruelty can happen.
My lord, but
dowry is
cruelty by the cat.
Demand of dowry gets attracted as an added instance to 498A to bring in 3 and 4 of Dowry Prohibition Act. But plain cruelty also attracts 498.
Plain cruelty, but this is a cruelty where the cat has scratched her.
I did not say cat cruelty. Plain cruelty.
I'm on this instance where the cat has scratched her, and she said, "How can that be amount to me instigating the cat?"
There is only one paragraph. Otherwise, there are many instances.
My lord, if I may, my lord, the other instances are all omnibus. There are no specific date and time as to what has transpired. What investigation is going to come out of it?
No, have you seen the allegations made against you by her?
That I have had alcohol.
Alcohol, very alcohol.
Alcohol, I have played cricket.
Cricket?
Those are the allegations in the complaint.
You play cricket?
Yes, I do play cricket.
No,
I'm talking about the petitioner number 1.
Correct, of course. I'm not talking of the father here. Yes. No, he's telling not cricket betting.
Betting cricket.
My lord, now.
Ella one there.
No, not that. But I'm saying that it is now right in the open. Even there are several apps for that purpose.
Oh, I don't know. Yes.
I mean, it's probably something called that Dream
Game of
11.
skill.
Game of skill.
Oh, yes. All right.
My lord, if I may take your lordships to that other memo, my lords.
4/3/2025.
Please, my lords.
But the
allegations.
If you read the complaint in the domestic violence case.
Please, my lord. All those.
1 minute. Domestic violence case and the other complaints. You have tortured her for unnatural sex.
My lord, now, my lord, kindly see when that torture that she claims to have happened.
Bali.
That there is no such thing.
Continuous cause of action. ಈ ಸರ್ ನೀವು
Now she says that they traveled, she paid for everything. That I have produced documents to show that in fact the petitioner, who's the one who's paid for the most, they've split their trips and gone ahead, Manoj.
oh, after marriage.
After marriage, the evidence of which or the photo, the ticket details are produced, Manoj, because those are only
Oh, husband's ticket, husband, wife's ticket, wife.
things like that has transpired between them. What understanding they have, I don't know, but
That nobody will know.
nobody will know.
No court of law, even after complete evidence, will know.
Please, Manoj.
Yes.
My lord, she claims that I have bought bottles of alcohol and had alcohol and in fact tortured her. But in fact, she's the one who's bought those alcohols because her passport number is what is given on the bill.
ಅರೆ ಅವ್ರ ಪಾಸ್ಪೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ತಗೊಂಡ್ಬಿಟ್ರೆ?
My lord, now if she's also consuming, then from where now, my lord? How can it be only that I do every act and she has not done anything?
Presumptions. Husband.
My lord, there is no presumption because
Husband.
my lord,
Yes.
that's about it, man.
ಇನ್ನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿಲ್ವಲ್ಲ, ಯು ಕಾಂಟ್ ಸೇ ಎನಿಥಿಂಗ್.
Yes, ma'am.
ವಾಟ್ ಅಬೌಟ್ ದ ಫಾದರ್? ನೀವು ಇರಿ ಸರ್ ಒಂದು ನಿಮಿಷ.
My lord, the father has not done anything. There are no instances. There is only omnibus allegations. And all the allegations are to the effect of they told him to do it or they did not allow me to do, dance and things like that. Dance. So the entire issue that has transpired between the couple is that the parents and the husband told her not to dance on the streets. In fact, do it in a studio. So that is where all of this has culminated.
Why would she dance on the streets, sir?
There were videos on Instagram on her
reels ಮಾಡಕ್ಕೆ ಇರ್ಬೇಕೇನ ಅದನ್ನ
exactly whatever, Melody.
If you misunderstand or mistake the reels to the daily practice, it is difficult.
It was not reels, but they just advised her not to do it, and from there is where all of this has culminated from. There is no wound certificate as well, my lords. There nothing. Even in the hospital bill says there's no damage or any hurt that has been caused to the wife. So it was only a verbal thing, and a cat has scratched her. In fact, I'll leave it at that.
ಕಂಪ್ಲೇಂಟ್ ಮತ್ತೆ ಹೋಗ್ಬೇಡಿ. ಏನು ರಿಪ್ಲೈ ಹೇಳಿ. ಫಾದರ್ ಇನ್ ಲಾ ಮತ್ತೆ ಮದರ್ ಇನ್ ಲಾಗೆ. ಮದರ್ ಇನ್ ಲಾ ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ಲಿ?
Mother-in-law is also petitioner number 2.
Read the complaint, my lord. Page mother-in-law is here, is it?
Mother-in-law is also a partner
number 3, my lord. Oh. ಈಗ ಹಸ್ಬೆಂಡ್ ಬಿಡಿ, ಫಾದರ್ ಇನ್ ಲಾ ಮದರ್ ಇನ್ ಲಾ ಮೇಲೆ ಹೇಳಿ.
Yes, my lord.
There is no other.
17, my lord.
Only father in law, mother in law?
Only father-in-law, mother.
There is no other in law.
ಅಷ್ಟೇ.
All right. Page 17, my lord. It's Kannada, my lord. Because translated ಮತ್ತೆ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಸಮಸ್ಯೆ ಇದೆ. Translation ಅಲ್ಲಿ ಸಮಸ್ಯೆ ಇದೆಯಾ? Yes, my lord. Page 17, my lord. Annexure A of their petition. Of their petition. Petition. ಕೇಶವ್ ಎಲ್ಲಿದೆ? 17 annexure A. ಎಷ್ಟೊಂದು ಪೇಪರ್ಸ್ ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
230 move ಮಾಡಿದೆ my lord.
ಆಮೇಲೆ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Certain documents. Then they realized after my objection.
I've only produced
ಈಗೆಲ್ಲ ನಾವು petition
Ma'am.
ಇದೊಂದು ಟ್ಯಾಗ್ ಕಟ್ ಮಾಡಿಕೊಡಿ, ಕೈಗೆ ಸಿಗಲ್ಲ. Page
17, my lord. Annexure A, my lord, of their writ petition. My lord, 2/12/2024 was the complaint, my lord.
Yes, sir.
Iga first paragraph she says that she is with the father-in-law, mother-in-law in the matrimonial house, my lord. Thereafter, my lord, ಓದ್ ಬಿಡಲ್ಲ ಫುಲ್ the court has time. My lord, ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನಾನು ಚೈತ್ರ ಸೋನ್ಸೋ ಜೊತೆಯಲ್ಲಿ ಸುಮಾರು 1 ವರ್ಷದಿಂದ 1 ವರ್ಷ 3 ತಿಂಗಳಿಂದ ನನ್ನ ಗಂಡ ನನ್ನ ಮೇಲೆ ಕೂಗಾಡಿ ಜಗಳವಾಡುತ್ತಾರೆ, ನನ್ನನ್ನು ಮಾನಸಿಕವಾಗಿ ತುಂಬಾ ಕುಗ್ಗಿಸಿರುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಈ ಎಲ್ಲಾ ವರ್ತನೆಗೆ ಹಾಗೂ ಎಲ್ಲಾ ಕೆಲಸಗಳನ್ನು ನನ್ನ ಅತ್ತೆ ಮತ್ತು ಮಾವನವರ ಕುಮ್ಮಕ್ಕು ಹಾಗೂ ಪ್ರೋತ್ಸಾಹ ಮತ್ತು ಮದುವೆಯಾಗಿ ಒಂದು ವಾರಕ್ಕೆ ನಾವು
Instigation and encouragement.
Instigation, my lord. And one, some more thing are there regarding the child, my lord. What is happening is, that father is a drunkard, sorry, husband is a drunkard, my lord. And he has Ludo, he plays Ludo.
ಅದೆಲ್ಲ ಹೇಳ ಅದಕ್ಕೂ ಅದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲ, father in law, mother in law, ಬರ್ತೀನಿ, my lord.
ಬರ್ತಾನೆ ಇದ್ದೀರಾ ಹೇಳಿ.
Because of that, he goes out in the night at 10 p.m. Husband. And because of that, the mother does not want to have a child, my lord, with the father. She wants to give some more time to the relationship because she was into this marriage because she loved this person. He came to her saying that he will help her in regarding the dance and other parts, and because his father was a producer, my lord, and she thought of certain thing, help would be needed to her, and because of that she got married to this person. Later on, they wanted, all father-in-law, mother-in-law wanted to stop this Bharatanatyam and other things. She's a Guinness World Record.
Bharatanatyam?
Yes, my lord.
Street al
the Guinness World Record.
Yes.
They have produced, my lord, in Annexure A, my lord, all the Guinness World Record and other things have produced it. She plays Bharatanatyam. And because of that, the father-in-law, mother-in-law
performs Bharatanatyam.
Yes, my lord, she performs Bharatanatyam. I'm sorry, my lord. Yes. So because of that, father-in-law, mother-in-law used to torture her to have kids, my lord. She has stated in the particular paragraphs, each and every paragraph where she has given the expired food by the mother-in-law. That is in page number.
Expired food.
Yes, my lord. ಯಾವ್ದು ಎಕ್ಸ್ಪೈರಿ ಆಗಿರುತ್ತೋ ಅದನ್ನೇ ಯೂಸ್ ಮಾಡಿ ಅಡಿಗೆ ಮಾಡ್ತಾರೆ, my lord. Because of that she suffers ಅಂತ ಬರ್ದಿದ್ದಾರೆ, my lord, in the complaint page 20, my lord. First three lines, my lord. ಮನೆಯಲ್ಲಿ ಕೆಲಸ, ಪೂಜೆ, ಅಡುಗೆ ಎಲ್ಲ ಮಾಡಿದರು, ಏನು ಮಾಡಿಲ್ಲ ಎಂದು ಸುಮ್ಮನೆ ಸುಳ್ಳು ಆಪಾದನೆ ಮಾಡಿ ನನ್ನ ಗಂಡ ಹಾಗೂ ನನ್ನ ಅತ್ತೆ ಮಾವ ನನಗೆ ಹಿಂಸಿಸುತ್ತಾರೆ. ನನ್ನ ಗಂಡ ಹಾಗೂ ನನ್ನ ಅತ್ತೆ ಮಾವ
ಬೇಡ ಬಿಡಿ ಅದೆಲ್ಲ, ಯಾಕೆ ನಾನು ನೋಡ್ಕೊಡ್ತೀನಿ.
ಹಾ, yes, my lord. And thereafter, my lord,
ಟೈಮ್ ಎಕ್ಸ್ಪೈರಿ ಆಗ್ಬಿಡುತ್ತೆ ಅದಕ್ಕೆ.
Yes. And she also mentions regarding the mental torture she gives, and the father, my lord, father-in-law, he makes an allegation towards the complainant saying that ಬೀದಿಲೆಲ್ಲ ಕುಣಿಯೋಳು ನೀನು, and ಬೀದಿಲಿ some other words he has used, my lord. ಅಂತೋರು ನಮ್ಮ ಮನೆ ಸೊಸೆಯಾಗಿರಬಾರದು, you should not dance. This is what the father-in-law has done, my lord. So petition number 1, 2, 3, all averments are made out in the complaint, my lord. Because of that, it has to go to investigation, because at this time, if this court intervenes, then the investigation will not happen, my lord, and she will be at loss, my lord. Because Apex court has time and again that the Constitutional Court should not intervene at the stage of
intervene ಆಗಿರೋದೆ.
My lord,
Supreme Court has directed
this does not
intervention.
come under abuse of process of law or read between the lines, my lord.
Oh, correct. Yes.
Muhammad Ali or Wajid. Yes, this has to be investigated, my lord. Prima facie, the case is made out. MLC report is there, my lord.
Nagaraj,
Yes, my lord.
Yes, sir. Yes, Keshav.
One more submission. Pursuant to the incident, my lords, after the cat has scratched her, there was a fight that was happened between the husband and the wife, where the wife says that she has had an extramarital affair, pursuant to which they were supposed to file a mutual consent divorce petition, which they didn't, because of which the husband has filed a petition for divorce on the ground of adultery as well as cruelty. And that is also produced at Annexure E.
Ground for divorce.
Ground for divorce. At Annexure E, my lords, he's also made several allegations against the wife as well, and has preferred that complaint. So it was after this, the divorce petition that was filed by the husband, that the present complaint comes to light. So therefore, it is only done as a counterblast measure, and it has only been done to harass the petitioners here, and therefore I pray that the petition be allowed.
Regarding the WhatsApp messages, my lord.
ಅದನ್ನು ಓದ್ಬೇಕಾ ಸರ್?
ಅಲ್ಲ, if they have to say something, because betting is common ಅಂತ ಅಂದ್ರು, my lord. That texting, when a man is married, my lord, he cannot text.
Married man can't bet.
ಅಲ್ಲ, regarding the WhatsApp messages, my lord, where he has made an text to the three women, my lord. What they have to defend, I don't know, my lord.
Texting is also bad.
Yes, my lord. My lord, this amounts to cruelty, my lord. He is a married man.
Married men should not text.
In that way,
text anybody.
Manner, my lord. In that manner, my lord.
So, my lords, if I was to text anyone,
you are married.
No, even if whether I'm not, yes or no, irrespective, then that would also, that will change every relationships to the earth.
So according to you, married men should not text
in that manner,
another woman.
No, my lord, he can text, but not in that manner, my lord.
ಯಾವ manner?
My lord, page 95, my lord. ಮತ್ತೆ ಟ್ರೂತ್ ಆರ್ ಡೇರ್
ಓದ್ಬಿಡಿ.
ಟ್ರೂತ್ ಆರ್ ಡೇರ್ ಇದೆ.
ನೀವು ದಟ್ ಮ್ಯಾನರ್ ನಾನು ನೋಡ್ಕೊಂತೀನಿ, ನೀವು ಓದ್ಬೇಡಿ.
Kindly see when this was taken.
ಮತ್ತೆ ಸಾಕಲ್ಲ,
Date I'm saying, it's only date.
ಬಿಫೋರ್ ಮ್ಯಾರೇಜ್.
It was on 29th April 2023, before marriage. Their marriage was on 23/8/2023, and they were in a relationship even 1 year before, 1.5 years before marriage. So they're all
during that
mutual
relationship
friends.
you are texting other women.
No, they're all mutual friends. So
ಮ್ಯೂಚುವಲ್
what-
ಫ್ರೆಂಡ್ಸ್ ಹಿಂಗೆಲ್ಲ ಮಾಡ್ತಾರೆ. ಟ್ರೂತ್ ಆರ್ ಡೇರ್ ಎಲ್ಲ ಆಡ್ತಾರೆ my lord. ಫ್ರೆಂಡ್ಸ್ ಜೊತೆಲಿ ಬಾಂಬ್. ಸೊ
ಆಯ್ತಾಯ್ತು. ಏನು ಓದಕ್ಕೆ
Gen Z crowd has taken it a little. Gen Z crowd has taken it one step further.
this is why it will lead to marital discord, my lord.
ಕರೆಕ್ಟ್. ಇಲ್ಲ, ಅದು ಸಿಚುಯೇಷನ್ಶಿಪ್.
Situationship, yes, my lord.
I won't make any statement on that.
Yes.
That's it, my lord. My lord, one more thing, my lord. There is a DV cases also they have stayed because of this particular matter was stayed before this court. They have told the same thing. They have not gone on merits or anything, my lord. So they have
ಅದೇ petition.
Other petition, I've challenged a DV petition as well to say that there are completely different allegations as compared to the complaint dated 2/12 before your lordships as compared to the DV case. Now there are completely different allegations, different reasons altogether. So I made submissions, and this honorable coordinate bench of this court was pleased to grant a stay of those proceedings as well.
Lord, ಅದು ನಿಮ್ಮ ಮುಂದೆ ಇದೆ, my lord.
ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
My lord, they have tagged this.
Where is it?
It was supposed to be tagged, my lords, but it has not been tagged.
ಪರವಾಗಿಲ್ಲ.
Because there's an order to that effect to tag it along with this petition.
No problem. Yes. It's all right.
Grateful.
Heard, so and so, reserved.
Grateful.
Vacating stay ಯಾರು ಹಾಕಿರೋದು?
ನಾನೇ.
And
State also is
state
filed.
has also filed.
ಏನ್ ತೇಜಸ್ vacating stay ಹಾಕಿರೋದು?
They want to investigate the cat.
We'll see what is required to be investigated, we'll do.
Grateful.
ಅವರಿದ್ದಾರಾ? ಹಾ, ಅವರೇ. ಇತ್ತವಳಿ ಅಲ್ಲ, 330 ಒಂದು 20 years suit with petitioners counsel.
Yes, ma'am.
Wait, let them start. Yes. Mumbai Metro.
Coming inside a Mumbai Metro, it's
Oh,
like
that
that, my
way.
lord. Your lordship's court is always like that.
Yes.
Yes, my lord, as
I
was
thought you have come from Mumbai Metro.
No, the
Wait.
experience.
Angad.
Yes.
Let them start and finish. Yes.
My lord, defendant's petition. Defendant number 2 files an application under
Section 10.
Please. Section 10. This is a suit of 2006. There is another suit filed by the defendant in 2004 for portion of the property. 2004 suit gets dismissed in 2013, restored in 2023. Evidence is recorded till yesterday. Matter is set down for arguments on the 11th. Our prayer before the Section 10 court was, let the hearing and judgment in 2004 suit be passed. Till then you wait, or else let both these matters be heard by one court.
That is section 24.
Section 24 was filed before the principal district judge seeking for transfer of one of the court to
same thing, yes.
whichever court. Now this matter is listed for final arguments. Their suit is 2006. They are now saying that you are delaying the matter. My suit, my lord, was dismissed, so I got it restored after
All
10
right,
years,
you-
all that.
You
But
come on merits. Yes.
On merits, my lord, if your lordship may kindly look at the schedule. This person who is before your lordship.
Page.
My lord, your lordship may kindly come to Annexure C, which is my suit, which is my sale deed, which is at page 45.
45.
Please, me.
Yes, ma'am.
I purchased this property in 1994. And the schedule to this property is at page number 51.
Yes.
ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ಗಾಣಕಲ್ಲು ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 3/3B. ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ ಸೊ ಅದರ ಪೈಕಿ ಕುಷ್ಕಿ 7 ಗುಂಟೆ ಜಮೀನಿನ ಚೆಕ್ ಬಂದಿ. I purchase 7 guntas of land.
When survey number
1 acre.
Survey number 3/3B. Yes.
I file a suit in 2004 against the defendants. Some of them are impleaded at a later point of time.
All right.
And in 2009, I amend my schedule. Seeking
This
to
is
change.
OS 8729 of 2004.
Please.
Yes.
I amend my schedule by changing the survey number. I do not change the boundary. Schedule remains the same. Because the contention taken by defendant number 1 in the suit, who is the GPA holder of defendant plaintiff 1 to 10 herein, says that there is no property in 3/3B. Your property lies in 17/2A. I also get a survey done, private survey done, though through a Tahsildar's office, but not through court appointed surveyor. The survey also confirms that the property lies in 17/2A. Subsequently, in 2006, the defendant's predecessor or vendor files a suit in 2006, seeking for a declaration and injunction that I am interfering with his possession in 3/3B. When he files the suit in 2006, I wouldn't have amended the schedule. So the dispute between the plaintiffs in 2004 suit and 2006 is the very same subject matter. Their claim is that they have purchased 1 acre 5 guntas of land in 3/3B. My case is I have purchased 7 guntas of land. The 17/2 and 3/3 are adjacent properties. My lord, I will go to an extent of saying, assuming, my lord, 2004 suit gets decreed and this suit also gets decreed. In execution, what would happen in execution? Because my contention is my 7 guntas is there. If 7 guntas to be identified. So my suit which I have filed, which I have amended as 17/2A without changing the boundary, needs to be decided first for identifying the property, because I have an interim order from 2004 till date. Status order.
What is the subject matter of the subsequent suit qua the schedule? Is it the same?
No, the survey number only changes.
If it is not the same survey number, how can it be?
No, but the schedule is the same, my lord. It is a larger portion
Schedule
of
is
7
what
guntas.
you have described.
No, that is my 7 guntas only. Their schedule is
in
for
the-
1 acre.
In the subsequent suit
Please, my lord.
filed, subsequent suit is by you.
They file the subsequent suit.
Not by me, my lord, by my vendors.
Say vendors.
He
fine.
gets impleaded
All right,
subsequently.
no problem. Subsequent suit is by the vendors.
Please.
That is a schedule that they have described, which is different, which has a different survey number.
That is, my lord, because it is a larger extent. It is 1 acre 5 guntas of land. Mine is 7 guntas of land.
Correct?
Please.
So in entirety, it is different. The survey number is different, the area is different, boundary is different, everything is
No,
different.
I am saying I am
With that
inside
being the
that.
case, how did you file a section 10 application?
No, I am inside that 1 acre 5 guntas. So the
The 7
boundary would-
guntas is also inside that 1 acre 5
1
guntas?
acre 5 guntas. Because I have not changed the schedule. I have only changed 3/3B survey number, that's all.
No,
And
3/3B ಆಗಿರೋದು ಪೋಡಿ ಆದ್ಮೇಲೆ.
ಪೋಡಿ ಆಗಿ 3/3 ಇದ್ದಿದ್ದು ಪೋಡಿ ಆಯ್ತು.
ಪೋಡಿ ಆಗಿದೆ.
ಪೋಡಿ ಆಗಿದೆ. ಅವರು 1 acre 5 ಗುಂಟೆ ನಾವು ತಗೊಂಡಿದ್ದೀವಿ ಅಂತಾರೆ. And this person purchases in 2018, gets impleaded in 2022. And for a second, if your lordship may kindly look at what he purchases. There are 3 different schedules: GPA, agreement to sell, and sale deed. There are 3 different schedules. Your lordship may kindly look at.
So is it not different properties?
No, they themselves are not.
Because
clear.
the stay order that I see of Justice R. Nataraj
Please.
is that the suits and the relief sought in the suits qua the schedule are substantially similar.
Please.
So substantially same,
Please.
which is the tenor of section 10.
Please.
So it is stayed. Now you should demonstrate that it is substantially similar. Now you are saying it is of different survey number also.
No, only survey number, my lord. Because boundary prevails, my lord. I may have a
That is
different
correct.
survey
That
number.
is all right.
So I have not modified the boundary. The boundary remains the same. He is claiming for a larger extent. I am claiming for a smaller extent of 7 guntas of land. The purchaser or this defendant's vendor's vendor is the common link between my vendor and the defendant's vendor. So So there is commonality. Parties before the 2004 suit and 2006 suit are same. There are additional defendants in 2006 suit, but the same parties are in 2004 suit.
All right.
In the 2006 suit also, defendant number 1 also agrees or accepts that this suit needs to be stayed because there is commonality of boundary. And also what the defendant, contesting defendant before your lordships is contending is that he has purchased a property, list pendants property, and his schedule also doesn't match.
So according to you, the 2004 suit should be decided first.
Please, my lord, that is all.
So
Now
that-
both are set down for arguments. In a matter of 1
He'll
month,
stay
nothing is
ಆಗಿದೆಯಲ್ಲ?
going to.
ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, ಇದು ಸ್ಟೇ ಆಗಿದೆ, ಇದನ್ನು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಗಿದೆ. So if
Argument stage ಅಲ್ಲಿ ಇದ್ದಾಗ you filed this petition.
I filed the petition. I filed section 10 because that is when
It's
my,
this is a 2006 suit.
please,
You filed the petition in 2024.
please.
Uh,
That is when trial
Section
gets
10
over.
application ಹಾಕಿದ್ದೆ ಯಾವಾಗ?
2024, because that is when trial gets completed in the 2006 suit. I
That's all
finished
right.
cross
Then
examination.
what did you do for 18 years?
No, my suit
Why were
was,
you- why
no,
were
no,
you-
my suit was dismissed.
You didn't
2000
know that it is substantially similar?
No,
for
I could
18
not
years?
have, no, I could not have filed a section 10. My suit was not on record. It gets restored only in 2023.
Why?
That was dismissed for
For
10
what?
years. For non-prosecution,
How many years was it lying dismissed?
for 10 years. 2013 gets dismissed, 2023 it gets restored. Now it has reached the stage of final arguments.
ಎಲ್ಲ 10 years ಅಲ್ಲೇ ಇದೆಯಲ್ಲ ಇದೆಲ್ಲ?
20 ವರ್ಷ, ನಮ್ದು ಇನ್ನೂ
ನಿಮ್ದು 20 ವರ್ಷ,
2 ವರ್ಷ
ಡಬಲ್.
ಆಗಿದೆ. 22
20 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿರೋದು.
ಅಲ್ಲ, ಇವ್ರದೇ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು. ಐ ಡೋಂಟ್ ನೋ ವೈ ಇಟ್ ವಾಸ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಸೋ ಲಾಂಗ್. ಮೈನ್ ವಾಸ್
ಅದೇನ್ dismiss ಆಗಿರ್ಲಿಲ್ವಲ್ಲ?
ಅದೇನು ಡಿಸ್ಮಿಸ್ ಆಗಿಲ್ಲ. ಐ ಡೋಂಟ್ ನೋ ವೈ ಇಟ್ ವಾಸ್ ಪೆಂಡಿಂಗ್. ಮೈ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್, my lord, is anyway now 2004 is set down for arguments, and there is a direction by this honorable court to complete the matter within a specified time. So it is being taken up day to day. Now it is on the 11th for final arguments, wherein the plaintiff has to commence arguments. So that would get over. And this suit is listed, I think, this Friday, tomorrow.
How
suit
can it
is-
get listed?
No, stay, but despite stay, my lord, the trial courts give dates,
Oh,
though longer dates. So it is listed tomorrow. So allow me to complete my arguments in the 2004 suit, which will be for a month, for a period of even assuming, my lord, if the trial court passes judgment, because there is a direction, in a matter of 1 month, let this suit be stayed till 1 month, and then it can be taken up. Nothing will happen. They have waited for 20 years, my lord. My suit is also there.
waited for 20 years. So ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ದಿನ ಆದ್ರೆ ಏನಾಗ್ತದೆ?
ನಮ್ ತಪ್ಪಲ್ಲ, ಅದು ಅವ್ರದೇನೆ ಸೂಟ್ ಆಗುತ್ತೆ. They have not prosecuted. So there is similarity is my submission, because I don't change the boundaries. It is the same. My lord, as I gave that example also, if there is a decree, how would the decree also be executed? Because it is the same property.
Problem ಆಗುತ್ತೆ.
That is why, my lord, if
Yes.
But please have section 10 of the CPC. List of dates also I have prepared.
ಅವರು ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. Section 10.
Yes,
Yes.
may I read section 10? No?
Stay of suit.
Stay of suit. No court shall proceed with the trial of any suit. But I'll just pause here. Trial, your lordships is very well, commences once issues are framed.
Yes, correct.
So this application is generally filed at a stage prior to commencement of issues, generally. No court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between, now please mark not, the same parties or between parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court having jurisdiction to grant the relief claim, or in any court beyond the limits of India established or continued and having like jurisdiction or before. But now, a section 10 application can arise only in a context where there is a previously instituted suit and a subsequently instituted suit. So it necessarily requires two suits to exist.
Correct.
Now, Lord, in 2004, the petitioner in this particular petition, Lord, files a suit. Lord, that is OS.
2004 OS.
That is the 2004 suit. Now, let's call it the 2004 suit. It
Yes.
was a bare injunction suit. She only sought for protecting her possession in survey number 3/3B. Because as that sale deed was shown to your lordships, that sale deed concerned 3/3B.
7 guntas over 3/3.
3/3B. In 2004, a suit is filed for protecting her possession concerning 3/3B. Lord, I've given your lordships a chart note.
Yes. Chart ಯಾವ್ದು?
I just passed it over. Please have this chart note. The 2004 suit is on the right and the 2006 suit is on the left. Lord, you lordship will see the prayer in row number 2 on the right hand side. That was the 2004 prayer when she first filed the plaint.
Yes.
By granting permanent injunction restraining the defendants, their men and people from in any way interfering with plaintiff's peaceful possession. Lord, then in 2006, my vendors file a comprehensive title suit for declaring that they are the lawful owners of 3/3B. Now, please see on the left-hand side, Lord, declaring that plaintiffs are the absolute owners having lawful right, title, interest, and possession over the scheduled property. Lord, please turn overleaf, Lord. The scheduled property, I just want to point to your lordship. I've also given page number references at every part. All that piece and parcel of agricultural land measuring an extent of 1 acre 5 guntas being portion of 3/3 later assigned with subdivision number 3/3B. Lord, the boundaries are also given east by west by so and so. So in 2006, my vendors file a comprehensive title suit. Now, in 2009, Lord, before they file that amendment application, your lordship just have my list of dates.
Yes.
This is very conveniently suppressed in the oral arguments. Please see my entry number 3, Lord. On 4/6/2008, Kusuma Kumari, who is the petitioner before your lordships in this petition, institutes a suit OS 3599 of 2008. It's a rectification of title suit. So essentially, she files a suit against her vendors, the one who executed a sale deed, and says, you have wrongly executed a sale deed in my favor. It should have been 17/2A, but our sale deed shows it's 3/3B, goes before the court, arraigns her vendors, and asks the court to rectify the description in the sale deed.
That is dismissed.
That suit is dismissed. That suit is now final. I have filed the memo as well, Lord, on the previous date for rectification of the description in the sale deed. That suit fails. Later, Lord, in spite of that suit having failed, she files a amendment application in her suit in 2004 that your lordship will see is 22/8/2009.
Yes.
And she seeks to amend her plaint prayer and the suit scheduled property.
In 2004 suit.
In the 2004 suit, what was earlier 3/3 and a bare injunction suit, in 2009 and 2010, 2 amendment applications are taken out. In one, she seeks to amend her just the description of the property. What was 3/3B is now changed to 17/2A.
Oh, it's changed already. Yes.
In 2009, by her own case, 3/3B has become 17/2A, in spite of her having failed against her vendors in the 2008 suit for seeking rectification of her sale deed.
Yes.
In 2010, Lord, in entry number 6 on the list of dates, a declaration relief is also sought concerning 17/2A. Now, there ends the matter, Lord. Now, please come to the chart. And in the chart, your lordships will see what I told your lordships is in section 10 applications, there is a triple test. There have to be same parties, same relief, and same subject matter. In this case, Lord, I've also pointed out cause of action paragraphs in both the plaints are completely different. Parties, Lord, in the first column I've shown are completely different. Please see the parties. And most importantly, the subject matter of both the suits are completely different. I've shown your lordships not by extracting the prayer, their own prayer on the right hand side. I've extracted the amended prayer. Please see the 2004 suit on page 1, A.1, Lord, right at the bottom in the chart, declaring the plaintiff herein as the absolute owner in lawful possession and enjoyment of plot number 52, situated in 17/2A. Initially, it was 3/3B. They themselves change it and make it 17/2A in spite of having failed in their rectification suit. Now, please see to the left. Mine is concerning 3/3B. Now, instead of filing, if it was still their case, Lord, it was a genuine application, bona fide plea, that see there is a subsequent suit. I filed my suit in 2004. There's another suit. They should have immediately rushed to the court. 2006 suit only. They should have filed an application saying the cause of action is the same, the relief is the same, the subject matter is the same. Please arrest the suit. Let this go forward. Lord, after 19 years, when it is set down for arguments, so much judicial time has been exhausted, so much cost and expenditure has been exhausted by my client. A Section 10 application is filed, that application is dismissed on the face of it, where the court explicitly records that the subject matter is completely different. Previously, my lord, in 2016, they come with the same plea, my lord. I've shown your lordships that yesterday in the memo. Please have that memo, my lord.
Which memo?
Not yesterday, I just handed over a memo in which I showed your lordship the coordinate bench judgment, because there, in their suit, my lord, they file an application for appointment of a local commissioner. Was it in their suit or our suit? In our suit.
Yes.
In my vendor suit 2006, an application is taken out by them for appointment of a local commissioner to identify whether their 17/2A, which they now said falls within this 3/3B. There, my lord, see what the argument of the defendants were. Please come to page 15, lord, of the memo.
Justice Sunil Yadav.
Yes.
Yes.
The defendants have filed written statement and contended that the second defendant is the owner and possession and enjoyment of land measuring 7 guntas in 7/2A of Ganakal village by virtue of sale deed dated so and so. It is further submitted that the documents through which the defendant is tracing title, including the sale deed, describes the property as survey number 3/3B. Their suit will fail on this ground itself. Your sale deed shows one number, but your suit is filed for a completely different description. On maintainability, the suit will be dismissed in the final arguments. Though the property that has been sold to the defendants in reality, as per the boundaries mentioned in the sale deed, is property in 17/2A. Now, Lord, the learned counsel for the defendant further submits that in light of the defense taken by the defendants and in light of the description of property in the deed of conveyance executed in her favor as 3/3B, in the event that the suit is decreed, the plaintiffs would encroach upon the property of the second defendant, taking advantage of the misdescription of the survey number. Accordingly, it is contended by the learned counsel for respondents that the application filed by the second defendant is indeed the appropriate remedy for the purpose of identification of the property and the court. Now, please see what the court says, Lord, in page 19. In light, para 8, Lord.
Yes.
Please mark that, Lord. In light of the case put forth by the plaintiffs and noticing the defense set out by the second defendant, it is clear that the right claimed by the second defendant, which is Kusuma Kumari, the petitioner, is with respect to property that is other than the property claimed by the plaintiff. So my suit, what I'm claiming is concerning 3/3B. What they are claiming is 17/2A, for which they have filed a separate suit.
Yes.
And the court is very clear on that. If indeed the second defendant is aggrieved by non-identification of a property and by interference of the plaintiff with respect to the property claimed by the second, such a right and remedy is by way of separate proceedings. Same cannot be made subject matter of present proceedings. So this application having filed in the 2006 suit, my suit, having failed, yet in 2024, an application is taken out under Section 10. That Section 10 application is dismissed. They run to this court, obtain stay. Then, Lord, they file a Section 24 application for transfer of the two suits before the same court. And now please see that order, Lord, which is there at page 51, Lord. Just please mark this, Lord.
Yes.
I've given the list of dates. All of this is provided, not just 8 or 9 dates in a 20-year litigation, which is relevant to adjudicate this petition.
Yes.
Now, please see the first paragraph on page 51. This is a petition filed under Section 24, praying to transfer and club the suits in OS 2004 and 2006 to either of the court. Now, suddenly, Lord, what they wanted earlier, just a few months back before they suffered a dismissal, was you arrest one suit, allow the other suit to go, let the first suit get decreed. Now, that having been failed, now what they want is, let both the suits which are being tried by two different courts concerning two different properties be tried together. Lord, it's completely inconsistent. A Section 24 application can be filed either for consolidation or for clubbing. Now, consolidation means it will be merged together into one action. Clubbing is different, Lord. Clubbing means they are two separate actions and they will be clubbed together. They will be clubbed together, which means two separate suits before the same court to avoid conflict of findings. To avoid conflict of findings. So, my lord, the filing of the section 24 application is like a suicide to their own case on the section 10. It's a suicidal argument. The minute you file the section 24, it defeats your argument on section 10. So, my lord, the law on section 10 is very clear. I'm just sharing a list of judgments. The triple test has to be satisfied. I've given your lordship the chart. The subject matter is different. The parties are different, and the cause of action, because I've given a chart on what the issues in the both suits are. Now,
Yes.
please see, my lord, I just want to show your lordships just two judgments. There are more in this, my lord. But just on conduct, I want to show to your lordships, my lord, because if this practice continues, my lord, then suits will go on for 25, 30 years, my lord. Now, my lord, properties itself will not become inheritance. Even litigations will become subject matter of inheritance with these kind of litigants trying to abuse the process in this way. Please come to, my lord, page 23, my lord, of my list of authorities.
Yes.
Para 17, my lord. Coming to the case, sorry.
Yes, tell me.
17.
Hmm.
Coming to the case on hand, as already pointed out, the subject in issue in both suits is identical only with regard to one item of the properties mentioned in schedule in both the suits. All the issues and parties in both the suits are common. That apart, the relief sought in both the suits is also different. As also pointed out, which is a substantial question and which is the incidental, both with regard is not yet decided, and both are pending at different stages. Now, please mark page para 18, Lord. Further significant factor to be noted is that the defendants allowed the trial of the later suit to go on, and only at the stage of arguments the present application is filed. Identical in terms of conduct. In my considered view, this application is definitely at the belated stage. It's also to be noted that when the defendants have the knowledge that the issues in the earlier suit and the later suit are common in all fours, proper application could and should have been made at the threshold if they really wanted to. Now, please come to, my lord, the Delhi High Court judgment of Justice Hari Shankar. Lord, just please see. Lord, please come to page 14, Lord.
Para 20.
Para 20, it starts not the relevant para, but I just want to
27.
show your lordships, he extracts the authoritative judgment of the Supreme Court on page 12. Aspi Jal, I've not separately produced it, it's extracted here. Now, Lord, if your lordships turn to page 13, there is an underline, Lord, basic purpose and underlying object of section 10.
In
Lordships
respect
are
of
there,
the same cause of action. Underlining, right?
that paragraph, Lord. The basic purpose and underlying object of 10
That's good.
is to prevent the courts of concurrent jurisdiction from simultaneously entertaining and adjudicating upon two parallel litigations in respect of the same cause of action, same subject matter, and the same relief.
No, the portion in italics, yes.
Sorry, Lord.
The paragraph, the portion in italics.
Italics, yes, Lord. Just that. Lord, please turn overleaf, Lord.
Yes.
Again, the italics over there, Lord, the italicized parts. But I just want to, the principle that the proposition that I want to use from para 12 in the extracted column is the entire subject matter of the two suits must be the same. The entire subject matter, even if there is one property. In this case, there is only one property in both are different. But even if there are two suits with, let's say, 3-4 properties, one common, that will not attract section 10. Now, please see, Lord. 23, Lord, just para 23. And I'll stop with just reading this judgment, Lord. No doubt, both the decisions have underscored as a fundamental test.
Yes.
This is on page 14.
Yes, yes.
For the purpose of section 10, being whether on a final decision reached in the previous suit, such decision would operate as res judicata in the subsequent suit. That's the test. If the 2004 suit were decreed, will the 2006 suit be hit by res judicata? Now, that can only happen if the reliefs are same, if the cause of action is the same, and the property is the same. So that's principally the
Parties
test.
are also the same.
Yes, and the parties are the same. Now, please come to page 20, para 27 on page 16. Given the rigidity of this test, I'm just reading this to show
Yes.
how he applies the law to the facts. Given the rigidity of this test, the fate of the present petition and indeed the petitioner's application on 10 was preordained. The relief sought in so-and-so and so-and-so is obviously different. CS so-and-so sought a declaration that the sale deed dated so-and-so was void ab initio. CS sought a decree of possession evicting the petitioner from the suit property. By no stretch of imagination can it be said that the relief sought in the two suits were identical. Apart from the sameness of relief, the two other indicia required to be cumulatively satisfied in order for the trial of a later suit to be stayed under 10 is identity of cause of action and identity of subject matter. Neither cause of action nor subject matter of the two suits can be said to be the same. The cause of action related to validity of the sale deed, so and so that related to this, and then he goes on. So Lord, this shows what the law is and how that law has to be applied to the facts of this case. Lord, I have given your lordships a chart to show that the parties are different, the issues are different, and the subject matter is completely different. And in fact, the filing of the section 24 shows how malified this entire litigation is now turning out to be. 20 years later, you file a section 10, you arrest my suit, and now you want to litigate there, Lord. Lord, I would only request lastly, Lord, some timeline has to be fixed, Lord. Otherwise, Lord, there has to be some priority given to a 2006 suit. Otherwise, day in and day out, these suits will just be pushed, and footballed all the way ahead. Man. That's my respectful submission.
Yes, madam.
My lord, my rectification suit, I was told in the court that I have suppressed filing of rectification suit. I can't make the same
Orally,
submission
Lord.
to
Orally
my
suppressed, I
orally.
said.
I can't make the same submission to my learned friend who's a junior
So
who's
like,
entered appearance now, because there is an RFA file where his client has already entered appearance in July of 2024.
I'm aware
So
of
that is conveniently suppressed by my learned friend. Now
RFA, there
coming
is no
back to
stay.
the
That is
law.
all right.
RFA,
Suppression
there is
of-
no stay.
Please, my lord.
Alleged suppression versus suppression.
Please.
That RFA was filed 14 years after the dismissal. The condonation
That
of
is-
delay application is not yet allowed. So,
No,
in
that is
fact, it is
pending
not yet pending.
consideration.
If the condonation of
Pending
delay is not allowed,
consideration. So-
it's not instituted yet.
If my learned friend
Yes.
has finished,
All right.
I will address.
Yes, madam. You sit. Take this.
My lord, the main contention is it has to be same. Language in section 10 is substantially similar. Parties are substantially similar. It need not be that the party A should also be here in party. The contesting parties are same. It is about the same property.
Plaintiff
Though
is
the-
different. Plaintiff
Same.
is different.
Same.
Plaintiff is same.
The
Given the
plaintiffs
chart,
here,
let me see the
plaintiffs here in the 2006 suit are the defendants in my suit.
Ah.
I am the defendant in their suit along with other landowners, my lord. I am made the defendant. By filing that suit, my lord, they admit that I am there next to their property and that I am causing interference. 2006 itself, their argument is I should have run to the court. I should have filed a section 10. That did not arise till 2009. When I did a survey, that is when I came to know that there is a discrepancy as far as the survey number is
So
concerned.
17/2A you claimed.
Please, that's what the survey has denoted. They also rely
Now,
on,
if you have claimed or corrected it to 17/2A, then how are you now saying 3/3B is the same?
because my sale deed says that.
You have yourself
3/3B.
got it corrected now.
No, I have made an application to, I have amended in the plaint. It is
you have-
subject to the result of that, my lord. I have to prove that I am in 17/2A. 3/3B, anyway, I am intact because the sale deed
So
itself
according to you,
shows.
3/3B is incorrect. 17/2A is what is correct.
Please, my lord.
If that is the thing, how are both the suits the
My lord,
same?
their
Because
property
one,
itself.
this is 2006 suit is 3/3B and according to it is 17/2A. The two
These
are entirely
17/2
different now.
and 3/3 are adjacent properties. So there is encroachment by this person is what our contention is. And also, my lord, the trial court in 2004, while confirming the interim order in 2005, categorically identifies that this is a vacant property and this defendant is interfering. Hence, the vacant property needs to be protected. That is why there was an order of status quo which has continued for 22 years. I have the order of status quo as on today also. Post restoration of the suit.
That is in 2004 suit.
2004 suit.
All right.
Post restoration of the suit, my lord, the interim order
That
has
is
also
going
been.
on, that will go on.
That is listed for argument.
That's all right. That is nothing to do with this.
No, it is part of this
No,
property.
no, 2004 suit, what is happening is going on.
Yes.
That will go on.
No,
It
that
went, it went on for 20 years. It will go on now also.
No, it
it
is
is
listed
on-
for final arguments and it is now set down for final arguments. In a matter of a month, the order will also be passed because there is a
So we are not
direction.
concerned about 2004 suit.
No, that is the subject matter. My section 10 is arising out of my 2000. If there was no suit, I wouldn't be before you,
Correct.
lordships.
There should be two suits for
There
section
must be,
10.
that's basic, my lord. Two suits are there. Subject matter is same. Parties are same. Defendants in the 2006 suits categorically say, not only me, other defendant also.
Correct. Why
that
did
it needs to
you
be
did
sued.
not realize that for 20 years?
No, my suit was not even there on board. My suit
It
came on
came
board.
back on board when?
Twice their suit
2023.
has got dismissed for non-prosecution.
When did it come back on board?
2023 of August.
Oh,
They
10 year
complete
gap, you told me.
Yes.
Yes, yes.
They complete their trial only in 2024 April. That is when, well, a trial would mean even arguments. It is not that trial would mean only recording of evidence. It would mean arguments also. Once the trial got completed, that is when the subsequent purchaser, well, not
No,
subsequent purchaser.
trial either in civil or criminal law, it is issues and charges framed there.
Well,
Trial would commence only then.
trial would commence, but it wouldn't get completed just because evidence is completed.
No, trial,
It would continue.
trial beginning is after framing of issues,
Issues.
culmination is by a decree.
Decree, that is what.
Or
Their
a
argument,
rejection, whatever it is.
Their argument is at the time of arguments you have filed, that would, because defeat the very purpose of section 10. Section 10 says you will not proceed with trial. No court will. So my submission is, because the subsequent purchaser completes his examination only in 2024, that is when I filed my section 10.
All right.
As the subject matter is similar, my lord, and parties are same.
Just 2 points in reply.
When it got dismissed for non-prosecution in 2013,
Please,
the suit was in 2006, the subsequent suit.
please.
For 6 years, you could have done something. That also
I amended
7
it
years.
only in 2009.
Huh?
I amend my plaint only in 2009. That is when a survey is done. That is when I realized that it is in
It is
17
different.
bar 2A.
That's when you realize that both
Larger-
are different.
No, the larger picture, my lord, may I reiterate? It's a 1 acre 5 guntas land, what he's claiming. I am
ಅದರಲ್ಲಿ
claiming
7 ಗುಂಟೆ
some-
ನಿಮ್ದು.
ಅದ್ರ ಒಳಗೆ ನಂದು 7 ಗುಂಟೆ ಇದೆ. Is my concern. So if there is a decree in both the suits, what would happen to the parties? Yes, all this fine argument of 20 years, 40 years is good. What would happen? Ultimately, what would happen to the parties? Both of us are at the stage of receiving judgment from courts. In a span of 1 month, what will happen?
We'll see.
In
Yes.
fact, previously instituted suit is not to simply see which suit is first in point of time. In their 2004 suit that they first filed, that was a bare injunction suit. In 2006, I filed a comprehensive title suit. They then later amend their suit to a comprehensive title suit concerning a different property. So if anyone is a previously instituted suit, it's actually my suit. On that ground, itself the
2006
section 10.
suit.
Mine, because they then later amend and add a declaratory relief concerning 17 bar 2A. So in fact, on the maintainability aspect itself, it should be dismissed.
Well answered.
Second, it says no court shall proceed with the trial, which means you don't wait till the trial is halfway into completion of trial and then file that application.
Publish.
Heard reserved. Entry order ಇದೆಯಾ?
Either.
Heard reserved. Entry order subsisting would continue till the disposal of the petition.
So great.
Please.
Ayurali Parmeshwar Hegde. Baby Patil has come. Patil ಅವರೇ, ನಿಮ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗೀತಾ?
It got adjourned, my lords, to the 25th because we were not able to file a paper book. We have to instead file a convenience volume is what
ಇಲ್ಲೇನ್
we saw.
ಬೇಕಾಗಿಲ್ಲ ಹೇಳಿ.
Of late, B.B. Patil is really enjoying the arguing matter at the appeal court. He is
Contesting against my
Oh.
friend Hegde, my lords. That's all I am enjoying.
ಇದು it is covered ಅಂತ ಹೇಳೋದು.
No, my lords, my only request is,
Puneet Sabharwal also have considered in this Attar Mohammed.
I've noticed that. My lords, I've considered it. There is one more judgment in 24, my lords. That one apart. There are some discrepancies, my lords, which I want to point out in the impugned order. For instance, my lords, he says that he grows ragi and hurli in his RTC. But whereas the bills shown are for sugarcane. Now this is 3 lakh rupees cash was found in his house.
Oh.
And not to mention this, my lords, there is a requisition by the adjudicating authority for about 11 witnesses to come. Notices were issued.
All of them have come in the
No,
department.
11 of them ಹಲವಾರು ಬಾರು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಬಂದಿಲ್ಲ ಅಂತ ಅವ್ರ ಫೈಂಡಿಂಗ್ ಇದೆ.
ಯಾರ್ದು?
ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಅಲ್ಲ, ಈಗ witnesses examined in the
Page number
now the
191.
investigating officer is examined.
Please, my lords.
Investigating officer is examined.
Please, my lords.
All right.
Prosecution witnesses are examined in the departmental inquiry.
Some of them have been dropped here in the charge sheet, some of them have been witnessed there.
Notwithstanding the same, the inquiry officer by an elaborate report on evidence holds that the charges are not proved. The disciplinary authority accepts it and closes it. If a particular allegation is not proved in a case where it has to be in a case where probabilities have to be preponderant, probabilities, then where will you prove it beyond reasonable doubt?
That is why, my lords, when we, as late as 2024, the Honorable Supreme Court, an appeal from this court, my lords, went, where the case was taken up, there is some other evidence which we want to rely upon. Based on that, the matter stands remanded. I can produce that judgment. Now, my lords, 11 of them, page number 191 ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ 11 of them we have issued ಸಾಕ್ಷಿದಾರರಿಗೆ ಹಲವಾರು ಬಾರಿ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಲಾಗಿದ್ದು ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗದ ಕಾರಣ ಸದರಿಗಳನ್ನು ವಿಚಾರಣೆ ಮಾಡಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. So 11 people by his own admission, they may be necessary, whereas in a criminal proceedings he can't say I won't come. That may have a bearing is my respectful submission. I'm not saying, my lords, that
this has become final anyway.
My lords, now
ಇದರಲ್ಲಿ 3 ಲಕ್ಷ ಕ್ಯಾಶ್ ಬಂದಿದೆಯಾ?
It's not the part of the
charge sheet part, not a part of the charge sheet. Even in this, even in the criminal trial?
Yes, my lords, may kindly come to the charge itself, my lords. Charge itself. Page number ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗಿದೆ, 190 ಅಂತಿದೆ ಇದು ನಮಗೆ. 190 ಅಂತ.
190 ಅಲ್ಲಿ ಅವ್ರದ್ದು ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಇನ್ಕ್ವೈರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ಡರ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಚಾರ್ಜಸ್ ಏನ್ ಫ್ರೇಮ್ ಆಗಿದೆ?
ಚಾರ್ಜಸ್
ಇದೆ ಕೊಡಿ.
There are 3 charges. One is regarding disproportionate assets. The second charge is not submitting of the assets and liability statement.
You have not submitted?
Assets and liability complete ಆಗಿ ಕೊಟ್ಟಿಲ್ಲ, ಮಧ್ಯದಲ್ಲಿ ಮಿಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. So charge number 1, so far as the disproportionate is concerned, it is not only
ರಿಟೈರ್ ಆಗಿದೆ ಯಾವಾಗ?
Let's 21-22. Let's the first charge is regarding the disproportionate. The second charge is regarding the assets and liability.
This is in the departmental inquiry.
ಹೌದು. Let's
departmental inquiry ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ ಅವರು. He says 3 lakhs cash was found in his house.
ಹೌದು, please.
At the time of search. How have you explained it?
Charge sheet. My lords, may kindly come to page number. Column number 7. It starts from, my lords, at page number. Page number 160. Page number 160.
160.
160. ದಿನಾಂಕ 6/9/80 ಪೊಲೀಸ್ ಇಲಾಖೆಯಲ್ಲಿ ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಆಗಿ ಸರ್ಕಾರಿ ಸೇವೆಗೆ ಸಲ್ಲಿಸಿ 20
ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್
at the time of retirement,
ಆಮೇಲೆ
joined as a
assistant commissioner of police,
ACP.
Yes. Let's column number 7, last
column number 7 is at 160 here.
ಸೇವಾ ಅವಧಿ 6/9/80
ಮುಂದುವರೆದಿದೆ
72 ಮುಂದುವರೆದಿದ್ದು. Page number 179. Page number 179. That is included in the whatever the amount found in my house, that has been included in the asset portion,
not liability. Yes. ಆರೋಪಿತರ ಕುಟುಂಬದ ಒಟ್ಟು ಆಸ್ತಿ ಇದೇ ಪ್ರಾಬ್ಲಮ್.
The same is the charge.
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ಇದಿರಲ್ಲ.
My lords, that is why I say it is a little too late in this stage, because we can understand, my lords, if the trial had not even commenced. Why make him go through the rigmarole of a trial is also an argument. Here is a case where charge sheet is already filed, trial is yet to, it's almost on the way.
Charge frame ಆಗಿದೆಯಾ?
Evidence
ಮತ್ತೆ charge frame ಆಗಿ ಬಹಳ ದಿನ ಆಗಿದೆ.
Witnesses are going, and that's why ಆ ಚಾರ್ಟ್ ಒಳಗಡೆ ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ
ಮಾಡಿಲ್ಲ ಅಂತ ಚಾರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದೆ. PW1 ಯಾರು, PW2 ಯಾರು. ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ it's a matter of just weighing the balance, my lords, and coming to a conclusion.
Matter of weighing the balance. You have nothing that to tilt the balance.
I leave it to my lords. I only now, my lords, I'm relying on one judgment, my lords, of 2020. I'll give it.
ರಿಮಾಂಡ್ ಆಗಿರೋದಲ್ವಾ?
Remand again. Remand, Supreme Court. Ad one day, saying that there is some additional evidence. Adnon bitter, I can rest my arguments, my lords may deal with it as my lords see.
We'll dictate it
Please.
next on Wednesday. We'll post.
Please.
And reserve ಮಾಡಿದ್ರೆ ಎರಡು ಆಗ್ಲೇ ಮಾಡಿದೀವಿ, pile up ಆಗ್ಬಿಡುತ್ತೆ.
My apologies, my lords, I was on my legs in another court.
No problem. You're on your legs.
Please, oblige.
Continue ಮಾಡಿ. Mood matters.
Morning I
ತಗೊಳ್ಳಿ. ಮಾಡ್ವಾ ತಗೊಳ್ಳಿ.
One serial number 86, one then.
ಒಂದ್ ನಿಮಿಷ, 2:30 ಮೂರ್ ಮ್ಯಾಟರ್ ಇದೆ, ಮೂವ್ ಮಾಡಿದ್ದು.
Survey number 45 and 46.
Yes, Chandrasekhar, what's the problem? ಅಲಾಟ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಇವ್ರದ್ದು?
ಅಲ್ಲಲ್ಲ, preliminary notification was issued earlier. A preliminary notification was issued. After that, Malala filed objections. Objections were filed, order was passed. The land action officer recommended the lands are not suitable for the grave girdle was there. After that, Malala, no denotification issued by the government. Now, the petitioners here in Malala, the question only subsequent note issued by the land action officer. Without challenging the preliminary notification, state is not a part, made a parties. The acquisition is by the state, Malala.
ಇದರಲ್ಲಿ ಸ್ಟೇಟ್
Party ಮಾಡಿಲ್ಲ. Acquisition is by the state only.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
Lord, 6/6/2025, they have fixed the hearing,
ನಾಳೆ ಡೇಟ್ ಇದೆ
which has.
Defer it for a week. Yes.
what-
Who has fixed?
Pardon,
land action officer.
ನಿಮ್ಮ SLAO. Yes. You implead the state as a party.
Yes.
Actually, my submission is, I have to question notification also. It's better.
Correct. Bring the proper writ petition.
Not, it's as if it is.
ಎರಡೂವರೆಗೆ ಮೂವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಏನೇನೋ ಮಾಡೋದು ಬೇಡ.
It's not maintainable. That is my submission.
ಎಲ್ಲ ಮಾಡಿ. Yes. Heard the learned counsel appearing for the petitioner and
I may
learned
permit
counsel.
to take notice, Malala.
Correct. ನಿಮ್ heard ಅಂತ ಹೇಳಲ್ಲ. Learned counsel Chandrasekhar is directed to accept notice for the respondent board.
Both the response.
Two ಅಲ್ಲ? Two and?
One and two.
The petitioner shall implead the state as a party respondent to these proceedings. ಇಲ್ಲೇ ಮಾಡಿ. Learned AGA is directed to accept notice for the respondent. The learned counsel for the petitioner submits that the SLAO has kept his hearing for tomorrow with regard to the land in which the petitioners have a claim. The learned, in the light of the impending situation, I deem it appropriate to direct the SLAO to defer his hearing qua the subject land, qua the land that is the subject matter of the present petition till the next date of hearing. List on 2 weeks ಕೊಟ್ಟಿರ್ತೀನಿ. The learned counsel Chandrasekhar to secure instructions and make his submissions. List on 18th. 18th ಅಲ್ಲ, 19th. Yes. Amend ಮಾಡಿ ಈಗಲೇ.
Very good.
Yes.
one submission, your lordship. 230 moved matter.
Wait,
file is
madam.
investing. They have not sent the file, your lordship.
ಆ ಕೋರ್ಟ್ಗೆ ಹೋಗಿದೆ ಮೇಡಮ್.
Instructions, your lordship.
ನಮಗ್ ಬರಲ್ಲ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, your lordship.
ಫ್ರೆಶ್ ಪೆರೋಲ್ ಇಲ್ಲೆಲ್ಲಿ ಬರುತ್ತೆ ಮೇಡಮ್?
On that day, it was.
ಅಯ್ಯೋ,
listed.
that day the court was not sitting, so I took it. ಫ್ರೆಶ್ ಪೆರೋಲ್ ನೀವು ಮೂವ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ. ಎಸ್. ಅದೇ ಮ್ಯಾರೇಜ್ ಪೆರೋಲಾ? ನೀವು ಅಲ್ಲೇ ಮೆನ್ಷನ್ ಮಾಡಿ. ಎಸ್.
FTP court, my lord, without jurisdiction, passed an order by appointing assistant executive engineer as court commissioner to division of the properties.
1, 2, 3, 4. Petition, emergent notice to the respondent's petitioner.
Respondent number 5 is the only contesting party. Other parties are executed, relinquished it in favor of us.
ಮತ್ತೆ ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದಿರ?
ಅಲ್ಲ, ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ.
Respondent number 5.
Yes, is the only contesting.
That is Sidlingama.
Yes, please, my lord.
Learned counsel submits that the contesting respondent is only respondent number 5. Therefore, the petitioner shall serve on the counsel who represented the respondent number 5 in the execution proceedings. the
FTP proceedings.
FTP, final decree proceedings. The learned, ಬೇರೆ ಯಾರು ಬೇಡವಾ?
ಬೇರೆ ಯಾರು ಬೇಡ. Other parties are executed relinquished in favor us.
Less the matter on 16th in preliminary hearing till such time the concerned court shall, till such time there shall be an interim order of stay as spread for. Next.
Memo for hand delivery.
ಯಾಕೆ ನಾಳೆ ಇದೆಯಾ?
ನಾಳೆಗಿದೆ, ನಾಳೆಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್.
ಉಮಾಶಂಕರ್.
ಅದರಲ್ಲಿ ಫಸ್ಟ್ petitioner died. ಎಲ್ಲ
Respondent counsel ಯಾರು ಇದಾರಾ? Sorry, in terms of the compromise ಮಾಡ್ತಾರೆ. Yes. Anyway. Yes. Now the suit is closed in terms of the compromise. Yes. That's, that ಇಲ್ಲಿ
proceedings ಅಲ್ಲಿ appointment of commissioner ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ.
Correct.
ಎಲ್ಲ ಪಾರ್ಟೀಸ್ ಇಲ್ಲೇ ಕಾನ್ಫರೆನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಇಲ್ಲೇ ಡ್ರಾ ಮಾಡಕ್ಕೆ ಹೇಳುವ. We'll see. Yes.
Is an order to that effect?
I will pass an order to that. Why is Krishnamurthy sir waiting? ಒಂದು ನಿಮಿಷ ಕರೆದು ಬಿಡ್ತೀನಿ. Yes. 90? Government ಈಗ ಕಾಸ್ಟ್ ಎಷ್ಟು ಇಂಪೋಸ್ ಮಾಡೋಣ?
ಕಾಸ್ಟ್ ಬೇಡ ಸ್ವಾಮಿ.
ಸೀನಿಯಾರಿಟಿ ಹೋಯ್ತಲ್ಲ ಮತ್ತೆ 8 ತಿಂಗಳು.
That may be but cost no.
That may be ಹೆಂಗೆ?
Because his husband itself is earning more than 33 lakh rupees and 33 lakh rupees per annum. Husband, but that was not considered. Not cost ಬೇಡ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಒಂದ್ ಸಬ್ಮಿಷನ್ ಮೇಲಾಡ್ ಅವರು ರಿಟೈರ್ಡ್ ಆಗಿದೆ, ಅವ್ರದ್ದು ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅವ್ರಿಗೆ ಪೆನ್ಷನ್ ಸೆಟ್ಲ್ ಮಾಡಿಲ್ಲ. And one more thing, because of the part on the part of the state, Milad, she has to.
I accept lot of.
ತಾವು ಲತಾ ಕೇಸಲ್ಲಿ ಸಂಬಳ ಕೊಡ್ಸಿದ್ದೀರಾ 3 ತಿಂಗಳದ್ದು ಆಯುರ್ವೇದಿಕ್ ಇದ್ರು.
ಬೇರೆ citation
8 ತಿಂಗಳ ಸಂಬಳ ಕೊಡ್ಸೋಣ.
8 ತಿಂಗಳ ಸಂಬಳ ಕೊಡ್ಸಿ.
ಕಾಸ್ಟ್ ಬೇಡ ಇದರ ಮೇಲೆ.
ಕಾಸ್ಟ್ ಅಲ್ಲ ಸಂಬಳ.
ಸೀನಿಯಾರಿಟಿ ಪ್ಲಸ್ ಸಂಬಳ.
ಸೀನಿಯಾರಿಟಿ ಈ ಕೇಸಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ has to be considered ಅಂತ.
ಕನ್ಸಿಡರ್ಡ್ ಅಂತ ಮಾಡೋಣ.
ಪ್ಲೀಸ್.
ಬಟ್ 8 months ಡಿಲೇ ಆಗಿದೆಯಲ್ಲ.
ಹೌದು. 8 ಇಲ್ಲ 10 ತಿಂಗಳೇ ಆಗುತ್ತೆ because application was uploaded on 27/6/23.
Rest of the things I like.
No, the government servant should know if he steps into the shoes of the petitioner.
Then it's.
ನಿಮ್ಮ ಒಂದು ವ್ಯಾಲಿಡಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡದೇ ಇರೋದಕ್ಕೆ 8 ತಿಂಗಳು ಡಿಲೇ ಆಗಿದೆ. The next colleague has joined and earned salary for 8 months. What happens to her seniority? What happens to the 8 months agony?
Persons or somebody, it has to be somebody.
So these government officers, they take these people for a raid. Hey, validity certificate tane kodana bidu.
Maybe the officer may be important, but
officer
ಅಲ್ಲ ತಾವಾದ್ರೊಳಗೆ ಆಫೀಸರ್ ಇಂದ ರಿಕವರ್ ಮಾಡಿ ಅಂತಾನೆ.
In the terms of cost.
That's not correct.
Salary.
8 ತಿಂಗಳು ಹೋಯ್ತಾ ಈಗ? Salary government ಕೊಡಲ್ಲ. Officer, I will ask the officer to pay from his pocket.
Then it's.
ಅಲ್ಲ 10 ತಿಂಗಳೇ ಆಗತ್ತೆ. 27/6/23ಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಅಪ್ಲೋಡ್ ಮಾಡಿರೋದು. 13/4/24 27/6/23 where she sought for validity certificate and she got the appointment order on 13/6/24.
ಒಂದು ವರ್ಷ. Why after I directed the certificate was given?
After taking long time election ಇದೆ ಅದು ಇದು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದೇ.
The rest of the question of law, I accept my lord with respect to that, but.
On 22/4/24, I said if you don't put your house in order, I will impose exemplary costs. ಅದಕ್ಕೆ next day ಕೊಟ್ಟಿದ್ದೀರಾ. ಅದಕ್ಕೆ 1 ವರ್ಷ ಆಗಿದೆ ಅಲ್ದಾಡ್ಸಿ ಅವರು. Pillar to post for no reason.
ಒಂದ್ಸತಿ DC ಮುಂದೆ ಹೋಗಿ ಅದು ವಜಾ ಮಾಡಿದ್ರು, ಕೊಡ್ಲಿಲ್ಲ, ಅಪೀಲ್ ಹಾಕಿದ್ರು. ಮತ್ತೆ ಅಪೀಲ್ ರಿಮೈಂಡ್ ಆಯ್ತು. ಮತ್ತೆ DC ಮುಂದೆ ಸೇಮ್ ಆರ್ಡರ್. Again appeal was filed against that order. It petition is.
ಕೊನೆ ಕೊಟ್ರಲ್ಲ.
ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. She has joined duty.
ಅಲ್ಲ ಬಟ್ ಅದ್ ಮುಂಚೆನೆ ಕೊಡಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್? Why do you make every person,
Family, they treat that husband is also there.
that is settled law, sir.
Yes. As per this honorable court judgments itself, it may be pronounced, but only I am seeking for.
We'll see. We'll ask the entire salary to be recovered from the pocket of the officer who has kept the file for 1 year and denied 1 year salary to this candidate who is selected, the lady who is selected.
Maybe as I previously accepted 1 month or 2 months.
1 month salary, yeah. Not.
Nothing. And who will pay the 11 months salary?
We'll
ಅವ್ರೆ
see.
ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಏನಾಗಿದೆ ರಾಂಗ್ಫುಲಿ ಇಬ್ರಿಗೆ ಇದ್ ಕೊಟ್ಬಿಟ್ಟಿದಾರೆ ಅಂತ ಅದು ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
Not,
ಪೆನ್ಷನ್
not.
ಸೆಟ್ಲ್
Who will pay
ಮಾಡಿ
ಅಂತ I will write.
ರಿಸರ್ವ್ ಮೇಲೆ
Reserved.
ಪ್ಲೀಸ್.
ಮತ್ತೆ ನೀವೇನ್ ಬರ್ಬೇಡಿ ಇಲ್ಲಿ ರಿಸರ್ವ್.
Shall I give?
ಅಂದ್ರೆ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಮಾತ್ರ.
ಇಲ್ಲ ಇಲ್ಲ ರೋಸ್ಟರ್ ಕೇಸಿಗೆ ಬರ್ತೀನಿ.
ಆ ರೋಸ್ಟರ್ ಕೇಸ್.
In terms of Akshata.
ಕರೆಕ್ಟ್ ಚೌಗ್ಲೆ. ಅಕ್ಷತಾ ಚೌಗ್ಲೆ. ಎಸ್.
ಆಮೇಲೆ ಲತಾ ಕೇಸಲ್ಲಿ ತಾವು ಆಯುರ್ವೇದಿಕ್ ಇದೆ.
ಆಯುರ್ವೇದ.
ಅದು ಅವ್ರು ಜಾಸ್ತಿ ಕೇಳ್ತಾ ಇದ್ರು ಸರ್, ನಿಮ್ದು ಕಡಿಮೆ ಕೇಳ್ತಾ
ಅದು 3 months ಸ್ಯಾಲರಿ ಕೊಡ್ಸಿರಿದಾರೆ, 3 months ಲೇಟ್ ಆಗಿದೆ ಅಂತ.
ಆಯ್ತು, we'll see. ಎಸ್.
That I.
We'll see. Reserved, yes. Next. Continue ಮಾಡಿ. Yes, Sandeep Patil.
An order passed by the Assistant Commissioner in exercise of power under section 136 subclause 2 in appeal is now made as a subject matter of a complaint by the Forest Department that
Yes.
it is in violation of
Interim objection ಹಾಕಿದ್ದೀರಾ?
I filed my objection, sir.
Lordship.
The person
The
exceeds
punishment
his
is 15 days.
ಹೇಳಿ.
The punishment is 15 days.
ಏನ್ 15 days?
15 days is the punishment under Forest Conservation Act.
15 days what?
15 days of imprisonment.
ಅದೇ ಹೇಳಿ ಮತ್ತೆ. 15 days, 15 days.
15 days of imprisonment.
ಹ್ಮ್.
Now 468, Lord, the time for filing this and taking cognizance is 1 year
ಹ್ಮ್.
from the date of offense.
ಏನ್ ಮಾಡಿದಾರೆ ಈಗ?
Lord, beyond 2 years, this complaint is filed and cognizance is taken beyond 2 years.
Complaint is beyond 2 years?
Yes, complaint is beyond 2
Cognizance
years.
ಯಾವಾಗಾರು ತಗೊಳ್ಳಿ.
Complaint is beyond 2 years. Kindly have a look at this.
Where's the complaint?
Lord, page 19. Kindly come to page 33.
Hmm.
This complaint is dated 25/1/2024.
Correct.
Now, next page, 33,
Hmm.
cognizance is taken on 31/1/2024.
Cognizance ಯಾವಾಗ ಬೇಕಾದ್ರೆ ತಗೋಬಹುದು. Don't worry about cognizance.
25/1/2024, but actually it was filed on 27/1. Kindly mark that date, 27/1/2024.
5/1/2022 is the incident.
Yes,
Correct.
yes,
It is at page 35.
that's right.
Complaint is registered on 25/1/2024.
27/1/20,
ಆಯ್ತು, 27/1/2024.
beyond 2 years.
ಸೊ 2 ವರ್ಷ ಆಗಿದೆ. ಜಗದೀಶ್ ಸರ್, ಅದಕ್ಕೆ ಗ್ರೌಂಡ್ 468.
No, it is, offense may have committed whenever, but when did I come to know about the offense?
Oh.
That is the law.
Yes, sir. When did you come to know, sir?
Sir, immediately upon come to know, we have sent a report and.
When
okay,
did you come to know?
Their parties
No, no.
before the very same accused.
ಆಯ್ತು, ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
Yes.
ನಾಳೆ ರಿಪೀಟ್.
Please.
ಎಸ್, ನಾಳೆ ವರ್ಕಿಂಗ್ ಡೇ ಅಲ್ಲ ಅಂದ್ರೆ ಮಂಡೇ. It will be repeating till it is over.
Please.
Yes. Yes, next. 84 ಏನಾಯ್ತು? ಆಯ್ತಲ್ಲ ಅದು? ಹಾ. Yes, Mohammed Azharuddin. Repeat Monday. Yes. Yes, Raju sir, ಇದೇನು?
Yes, my lord. Matter relates to certain works that were carried out in the village panchayat.
Objection ಹಾಕಿದ್ದೀರಾ?
Objection ಹಾಕಿದೀವಿ.
ಹಾ,
ಹಾಕಿದ್ದೀರಿ?
Yes, please, my lord.
ಹಾಕಿದ್ದೀರಾ? ಆಯ್ತು.
Lord, this
Next
is-
week continue ಮಾಡೋಣ.
Please.
Yes, Monday or Tuesday, it will get repeat. Ask Patil to be ready.
Yes, please.
Yes, next.
Interim order to be continued.
Interim order will continue. Don't mention about it.
For the respondent, we are ready in the matter, maybe passed over.
ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಇಲ್ಲಲ್ಲ?
330 list.
Why is it before me?
Preliminary
Surface
hearing,
proceedings.
Yes. Preliminary hearing,
ಇದಿವಾ?
B group.
ಇದ್ಯಾಕಪ್ಪ? It's surface ಅಲ್ಲೇ ಬರ್ regular court. Release the matter from the status of being parted, post the matter before the bench having roster. Next. Yes, Keshav, ಇದೇನು?
My lord, this is that slum matter, my lords. I was represented by Mr. D.R. Ravishankar. He had argued it at length.
I know, but
But
what is
senior is unavailable today, my lords. He's
is unwell.
He's
ಆಯ್ತು, next week repeat ಆಗುತ್ತೆ.
Great, my lord. Wednesday or Thursday, my lord.
It will come. If you're not, no harm. It will keep repeating till it is disposed. Don't, whenever you come, you argue. Yes.
Great. My lord, interim order.
That will continue, sir. Jagdish, sir. ಏನಿದು ಬೇಡ ಜಂಗಮ ಅದ? ಎಸ್ ಸರ್, ಹೇಳಿ. ಇದು ಇವತ್ತಿಗೆ ಕಾಲ ಕೂಡಿ ಬಂದಿದೆ, ಮುಗಿಸೋಣ. ಎಸ್, ಮಾಡಿ. ಅರ್ಜೆನ್ಸಿ ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದು.
ಅಲ್ಲ ಸರಿ. My request is, first two matters may be separated and other two matters may be taken up.
ಆಯ್ತು, ವಿಲ್ ಟೇಕ್ ಇಟ್ however you
ಬೇಡ
want.
ಜಂಗಮನೆ ಸೆಪರೇಟ್ ಆದ್ರೂ ಅಲ್ಲಿ ಜಂಗಮ
ಆಯ್ತು, ಸೆಪರೇಟ್ ಆದ್ರೆ
ಹೋದ್ರು ಬೇಡ ಜಂಗಮನೆ. ಏನಕ್ಕಾದ ರಿಸರ್ವೇಶನ್ ಅಪ್ಲೈ ಮಾಡ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ.
That is not the, and in the first matter, I am filing a memo.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ. The government has taken certain action in this regard. I will take first one only. Itawali. Madam. The first writ petition.
What is this?
In the first writ petition, I have sought for a direction to take action against the respondents who have violated the orders of this honorable court in the sense.
Which respondent has violated the order, sir?
That is,
Lord, this is in respect of some other case. So, caste certificate ಕೊಟ್ಟಿಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ಅವ್ರ ಮೇಲೆ. ಜಂಗಮರ್ಗೆ ಬೇಡ ಜಂಗಮ ಕೊಟ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು. ಅಲ್ಲಿ ನೋಡಿ
ಅವ್ರು ಮುಗಿಸ್ಲಿತ್ತಾಳೆ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಮುಗಿಸ್ಲಿ.
first matter, I have sought for an action against the respondents 5 to 9.
Have failed to take action in discharge of their duties.
No. See, they have violated the orders of this honorable court. The order is.
Allah, action against respondent 5, 6, 7, 8 and 9.
Yes.
ಯಾರವರು?
I have made them.
Social welfare officer, DCVC, assistant commissioner, grade 2 ತಹಸೀಲ್ದಾರ್. ಇವ್ರೇನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಲ್ವಾ? ಹಾಕಿದ್ದೀರಾ ಎಲ್ಲ?
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ.
ಅಲ್ಲ, ಅವರು ಬೈ ನೇಮ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಬೈ ನೇಮ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ದೇ ಆರ್ ರೆಪ್ರೆಸೆಂಟ್. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದ್ರಲ್ಲಿ ಅವ್ರು ಹಾಕ್ಬೇಕು. I will demonstrate before my lords whether the writ itself is maintainable or not. ಯಾರಿಗೋ ಕಾಯಿಲೆ ಬಂದ್ರೆ, ಯಾರಿಗೋ ಗುಳಿಗೆ ನುಂಗಿದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? What is their locus?
ನಿಮಗೆ ಕಾಯಿಲೆ ಬಂದಿಲ್ವಲ್ಲ?
ಅಲ್ಲ, ಲೋಕಸ್ ಸ್ಟ್ಯಾಂಡ್ ಇನ ನಂತರ ಕೇಳೋಣ. ಇವನ್
ಅಲ್ಲ, ಅದು ಕಟ್ ಸೆಟ್ ದಿ ರೂಟ್ ಆಫ್ ದಿ ಮ್ಯಾಟರ್ ಫಸ್ಟ್. ಅದು
ಮನುಷ್ಯನೋ ಮೃಗನೋ ಅಂತ ಫಸ್ಟ್ ಡಿಸೈಡ್ ಆಗಬೇಕು.
ಇದು ನೀವು ಸುಮ್ಮನೆ ಇರಿಸಿ.
ಅಲ್ಲ, ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್
ಯಾಕೆ ಈಗ ಹೇಳ್ತೀವಿ ಅಂದ್ರೆ, ಮೊನ್ನೆ ಬೇಡ ಜಂಗಮ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಏನ್ ಎಲ್ಲರೂ ಸೇರ್ಕೊಂಡು ಓಹೋ ಇವ್ರಿಗೆಲ್ಲ ಬೇಡ ಜಂಗಮ ಕೊಟ್ಬಿಟ್ರೆ ಏನಾಗಬೇಕು? ರಿಯಲ್ ಬೇಡ ಜಂಗಮಾಸು. ತಾವು ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಟು ಪೇಜ್ 25 ಫಾರ್ ಎ ಮೂಮೆಂಟ್. ಪಿಟಿಷನ್ ಅಲ್ಲೇನೆ ರಿಟ್ ಪಿಟಿಷನ್ 901.
901, yes.
Para 6 may be kindly seen below.
Page 30?
Page 25.
25. ವೆಂಕಟೇಶ್ ಸರ್ ರೆಡಿ ಇಲ್ವಾ ನೀವು? ನೀವೆಲ್ಲ ವಿಂಗಡಣೆ ಮಾಡ್ಕೊಂಡು ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದ್ಬಿಡಿ. 25. ಏನಿದೆ 25?
Para 6 may be careless in Lord. I have considered the submission made by the learned counsel for the parties. Admittedly, the petitioner did not have locus standi to make an application. Who is the petitioner? Petitioner is my Lord Dwarkeshwaraya. There, in this
ಇಲ್ಲೂ
petition
ಪೆಟಿಷನರ್ ಅವರೇನಾ?
ಹೌದು. ಇನ್ನು 3 ಜನ ಯಾರು? ಇವ್ರು ಎಲಿನರ್ಸ್.
Not only
ತಾಳ್ರಿ ಹೇಳ್ಬಿಡ್ತೀನಿ ನಾನೇ.
others are also petitioners.
ಈಗ ನೀವು the prayer that you have sought is to take action against 5, 6, 7, 8.
Yes.
For what?
For violating the orders of this honorable.
Which order?
ಇದು ಕೊಡಿ.
Contempt ಹಾಕಿ.
ಅಲ್ಲಲ್ಲ.
ಅವರು ತಮ್ಮ ಮಕ್ಕಳಿಗೆ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ
ಒಂದ್
ಅಂದ್ರೆ
ನಿಮಿಷ ಸರ್. ಇದ್ಯಾವುದೋ 1995 ಆರ್ಡರ್ ವೈಲೇಷನ್ ಅಂತ ಇದ್ದೀರಾ?
ಹೌದು.
ಮಾಲ ಜಂಗಮ, ಬೇಡ ಜಂಗಮ, ಬುಡ ಜಂಗಮ ಸಮಾಜ ಸಂಸ್ಥೆ.
ಅದರಲ್ಲಿ ಲಾಸ್ಟಿಗೆ ಹೇಳಿದ್ದಾರೆ.
ಲಾಸ್ಟ್ಗ?
ಹೌದು, ಲಾಸ್ಟ್ ಪ್ಯಾರಾ. Page 12. Page 11, bottom line, 4 lines. The Supreme Court, having examined the question of recognizing the caste status of a person and prescribed the procedure thereto, the entire matter will have to be re-examined in that light. Therefore, the learned Advocate General submits that the state will constitute a committee as contemplated in the said decision, and that committee will be free to decide the same unhampered by any of the circulars issued by the government.
ಮಾಧುರಿ ಪಾಟೀಲ್ ಪ್ರಕಾರ.
ಮಾಧುರಿ ಪಾಟೀಲ್ ಫಾಲೋ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ in that writ petition, the challenge was in respect of these circulars which they have relied upon.
All right.
Therefore, what we have done is, despite there being a direction by the government, they have again relied upon these circulars which are the subject matter of the writ petition. And government has also issued a circular stating that these circulars are not to be followed. Therefore, after the
ನಿಮಗೆ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ನಮಗೆ ಕೊಡದೇ ಇರುವಂತ ವಿಷಯ ಬೇರೆ, ಅದು ನಮ್ಗೆ ಸಪರೇಟ್ ಆಗಿ ಚಾಲೆಂಜ್ ಮಾಡಿದೀವಿ.
ಇದು ಯಾರ್ದು ಮತ್ತೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಈಗ?
ಅಲ್ಲ, ಇದನ್ನ ಈ ಪರ್ಟಿಕ್ಯುಲರ್
ಈಗ ನಿಮಗೆ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ ಈ ಪೆಟಿಷನರ್ಸ್?
ಇಲ್ಲ, ಇವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ. ಕೊಟ್ಟಿಲ್ಲ. ದ್ವಾರಕೇಶ್ವರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಅವನ ಬ್ರದರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಅವ್ರ ಬ್ರದರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಅದಾಯ್ತು. ಆದ್ರೆ
ಅಲ್ಲ, ಅವ್ರ ಬ್ರದರ್ ಇಲ್ಲಿ ಪಿಟಿಷನ್ ಹಾಕಿದಾರಾ?
ಇಲ್ಲ, ಬೇರೆ ಇದೆ, ಅದರಲ್ಲಿ ಬೇರೆ ಇದೆ.
ಮತ್ತೆ ಇದ್ರಲ್ಲೇ ಇದೆ ಹೇಳಿ.
ಇದರಲ್ಲಿ ಅವರು ಅದನ್ನ ಕೈಂಡ್ಲಿ ಸಿ.
ಈಗ ಪೆಟಿಷನರ್ 1, 2, 3, 4
ಹೌದು,
ಇವ್ರಿಗೆ ಯಾರಿಗೂ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರ ರಿಕ್ವೆಸ್ಟ್ ಅನ್ನ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ?
234
ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿಲ್ವಾ? ಎಲ್ಲಿದೆ ಅಪ್ಲಿಕೇಶನ್?
ಮಾಡಿದೆ.
ಎಲ್ಲಿದೆ
ಹೇಳ್ತೀನಿ.
ಅಲ್ಲ, ಹೇಳೋದಲ್ಲ, ತೋರಿಸ್ಬೇಕು.
ಪಿಟಿಷನರ್ ನಂಬರ್ 1 ಡಿಸ್ಟ್ರಿಕ್ಟಿಂಗ್ 1ರಂತೆ 2, 3 ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಸೆಸ್
ಅದನ್ನೇ ತಾವು ಸ್ಟೇ ಮಾಡಿದ್ದೀರಾ?
ಇದು ಇನ್ನೊಂದ್ ಕಡೆ ಹೋಗಿ ಇನ್ನೊಂದ್ ಸರ್ಟಿಫಿಕೇಟ್.
ಗಣೇಶನ ಹಬ್ಬದ ದೊಡ್ಡ ಕೆರೆಗೆ ಚಿಕ್ಕಕೆರೆಯಲ್ಲಿ ಇದ್ದ ಅಂತ ಅಲ್ಲೋಗಿ ಇನ್ನೊಂದು ಸರ್ಟಿಫಿಕೇಟ್.
ಅಲ್ಲಲ್ಲ, ವ್ಯಾಲಿಡಿಟಿ.
Don't worry about him, sir.
I am used to it, of course.
If you're used to it, you should not turn that side at all.
If he raises
a common friend, he is opposing in many bogus certificate cases.
Any certificate case ಅಂತ ಹೇಳಿ
bogus ಅವ್ರದ್ದು ಅವ್ರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು bogus. bogus ಅಲ್ಲದೆ ನಾನು ಅವ್ರಿಗೆ ಜೆನ್ಯೂನ್ ಅಂತ ಹೇಳಲಿಕ್ಕಾಗುತ್ತೆ?
ಹಿಂಗೆ ಹೇಳಿ ಲೇಟೆಸ್ಟ್ where I think Dhananjay appeared in Hemalata, Hemavati, that is HAL's case. Division bench had reversed it.
Supreme Court and
Justice
exercising
Bopanna
power.
had allowed it, then Division bench had reversed it. Supreme Court, I think, restored Justice Bopanna's order.
So they went on to hold that the 2002 GO will be the law in Karnataka, not the Vaira judgment.
ಅಲ್ಲ ಅಸಿಸ್ಟೆನ್ಸ್ ಹೆಂಗ್ ಬರ್ತದೆ ಅಂತ ನಮಗೆ ಗೊತ್ತು.
ಅಸಿಸ್ಟೆನ್ಸ್ ರೆಸಿಸ್ಟೆನ್ಸ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗೇ ಇತ್ತು.
ಇಲ್ಲ with the due respect, my lord, they have not brought that Sanju Nimju's case there.
No, ಎಲ್ಲ ಬಂದಿದೆ. Everything. Justice Hima Koil's judgment, I guess.
ಅದಕ್ಕೆ
I remember that because I had argued in the.
ಅಲ್ಲ ತಾವು
before
ಅದಕ್ಕೆ
Justice Bopa.
ತಾವೇ ಹರಿಕೆ ಮಾಡಿದ್ರಿ ಅದಿಲ್ಲ.
Yes.
now what we sought is that action is to be taken. Now I have filed.
ಯಾರಿಗೆ ಆಕ್ಷನ್
ಅಲ್ಲ, one
ತಗೋಬೇಕು
second,
ಕಾರಣ ಹೇಳಿ ನಂಗೆ.
ದಯವಿಟ್ಟು 1 second. Kindly look at the memo.
ನೀವು ಮೆಮೋ ಬಿಡಿ. ನಾವು come to your prayer say
ಮೆಮೊದಲ್ಲಿ
take action against 5678 for what purpose?
For violating it. ಅಲ್ಲಿ ಅಲ್ಲ ಅದಕ್ಕೆ
violation que whom?
ಅಲ್ಲ 1 second ಸ್ವಾಮಿ.
violation que whom sir?
ಮೆಮೋ ಜೊತೆಲಿ ನಾನು ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದ್ದನ್ನ ನಿಮ್ಗೆ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ವೈಲೇಷನ್ ಯಾರು ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡದೆ ವೈಲೇಟ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲ ವೈಲ್
ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಕ್ಕೆ ಈ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿತ್ತ, ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿತ್ತ?
ಇಲ್ಲ, ಅದಿಲ್ಲ.
ಎರಡೂ ಇಲ್ಲ.
Kindly the averments in the writ petition.
This will have to dismiss by imposing costs.
ಎಕ್ಸಾಂಪ್ಲರಿ ಕಾಸ್ಟ್, ಆರ್ಡಿನರಿ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು.
ಆರ್ಡಿನರಿ
ಅಲ್ಲ, ಅವ್ರು ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು 10 ಲಕ್ಷ ಆದ್ರೂ ಹಾಕ್ಬೇಕು. The maker of the constitution provide reservation to the needy person,
not the greedy.
To the greedy persons.
ಅಲ್ಲ ಇದರಲ್ಲಿ
only needy, not greedy.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಪಿಟಿಷನರ್ಗೆ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Hegde sir, everything apart, what is your locus to say that you have action should be initiated against 5678 for what purpose and what violation? You can't argue in thin air unless there is material. Will dismiss it with cost definitely. And pleading allantu ಏನು ಇರೋದೇ ಇಲ್ಲ. Nothing. ಯಾರಿಗೋ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಕ್ಷನ್ ತಗೋಬೇಕು? ವಾಟ್ ಇಸ್ ದಿಸ್? ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಕಾನೂನಲ್ಲಿದೆ. ಮತ್ತೆ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲೇಬೇಕು ಅಂತ ಕಾನೂನು ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ಮೇಲೆ ಹೌ ಆಕ್ಷನ್ ಕ್ಯಾನ್ ಬಿ ಟೇಕನ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್?
ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಬೇಕಾದಂತದ್ದು ಅಗತ್ಯ ಇಲ್ಲ.
ಕರೆಕ್ಟ್.
ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾವಾಗಲೂ ಕೊಡಬಾರದು ಎಂಬುದನ್ನು ಇಲ್ಲ. ನಮ್ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್
ಕೊಡಬೇಕು, ಕೊಡಬಾರದು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟ ಮೇಲೆ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಅಷ್ಟೇ.
ನಮಗೆ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅನ್ನ ಕೊಡದೇ ಇರುವಾಗ ಬೇರೆ ಕೇಸುಗಳಲ್ಲಿ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ವಿ ಆರ್ ನಾಟ್ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್.
ಫೈನ್,
ಇಟ್ ಇಸ್ ದೇರ್ ಡಿಸ್ಕಷನ್. ಇಫ್ ವಿ ಆರ್ ಸ್ಯಾಟಿಸ್ಫೈ ಆಲ್ ದೋಸ್,
ಮತ್ತೆ ಆಕ್ಷನ್ ಅಂತ ತಗೊಳ್ಳಕಾಗುತ್ತೆ.
ಬಟ್ ದೇ ಆರ್ ಫಾಲೋಯಿಂಗ್ ಎ ಸರ್ಕ್ಯುಲರ್ ವಿಚ್ ಹ್ಯಾಸ್ ಬಿನ್ ವಿಡ್ರಾನ್ ಬೈ ದಿ ಗವರ್ಮೆಂಟ್.
ಅಪೀಲ್ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಅವ್ರು ಅಪೀಲ್ ಹಾಕ್ಬೋದಾಗಿತ್ತು.
They are using this court to terrorize the official.
ಟೆರರೈಸ್?
ಹೌದು, ನೀವು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಲ್ಲ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತೀನಿ, ಕೋರ್ಟ್ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, ಇಟ್ ಇಸ್ ಸೋ ಆಬ್ವಿಯಸ್ ಯಾರನ್ನ ಟೆರರೈಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
ನೀವು ಟೆರರಿಸ್ಟ್ಗಳೇ, ನಾನು ಹಾಗೆ ಹೇಳ್ತೀನಿ. ಲಾರ್ಡ್ ಟೇಕಿಂಗ್ ದಿ ಸರ್ಟಿಫಿಕೇಟ್ ದೇ ಹ್ಯಾವ್ ಥ್ರೆಟನ್ ಡೇ ಅಂಡ್ ನಾವ್ ಡೇ ಟು ಡೇ ಏನಾಗ್ತಿದೆ ಅನ್ನೋದು ನನಗೆ ಗೊತ್ತು ಸ್ವಾಮಿ. ಅಫಿಷಿಯಲ್ಸ್ ಆರ್ ಕಾಲಿಂಗ್ ಮೀ, ಬಂದು ಅಫಿಷಿಯಲ್ಸ್ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ, ಇಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ, ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ತೀನಿ ಅಂತಾರೆ. ನನ್ನ ಮೇಲೆ ಅಟ್ರಾಸಿಟಿ ಕೇಸ್ ಹಾಕಿದ್ರು ಪಾರ್ಕೇಶ್ವರ ವೈಫ್.
ನಿಮ್ಮ ಮೇಲೆ ಹೆಂಗ್ ಹಾಕಕ್ಕಾಗತ್ತೆ?
ಹಾಕಿದ್ರು. ಯಾಕೆ ನಾನು ಸಿಟ್ಟಾಗಿ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ ಫಾರ್ ದಿಸ್ ರೀಸನ್.
ಅಲ್ಲ, ಇದನ್ನೆಲ್ಲ ನಾನು ಕಾಂಟ್ರವರ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಔಟ್ ಆಫ್
ದೇ ಆರ್ ಫ್ಯಾಕ್ಟ್ಸ್.
ಅಲ್ಲ, ಐ ಡೋಂಟ್ ನೋ.
ನಾನ್ ತಿರ್ಗಿಸ್ ಮಾಡಿದ್ರೆ ಅದು ಏನ್ ರಿಪ್ಲೈ ಬರ್ತದೋ ತಮಗೆ ಗೊತ್ತದು.
ನೋ ಗ್ರೌಂಡ್ ಇನ್ ದಿಸ್ ಸರ್.
ಅಲ್ಲ, ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಮೇಲೆ ಅವ್ರು ಅಪೀಲ್ ಹೋಗ್ಬೋದಾಗಿತ್ತು.
ನೀವು ಅಪೀಲ್ ಹೋಗಿದ್ರೆ ಹೋಗಿ, ಐ ವಿಲ್ ಪರ್ಮಿಟ್ ಯು, ಅದರ್ವೈಸ್ ದಿಸ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಮಿಸ್. ಸುಮ್ನೆ ಯಾರಿಗೋ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ ಅವ್ರ ಮೇಲೆ. ದೇ ಆರ್ ಗವರ್ಮೆಂಟ್ ಅಫಿಷಿಯಲ್ಸ್ ಹು ಆರ್ ಫಂಕ್ಷನಿಂಗ್ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ. ನೀವ್ ಯಾರು ಸರ್? ಇನ್ ಬಿಟ್ವೀನ್? ದೇರ್ ಇಸ್ ನೋ ಇನ್ ಬಿಟ್ವೀನ್ ಹಿಯರ್.
ಐ ಆಮ್ ಫಾರ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಓನ್ಲಿ.
ಮತ್ತೆ ಬನ್ನಿ. ನೋ 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 ನೋ, ಡೋಂಟ್
ಎನಿ action against
ವಿಧಾನಸೌಧ ಸ್ಟೇಷನ್ ಹಾಕಿದರೆ
making misrepresentation before this court.
Letter file and affidavit.
This is not trial court for you to get evidence and display here. Yes.
Letter file and affidavit. I will demonstrate before the court. Before the Vidhan Saudha case, a complaint was lodged. After my reply, they dropped it.
May I request one thing? Let it be posted on Wednesday. I will either withdraw it.
ಅಲ್ಲ, ಇದನ್ನ ಯಾಕೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬೋದು? ಇಷ್ಟು ಪ್ರೆಷಿಯಸ್ ಟೈಮ್, ಪಬ್ಲಿಕ್ ಟೈಮ್ ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ತಾವು ಕೇಳಿದ್ದೀರಾ, ಮತ್ತಿನ್ನೇನು
ವಿಡ್ರಾ ಮಾಡ್ತಾರಂತೆ ಬಿಡಿ, ನಿಮ್ಗೆ ಯಾಕೆ?
ಆಯ್ತು, ವಿಡ್ರಾ ಮಾಡಿದ್ರೆ ಕಾಸ್ಟ್.
I have not even taken 10 minutes. I have not taken in 7 minutes.
You take 24/7 and ಸಾಹೇಬ್ರು ಟೈಮ್.
The court will not sit sir 24.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಕೊಟ್ರೆ ತಾವು ಕೂತಿದ್ದೀರಾ? ಬೋರ್ದನ್ನ ಇದರದೇ ಕೇಸಲ್ಲಿ, ಕೊತ್ತೂರು ಮನ್ಸಿನ ಕೇಸಲ್ಲಿ 7:30ವರೆಗೂ ಕೂತಿದ್ದೀರಾ.
ನನಗೆ ನಿಮ್ಗೆ 24/7 ಆಗ್ಬೋದು. ಬೇರೆದು ಇರುತ್ತೆ.
ವೆಡ್ನೆಸ್ಡೇ ನಿಮ್ದೆಲ್ಲ ಅವತ್ತೇ ತಗೊಂಡ್ಬಿಡೋಣ. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವೆಡ್ನೆಸ್ಡೇ.
ಅಲ್ಲ, ಮೆಮೋ ಒಂದು ಪ್ಲೇಸ್ ಆನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ, ಅದು ಇರ್ಲಿ.
ಏನಕ್ಕೆ ಅದು
ಇರ್ಲಿ ಬಿಡಿ. Yes, next. Any the XXX?
This is pertaining to surrogacy. What has happened, Millards, is
ಇದು pending ಇದಾವ ಇನ್ನು ಇದು
this
surrogacy
petition is disposed of along with
This
the
is
certain.
disposed of.
Please, Millards, along with certain batch of matters. And in those batch of matters, there was a particular notification that was challenged, which notification, Millards, prohibited usage of donor gametes. But here, they are asking for relaxation of the age.
Age relaxation.
Age relaxation, no, but an error has crept in the judgment.
Dispose ಆಗಿ recall ಆಗಿತ್ತಾ?
Recall agila, but an error has crept in the judgment. My lords have cited that notification.
And close this.
Please.
But why did it come back
They are
again?
seeking for modification. They are not here.
Oh,
Even
they're
on the
seeking
last
for
occasion.
modification.
They have not served a copy on me, my lords.
Petition copy ಇಲ್ವಾ?
ಇಲ್ಲ ನಂಗೆ ಅದು last time ಬಂದಾಗ ಗೊತ್ತಾಯ್ತು ಅಷ್ಟೇ.
The counsel for the petitioner shall serve requisite set of papers upon Srimati Sadhna S. Desai forthwith. We'll take it next Wednesday.
Please, my lords.
Wednesday repeat ಮಾಡಿರ್ತೀನಿ ನೋಡು.
ಆಯ್ತು.
Yes.
Please. Great.
Correction of the order.
Lordship, in the interim order, it was mentioned as forest contribution instead of foreign contribution.
Shanti Bhushan. Ah, you are there. Yes, yes. Foreign contribution. Which interim order, sir? ಏನ್ matter ಇದು?
This is about that cancellation of FCRA registration and subsequent.
Oh, this is foreign contribution ಆಗ್ಬೇಕು
Yes.
forest. We'll correct it. Yes. ಆಮೇಲೆ ready?
Ready, Your Lordship?
You're ready?
Yes.
Your Lordship, this is
Yes.
an issue with regard to
I would
cancellation
just like to
of-
point out, I have a primary objection about the maintainability. If the court would like to
What
hear
is the
that.
threshold bar that you want to cross?
So,
You want him to cross?
no, so he himself has pointed out that initially he had filed
An appeal appeal?
an appeal that was converted. Subsequently, that he has stated was dismissed for non-compliance of office objections. But the website indicates that it was subsequently withdrawn by him. And the order that he
Is there an appeal remedy in this?
there is an appeal remedy under section 31.
Lordship, 1 minute, Your Lordship.
ಆಯ್ತು ಹೇಳಿ.
There is an appeal remedy, but the office objections which were raised by the office.
Office of the appellate,
By the registry.
registry of the appellate authority.
Oh, Your Lordship.
ಇಲ್ಲ.
By the High Court could not be complied, Your Lordship. ಅದು ಒಂಚೂರು ಕಾಂಪ್ಲಿಕೇಶನ್ಸ್ ಇತ್ತು
ಆಮೇಲೆ
ಯಾಕಂದ್ರೆ
ವಿಡ್ರಾ ಮಾಡಿದ್ರ petition ನ?
ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡಿದ್ವಿ. ವಿಡ್ರಾ ಮಾಡಿ we did not contest. We applied for a fresh registration under FCRA, Your Lordship. When we applied for a fresh registration under FCRA, they said you pay penalty of around 4 lakh, some odd penalty amount was popping up on this portal. So to challenge the quashing of the penalty, I filed this writ petition, Your Lordship. Unless and until I challenge that cancellation, this penalty will not go. Therefore, I have come in before this court.
ಅದಕ್ಕೆ appeal ಇಲ್ವಾ?
ಅದಕ್ಕೆ appeal ಇಲ್ಲ, because I am going for a fresh registration, Your Lordship. When I apply for a fresh registration, the portal automatically pops up 4 lakhs to be paid. My submission is, Your Lordship.
Tomorrow is the working day, I believe. ನಾಳೆ. You're there tomorrow?
Yes.
Yes. Yes. Others will repeat tomorrow. 90, 93, 94, 94 ಆಯ್ತಲ್ಲ, 93, 95, 96 ನಾಳೆ.
One request, 93. Initially, they had challenged some order passed by the trial court. Now they have filed an amendment application.
Which one? 90?
93. Now they have
ಸರಿ, ಏನ್
filed-
ಬೇಕೀಗ?
ಅದರಲ್ಲಿ ನನಗೆ ಒಂದು 2 weeks ಟೈಮ್ ಬೇಕು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ತೀನಿ.
ನೀವು ಹಾಕಿ ಅದು ಪಾಡು ನಾನು ತಗೊಳ್ಳಲ್ಲ ಹಂಗೆ ಇರುತ್ತೆ.
ಬೇಡ.
ನಾಳೆ ಬೇಡ ಆಯ್ತು ಸರಿ.
Humble submission, my lord, and for the petitioner, my lord, next week, Wednesday, my lord.
ಯಾವುದು?
93, item 93.
ನನಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಫಿಡವಿಟ್ ಹೋಗಿ ಬರ್ಬೇಕು.
ಆಯ್ತು ವೆಡ್ನೆಸ್ಡೇ ಅದು ಬರುತ್ತೆ, ಡೋಂಟ್ ವರಿ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ಮೇಲೆ ತಗೊಂತೀನಿ. ಅರ್ಜೆನ್ಸಿ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕದ್ ಬೇಡ ಅವರು.
It's not that, my lord, date may be fixed, my lord, since we have to come from Chennai.
It will be repeated every day, sir. Till these further hearing matters are closed, every day I am repeating. ಯಾವ್ದು ಮುಗಿಯುತ್ತೆ ಮತ್ತೆ fill up ಮಾಡ್ತಾ ಇದೆ. Yes.
Supposed to be tomorrow, my lord?
No, tomorrow it won't come. It will come on Monday or Wednesday. Yes.
Wednesday
ಅದು ಬರುತ್ತೆ ಬಿಡಿ ಸರ್, ಏನ್ ತೊಂದರೆ ಕೊಡಲ್ಲ, ಡೋಂಟ್ ವರಿ. ಎಸ್, ಇಬ್ರು ರೆಡಿ ಇದ್ರೆ ತಗೊಂತೀನಿ. ಎಸ್ ಮಯೂರ್, ಗೊತ್ತಾಯ್ತು. ಅದೇ ಸೈಲೆಂಟ್ ಆಯ್ತು ಅಲ್ಲ, ಧರ್ಮಸ್ಥಳ
pray for CBI investigation.
Oh yes, yes.
There is no urgency, nor there is any cause of action. Every CID has gone through with every file and it has gone into deep and conducted the investigation.
ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ರಪ್ಪ.
Correct, ತುಂಬಾ correct ಆಗಿ ಮಾಡಿದೀವಿ. It is a false complaint which is given by them. False persons was being brought to the CID when in the CID investigation by giving a statement, and even the statements and the phone numbers were given by the person.
My lord, they claim that there is a CDR that they are relying upon. My lord, as on the date of the incident, where the accused persons are, and my CDR is secured. My lord, they only secured CDRs of one accused. That too only till the midnight.
Can that be a solid? Can that solitary circumstance result in transfer to CBI?
ಅದ್ರ ಬಗ್ಗೆ ನಾನು ಮಾತಾಡ್ತಾನೆ ಇಲ್ಲ. They are relying upon that to say that I am giving false evidence. However, my
now crime is registered against you.
No. Also made an accused now. I am accused number 4, who is a complainant. My lord, my point is, there is a cause of death report wherein they clearly say that the death has been caused due to blunt force trauma to the cerebral portion of the eye.
ಇದು ಬಿದ್ದಾಗಿರೋದು ಅಂತ ಅವರು
Yes, my lord.
No, this is what 302 is brought down to 323.
Yes, 323.
My lord, idal tondre enu, why I am asking, why I am pleading for urgency. My lord, subsequent to the order of stay granted by this honorable court, my lord, there is another FIR registered by the very sister of this victim. My lord, what
against whom?
My lord, the same accused persons. My lord, what they do? My lord, I shouldn't be saying this in an open court, but I'm switching off the mic. What is happening? The story which the police has in this case is the actual story.
Patients of the injury can be seen in a fall only if the person sustained. Report is hereby furnished, my lord, at page number 336, my lord. 336, my lord. And thereafter, they have not produced the initial forensic report on 10/1/2023, wherein on 10/1/2023 forensic report is very clear that it can be occurred. The injury to the head may only occur when it is due to the fall itself. Yes. Fall itself. Yes. Body 13 injuries. Small injuries are there, madam. Well, the, well, it is in the stomach. Well, well, it, film. Yes, yes. They are seeking here.
That's, in that matter.
What is this matter? NCLT though. Now Supreme Court says I should not interfere at all. NCLT itself is expected.
This is a matter where a trial court says the resolution that is before the NCLT should not be used by SBI. SBI continues to use it. Now NCLT says, what am I supposed to do? Am I allowed to take note of judgment of another competent court, or the IBC prevents me from doing that? And this is the issue before your lordship. This is also the only issue before
And that,
any of the 24 high courts. This issue, therefore,
I think by detailed order, interim order have granted.
No, my lord, no, it has not been, my lord, it has not been heard in detail. My respectful submission is, writ petition itself is not maintainable. Your lordship may kindly see writ of mandamus. Under what circumstances mandamus can be granted? Your lordship may kindly see the prayers.
Just like this we grant.
Yeah, or just for asking, my lord, it cannot be granted at all. My lord, what?
It's not granted just like that. Your lordship does not grant interim order merely for anyone's asking. There has been years.
My lord, it was at the last minute.
Continued, and we continue to have an interim order precisely.
My lord, the question is, my interim order was granted. The reason is, my lord, it was reached at I think at 5:45 or something like.
5:45.
I think, my lord, 5:30 or something. And my learned friend has asked, your lordship, I was there, my lord, on that day. Your lordship said, don't precipitate the matter. You said, all right, we will not precipitate the matter. It is, my lord, it is going on like this. Your lordship may kindly take it tomorrow at 2:30. I have no objection.
We'll take it on Tuesday finally.
Please,
yes. Tuesday at 2:30 PM. You be ready.
Please, my lord, 2:30.
Great. And there's an interim order.
That will continue.
Otherwise,
always told, standing instructions. No interim order without specific vacation will not be continued.
And we've also prepared a note, and it's now part of the records.
Fine. And any judgments you're relying on, please furnish it in advance to them also.
Yes.
Tuesday, Madhyana, 2:00 ತಗೊಂತೀನಿ.
Please.
Yes. Non-compliance for office. 120 ವರೆಗೆ ತಗೊಂಡು.
My name may be shown in that matter.
Nitin sir, why are you waiting?
My lords, that serial 95, respondent number 3, my name may be shown. I have filed wakalat.
95.
Yes, my lord. We had filed the wakalat in, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
For respondent number 4, my lord.
Respondent
Okay, registry to print the name of Nitin Ramesh. Our ಹೆಸರು ಹಾಕದ?
ಹೌದು sir.
Nitin Ramesh is appearing for the 4th respondent. Tuesday, sir.
Please, grateful.
ಎಲ್ಲ 2 weeks. Same. 23, madam. Ian, what is the maintainability? Order 7, Rule 11. Correct. Allow adre RFA. Reject adre matra. Kodi. Learned the office objections to maintainability stands sustained. The learned counsel files a memo seeking conversion of the subject petition to be a regular first appeal. RFA, regular first appeal. In light of the memo petitions, in light of the memo, the petition stands converted so and so for statistical purposes. Yes, next. Yes. Next. 10 days.
Number 33, my lords. My lords have complied with all the office objections.
If not, elladrallu madam, if not already complied, comply the ensuing Monday, it will come. Yes. Monday alla, it's CRP alla Thursday. Ensuing Thursday.
There was a continuation of delay objection raised, my lord. I had actually preferred an RFA within the limitations period, which have withdrawn and liberty was given to me by the
Don't
CR.
worry, let it come up, we will answer that. Yes. That will not be taken as delayed one. Yes, Sunil, ಏನು?
33.
If not already complied, ಅಷ್ಟೇ. This is LAKADB, it will come on Tuesday. Yes, if it is complied. Learned counsel, overruling, ಏನು overruling?
Which I find a dispensation is not necessary. Only the relevant person can.
Accepting the submission of counsel Sunil, office objection is overruled list on Tuesday. We should gather some mass otherwise. Yes.
In compromise
Yes,
petition, my lord, LR application is filed. That has to be allowed, my lord. We'll amend the cost title.
ಈಗಲೇ
Amended petition ಕೊಟ್ಟಿದ್ದೀವಿ.
ಆಯ್ತು, ಈಗ ಮಾಡಿ.
Please. Compromise ಅಲ್ಲಿ.
Yes, ಅಷ್ಟೇ ಮೇಡಮ್. ಆಯ್ತು, ಹಾಕಿರತ್ತೆ ತಗೊಂಬಿಡಿ. 1 week. ಏನ್ ಬೇಕು? 1 week ಕೊಟ್ಟಿರ್ತೀನಿ. If not already complied, you comply. ಎಲ್ಲ 1 week. 1 week ಇನ್ ಕಮ್ಮಿ ಕೊಡಕ್ಕಾಗಲ್ಲ. Conditional order up from 4th time onwards, if not complied. Peremptory order. Which sir? Yes. Yes, Jagdish sir.